Court officer, sir. Madam, ಕೇಳಿಸುತ್ತಾ ಮೇಡಮ್?
ಕೇಳ್ತಾ ಇದೆ.
ಥ್ಯಾಂಕ್ ಯು.
ಸರ್ ಲೈನ್ದಲ್ಲಿ ಇದ್ದೀರಲ್ಲ ಸರ್ ವಿಜಯ್ ಕುಮಾರ್ ಸರ್?
ಇದ್ದೀನಿ ಸರ್, ಇದ್ದೀನಿ.
ಓಕೆ 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 ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಕೋರ್ಟ್ ಆಫ್ ಸರ್ ಮೇಡಮ್.
ಹೇಳ್ರಿ ಸರ್.
ಮೇಡಮ್ ನಾವು GIAC ಇಬ್ಬರು ಇಲ್ಲ, ವಿಷಯದಲ್ಲಿ ಇದ್ದೀನಿ ಮೇಡಮ್. ನಾನು
ಹೌದಾ ಸರ್?
ನಾನು ಒಬ್ಬನೇ ಇದ್ದೀನಿ. ಜಿ ಅವರು ರಜೆ ಹಾಕಿದ್ದಾರೆ.
ಸರಿ ಸರ್.
ಬಹಳೇದಿಲ್ಲ ಮ್ಯಾಟ್ರು, ಅಷ್ಟೇ ನಿಮ್ಗೆ ನೋಟೆಡ್ ಮಾಡಿದೆ ಅಷ್ಟೇ.
ಸರಿ ಸರ್. ಶಿವಾನಂದ್ ಪಾಟೀಲ್ ಸರ್, ಇವ್ರು ನೆಕ್ಸ್ಟ್ ಸರ್. ಸರ್ ಮ್ಯಾಗ್ಮಾ ಜನರಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಇರೋದ ನೀವು ಪೆನಲ್ ಅಡ್ವೊಕೇಟ್ ಇವರು ಅದಲ್ಲ? ಶಿವಾನಂದ್ ಪಾಟೀಲ್ ಸರ್, ಮ್ಯಾಗ್ಮಾ ಜನರಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಇದ್ದೀರಾ ಸರ್ ನೀವು ಪೆನಲ್ ಅಡ್ವೊಕೇಟ್? ಮ್ಯಾಗ್ಮಾ ಜನರಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಯಾರದಾರ ಸರ್ ಇಲ್ಲಿ?
ಸುದರ್ಶನ್.
ಸುದರ್ಶನ್ ಎಮ್ಮ.
For all private.
ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅವ್ರ ನೇಮ್, ಅದಕ್ಕೆ ಪ್ರೀತಿ ಪಟೇಲ್. ನಾವು ಇಲ್ಲಿ ಹಿಂದ್ ಕುಂತರ್ನೆ ಮಾಡಿ. ಮನೆ ಒಂಥರ ಐಸೋಲೇಟ್ ಕಾಯ್ತಾರ ನಿನ್ ರಾತ್ರಿನೇ ಬಂದಿದೆ ನಾವು ಅಲ್ಲಿ. ಇವತ್ತು ರಜಾ ಅಂದ್ರೆ ನೀ ಎಮರ್ಜೆನ್ಸಿ ಬಂದ್ರೆ ಒಮ್ಮೆ ರಜೆ ಮತ್ತೆ
It's for all.
Table में more folder चला, case में more folder blue color का. Yes. Just one minute. Page wise.
Page adjournment, page number 6, still number 22 and 23. Page number 7, still number
My lord,
24.
may I mention, my lord, sorry, my lord, serial number 27, 28, my lord.
Just wait.
Yes.
Just wait.
My lordship,
Please.
serial number,
Next page.
serial number 24, my lord.
24. Yes.
Please, can leave it next week, my lordship. Appeal is admitted.
Huh?
Appeal is already admitted, my lordship. Can leave it next week, any day.
Relist on date.
Page number
Huh. Huh. Well, have you informed the other side? Huh? When it reaches, 1, 2, 3 doubts I have. I just throw it open. I'm not going to take it up for hearing. But in light of that Tej Pratap case, okay, what implication it will have, I'll throw it open, then I'll adjourn.
Page number 8, still number 26.
Yeah.
26 to 20.
Serial number 27, 28, my lord.
Yes.
I'm sorry, my lord, we are not there, my lord, today. Lordship have it, my lord,
Yes.
next week or Monday, lordship.
We have moved that matter, my lords.
Regarding, my lord, the serial number 28, my lord, we have not received the information, my lord, whether, my lord, we complied the earlier order or not, my lord. We have to get the information that one also.
Okay, complete your
That-
instruction. I'll give a short date. Complete your
Please, madam.
instruction.
Please, my lord.
In that, my lords, only with regard to Mandamus, we have sought, my lords. Let them secure the instruction, but
Yes.
short date may be given, my lords.
Yes. 27 and 28, relist on. 20th.
My lords, sir, not 20th, my lords. Any other date, my lords.
Next
23rd or 24th, my lords.
23rd.
Yes, ma'am.
Please, madam. Please.
Please. Macho.
Page number 9, still number 29 to 31. Page number 10, still number 32 to 35. Page number 11, still number 36 to 38. 39 and 40, page number 12, page number 13, 41 to 44.
Lordship, serial number 43, my lords.
Yes. 43.
Appeal, I am for the appellant, my lords. Can leave it next week, any day.
That request relist the matter on.
Serial number 42, madam. Uptake is not well today.
Relist date.
22nd.
Lord, 44, my lord. Last
Yes.
matter. Lord, lordship have it next week, my lord.
Serial number 45 is the family court matter.
44.
Relist the matter on date.
Second.
You must ask your colleagues to inform the other side in all matters in which you have taken adjournment.
Please, my lord, please. Grateful, my lord.
No, serial number 45
Yes.
may be referred to mediation. Lord.
Mediation.
Oh.
You have informed the other
Okay.
side. Matters referred to.
Five.
The code. Mediation center. Mediation center. Parties are to put in appearance on
Friday 1:30.
17th. You have informed the other side.
Yes, sir.
At 11:30.
1:30.
1:30. 1:30. Yes.
Submission, my lords. Serial number 24. Next week, any day.
20.
24. Date is not given.
Adjourn. Somebody wanted to give a memo. Kutra. Their own memo could have came in. I think. Detail 21.
On compliance of office objection, first time, government advocate,
My lord, 2 weeks time may be granted, my lord.
Time granted for necessary compliance.
serial number 2, Bhimaraya, MN,
Review petition is filed to seek review of order dated so and so. Could you understand? We, no representation on behalf of the petitioner. Make clear if no steps are taken by, for necessary compliance, court would be constrained to pass necessary orders. Full stop. Relist the matter for dismissal in the orders list on next week date. Would. Yes.
for fifth time, serial number 3, government advocate,
Lord, 1 week time may be granted, my lord, in this matter.
Time granted finally for necessary compliance.
sixth time, serial number 4, Manjunath Mallaya Shetty,
Pass over.
serial number 5, Shivakumar R. Tengli,
My lord, I appear for the appellant in connected matter cross objection, my lords. The appellant, sole appellant had expired, my lords. I had filed an application to bringing the legal representatives of the appellant on record, cross objection.
What about in 5?
5, my lords, I myself will file an application because I have, yes, my lords.
We'll have it next week. We'll allow to together.
Please, my lords.
Now, any of you have the details.
Please, my lords. The applications are ready, my lords. It may taken up day after tomorrow, my lords. I'll file.
Release the matter. Good in.
Please, my lords. Oblige. Only thing is the affidavit is to be done, my lords. Oblige.
serial number 6, Vinayak Apte,
Seek some small accommodation is not well to do.
At request. In their presence, we'll pass some on. In his presence, we'll hear him and pass him. Relist matter on dateful.
22nd.
Oblige.
serial number 7, Manvinder Reddy,
Connected matter 7.1, my lords. There is a delay of 266 days in filing the appeal, my lords. Lords. These are the batch of matters, my lords, wherein connected matters, my lords, the matter has been remitted back to the reference court for fresh consideration.
But what about, this is under old act. Good. Now this relates to the same notification.
Same notification.
Common award
Common award.
passed.
Common award is passed in the reference court, my lords. There were several LAC numbers, my lords, different cases, my lords. In this, my lords, around 4 cases were clubbed together and passed a common orders.
You take us to the LAC order.
Yes, my lords. Lords,
53, 52, 54, 83.
yes, my lords.
So now the present appeal is filed against which LAC order?
Present appeal is filed against, my lords, in 202183, my lords.
Yes,
LAC number 54 is the reference number, my lords.
54 of 2010.
Yes, my lords. In LAC number 202184, my lords.
Yes.
LAC number 53 of 2010 is the reference number.
Now this order passed
Yes, my lords.
is with respect to which of the LACs? Does
My lords,
it relate
these are
to-
of LAC number 62 of 2010, my lords, of the
Correct,
very
but,
same court.
Whether
Yes, my
now
lords.
53 and 54 are presently here before
Yes,
this
my
court.
lords.
83, what has happened? 83 of 2010.
Yes, my lords. Those in connected matters, my lords, that those have been also remitted back, my lords. The judgment which I am referring to, my lords, the coordinate bench judgment, my lords, at page number 19, my lords.
19.
Yes. LAC number 57 of 2010, my lords, is the reference number. These are of the very same cases, my lords, batch of cases posted before the reference court, my lords.
No, correct. In this common order,
Yes, my lords.
at page 8,
Yes, my lords.
the only other number is 83 ಅಲ್ಲಿ ಏನಾದ್ರು order ಇದೆಯಾ ಈ batch ಅಲ್ಲಿ?
83, my lords. I'll just have to take a look, my lords.
We'll pass over, just check.
Please, my
Then
lords.
we can directly rely on this and close.
Please, my lords. I'll make my submission.
Now we have 54 and 53.
54 and 53, my
So
lords.
52 and 83,
I'll
by
just,
any chance it is there?
yes, my lords. I'll just make a reference.
Pass over.
A. NS Deshpande, Santosh A.
Deshpande is there. Government, you just look into what is this, some daily wage employees.
Please, my lord.
I'll have it next week. No doubt, there is no representation on behalf of the petitioner. But just see what it is and next week we'll dispose it of.
Please, my lord. I'll get
On,
it.
on merits also, there is no case. We can dispose it of. I'll have it
Please.
on Tuesday.
Please, my lord.
Relist the matter on Tuesday.
Number 9, Ravi B. Patil.
In this matter, my lord, I'll take notice for respond 1, 2, 3, my lord. We comply the order of the learned single judge. But there is a direction, my lord, to pass an order not to obstruct the other landowners to reach the complainant's land. We pass the order, my lord. Other side also knows, my lord.
They have complied, my lord, the comply ಮಾಡಿ.
Counsel for the petitioner submits that the direction of the learned single judge
Yes.
Please.
has been complied with. In full stop. The government advocate affirms such compliance. And the first government advocate affirms the compliance of direction of the single judge. Counsel for the complainant also states that the contempt that the direction of the single judge has been complied. In light of such submission, proceedings are dropped.
Lord, I'll take notice to respond 1, 2, 3, my lord. Served, my lord. Under
AGA appears, undertakes to file wakala.
from memo of appearance.
File memo of appearance for respondents 1 to 3.
Please.
Yes.
Right.
Number 10, Hitesh Gowda.
Yes. What about this this
Lord,
matter?
this matter, my lord, learned AG is on the line, my lord. But in this matter, my lord, last occasion, my lord, this all court directed us to deposit the CL amount, my lord. That amount is, my lord, we prepared and sent to the, my lord, government. Government, my lord, has to approve that amount, my lord, to deposit that amount before this all court. In so far as, my lord, merit, other merits is concerned, my lord, we filed the review petition, my lord. That along with the memo, my lord, we filed that number also.
Review before whom? Which bench?
Before the, my lord, division bench, this all court, my lord. Your lordship is also party to that, my lord. Other bench is there.
So we'll adjourn this.
Please, my lord.
We'll have it after 2 weeks.
Please, my lord.
We'll list after 2 weeks.
Number 11, KM Ghate.
Respondent number 2 requires to be complied with the order of the learned single judge.
Respondent number 2 is the answering.
Yes, my lord. He has to consider the representation given by the petitioner. Page 14, my lord.
Chief Officer, Town Municipal Council, Balki.
Please, my lord.
Is there no standing council?
No.
Then we'll have to issue warrant.
There is a, in the writ petition, my lord, Mr. Gaurish Kashampur was there.
Is there?
He was there in the writ
Then
petition.
You bring him, let us see. We'll pass over.
Please, my lord, please.
Pass. Yes, pass over.
Please.
You bring him.
My lord, I appear for the appellant in this case. My lord, the my lord, office objection in so far as 23, my lord, is concerned. It is the appellant number 3 has died after passing of the order of the learned single judge and before filing the appeal. Therefore, we made them a party as a LRs of the respondent. Appellant number 3. Office says I have to file application. Application is can be only, my lord, during the pendency. If anyone dies, my lord,
Submission by counsel for the appellant insofar as arraying of appellant 3A to D is accepted. Accordingly, office objection is overruled.
my lord, may make one
Mr.
submission,
Halali,
lord.
in the
Yes, my lord. May make, my lord, one submission. It is the appeal against the order of single judge in respect of the land acquisition, my lord. The earlier, my lord, respond 194. The government may be directed to take notice, my lord.
AG is directed to accept notice for respondents 1 and
2 and 3, my lord.
no 1 only.
So Sukumar Tengri was representing before single judge. 194 is the government, my lord.
1 and 4, AG is directed to accept notice. Then for
2 and 3, my lord, Shivkumar Tengri was representing before
2 and
the single judge.
2 and 3, learned counsel Shiv Kumar R. Tengli is directed to accept notice. Yes.
And but may I request, my lord, some date may be fixed because it's
Relist the matter.
1977 they acquired the land not received compensation as of now.
We'll have it on 27th. You serve copies. We'll have
Yes,
it on
please,
20
my lord.
in that.
Yes, I'll do it.
Now in that, I just wanted to bring to your notice, you are arguing one matter regarding that Tej Pratap.
Yes, my lord. Yes, my lord.
Regarding change in rules of the there is one
Yes,
more
my
judgment.
lord. Yes, my lord.
There's one more judgment apart from that, which I will give it to the court officer,
Yes, my lord.
where the apex court has decided whether the recruitment is to be continued in terms of rule or changed rule. So I think some Benny Katti anta eno one case ide. Just have a look at it. I'll give the citation to the court officer.
Yes.
That
Please,
very point,
I'll take
whether it has to be decided, recruitment should be done in terms of amended rule or original rule as prevailing as on the date of notification. There appears to be one judgment. I'll give it to the court officer and have a look at it.
Yeah, please.
Yes.
And in the case of BR, Lord, there was one more judgment I had already made available to this court, Lord, which says that unless the Lord the notification says it is with retrospective effect, it cannot be interpreted in that way.
Let us see. Yes.
Hearing on nine, seal number 30, Shivakumar Malipati.
Calling the order on dismiss for non-prosecution of producing certain documents of the KAT. I mean, given time I shall produce my 1 week time.
So office objection.
Yes, sir.
Now you'll comply.
I'll comply, sir. If since it's what did
Petitioner is permitted to comply with the office objections pending consideration of IA 1 of 23 and 2 of 23.
please,
Relist the matter on
in 1 week, within a week,
date code. Yes.
please. Thank you.
Number 40, SM Jalaluddin, SP Sangolgi.
My lord. This is a clear-cut case of suicide, my lord, which has been converted into a murder. The conviction of the appellants is not because there is incriminating evidence against them, but because of the inexperience of the defense counsel represented by the DLSA, not bringing on record the contradictions, the omissions.
You point out.
Yes.
As on the synopsis, I appear for accused number 2. The connected matter, my lords. Filed by accused number 2. May I just pass on the synopsis? May I make one submission, my lords? I take exception to my learned friend's submission that DLSA counsel. In fact, I appear for the legal
Bidi. We have not taken taken note of it.
In fact, I also represent.
No, correct. When we don't take note of it, question of expunging doesn't arise. That's okay. Yes.
I begin my submission from the conclusive part of the judgment, page number. My lord may kindly see page number 171.
Paper book. Page number
171 of the paper book. 171 of the paper.
170.
Judgment. The conclusive part of the judgment is, with regard to the motive behind the crime and the homicidal death are concerned, if we go through the material evidence on record, we find that the evidence of PW 357, it is clear and categorical to the effect that the accused number 1 had illicit relationship with accused number 2, wife of the deceased. And it has come in the evidence that PW 5, Kashinath, one of the elders of the village, that despite advice made by them, they did not heed to the request and continued the sit. The appellants were convicted on the theory of last scene, page number 177, with regard to the circumstantial evidence of the last scene together.
170.
177. The conviction of the appellants is based on 3 counts. One is the motive, second is homicidal death, and third is theory of last scene. If your honor may, my lordship may kindly see page number 5, 6, and 7 of the paper book. That is a complaint which was given by the complainant.
Yes.
The complainant is the father of the deceased. Complainant is the father of the deceased. Appellant had illicit relationship with the wife of the deceased. A1 had illicit relationship with the wife of the deceased. Complainant along with Shanku Jadhav and Mahant Jadhav, that is CW11 and CW13, had warned and advised not to continue, but they continued the same. On 1/8/2020, deceased went to his land to spray pesticide A2 went to others' land to do coolie work. Complainant and his wife, that is the father and mother of the deceased, went to graze goats. At 3 p.m., the father and the mother of the deceased, that is the complainant, received information from a hearsay witness by name Jainuddin, who came and told that the sole eyewitness CW2 told them that in the lands, the wife of the deceased and A1 were indulged into an illicit activity, sexual activity, and when he suddenly saw them, those people fisted him on the face and squeezed his testicles and then poured pesticide into the mouth of the deceased and then ran away. This is the allegation, Your Honor. The most important point here is CW11 and CW12, who had advised the appellant not to continue with the illicit relationship, were not examined. They are the material witnesses. They have not been examined by the prosecution. My Lord, may kindly see page number 61 and 62. CW11 is Shankar Tande Deval Jadhav, and CW13, page number 62, is Mahantesh Tande Deval Jadhav. These were two material witnesses who had advised the complainant, who had advised the accused not to indulge into the illicit relationship, but they continued this. They have not been examined. Deliberately, they have been given up, Your Honor. The second is, the complainant clearly says that the wife of the deceased went to others' land for coolie work. In the complaint, ನನ್ನ ಸೊಸೆ ಕವಿತಾ ಇವರು ನನ್ನ ಹೊಲದ ಪಕ್ಕದ ಹೊಲದಲ್ಲಿ ಕಸ ತೆಗೆಯಲು ಕೂಲಿ ಕೆಲಸಕ್ಕೆ ಹೋಗುತ್ತೇನೆ ಅಂತ ಹೇಳಿ ಹೋಗಿದ್ದಾರೆ. Page number 6, Your Honor. Second paragraph, third line. My Lord, the complainant further says that on 1/8/2020, deceased went to his land to spray pesticide. My Lord, may kindly see page number 20. The seizure Panchanama. If he had gone to spray pesticide with the machine, the story is that he went to spray pesticide to his land, and when the machine got spoiled, which was not working, he again came back to his home, took another machine to spray pesticide. Then he did not see his wife there. In the complaint, it is contradictory. Initially, he says that the wife went to others' land to spray pesticide, and the half portion, it comes into the complaint that when the deceased went to his land, taking the new machine, he did not find his wife. This is the allegation which had come. Your Honor, my Lord, page number 20, what has been seized is only a bottle of Foskil. No machine has been seized. what can be inferred is that the deceased had carried only a bottle of Foskil, that is the pesticide, to commit suicide.
Yes, yes.
It
You're in,
further-
you're in custody since how long?
4 years, 6 months, 5 months.
4/8/2020.
Huh?
4/8/2020.
No, but instead of going so much in detail, prima facie, you show us.
There is absolutely nothing.
Matters of evidence, now interpretation of arguments in complaint, vis-a-vis witness, etc. We'll reserve it at a later stage. Prima facie, who has supported the prosecution?
No, nobody knows.
Huh?
There is no evidence at all. Not even a single circumstance has been
So
proved.
always you must open with your best argument. Always open with your best argument.
Not even, the motive to the offense has not been proved, neither the
Correct. So
presence
now-
of the witness has
so
been proved.
You go to your best point and tell us instead of going deep into it. Deep into it means matter for at the time of hearing of the appeal.
Initially, the prosecution tried to prosecute on the strength of a sole eyewitness. He turned hostile and it resorted to lead circumstantial evidence by improvising the case. The sole eyewitness, the claim of the sole eyewitness is his lands are adjacent to the lands of the deceased and the place of incident. The place of incident is CW 14. He has not been examined by the prosecution.
Not been.
He has not been examined.
No, no. Who has turned hostile? CW?
CW 2, PW 1. He is the sole eyewitness.
Turned hostile.
He has turned hostile. He has deliberately turned hostile, my lord.
No, that's okay. So then what else?
Then
prosecution
nothing.
relied on
Prosecution
circumstantial
has
evidence.
improvised it led circumstantial evidence, claiming that all these people, PW1, PW3, PW and CW14 are all neighboring landowners. That is a blatant lie, my lord. If my lordship peruse
Rajesh, you are advancing common arguments.
page number.
No, no, I'm asking. You have some points in common.
Page number 50, the sketch map. Nowhere near the land of CW14. The place of incident are the lands of PW1, PW2, PW3.
No, we'll come back to you. Rajesh, you have a what are you tell us what again? Let's see.
But I'll just put it in a very simple manner.
Hmm.
The entire case revolves around the eyewitness statement of CW2. Who is examined as PW1 who has turned hostile. And the recovery, the punches to the recovery of the poison insecticide bottle mullets, they have turned hostile. That is not true. They have examined as PW. PW6 mullet and 8. I'm sorry, PW8 and PW11. PW8 and 11 are the witnesses to are the punchers to the seizure of the poison bottle mullet. They have turned hostile. And as per the prosecution case, the deceased accused number 1 had squeezed the private part of the deceased. However, in the PMA report mullet, there are no external injuries.
Take us.
Page 44. Page 44 in the PMA report bullets.
Forty-five, 46. 45, 46. Genito urinal.
48 is the final opinion. Let's kindly take page 48. What opinion as to cause of death? May I read first? Cause of death, in my opinion, is due to respiratory failure as a result of organophosphorus poisoning. Recovery is not proved, my lords. The poison bottle is recovered from the spot. It is not at the instance of the appellant. They were arrested after 3 days. That apart, my lords, PW 5 and 7 for the court say that A2 was present on the spot, which is not before in the 161 statement. That is the improvement in the prosecution case. PW 5 and 7. For the first time for the court, they would depose that A2 was present when they had gone to the spot.
Now come to page 6.
6. Yes.
Come to page 6, second para.
Second para.
ಈಗಿದ್ದು ಇಂದು ದಿನಾಂಕ 1/8/2020
ಬೆಳಿಗ್ಗೆ 10 ಗಂಟೆ ಸುಮಾರಿಗೆ ನನ್ನ ಮಗ ಈಶ್ವರ್ ಈತನು ನಮ್ಮ ಹೊಲದಲ್ಲಿ ಹತ್ತಿ ಬೆಳಿಗ್ಗೆ ಕೀಟನಾಶಕ ಔಷಧ ಹೊಡೆಯಲು ಹೋಗಿದ್ದು ನಂತರ ಸ್ವಲ್ಪ ಹೊತ್ತಿನಲ್ಲಿ ನನ್ನ ಸೊಸೆ ಕವಿತಾ ಇವರು ನನ್ನ ಹೊಲದ ಪಕ್ಕದ ಹೊಲದಲ್ಲಿ ಕಸ ತೆಗೆಯಲು ಕೂಲಿ ಕೆಲಸಕ್ಕೆ ಹೋಗುತ್ತೇನೆ ಅಂತ ಹೇಳಿ ಹೋಗಿದ್ದು ಇರುತ್ತದೆ.
ಪಕ್ಕದ ಹೊಲದಲ್ಲಿ means what? The place of incident. ಪಕ್ಕದ ಹೊಲ.
No.
Then
the spot Panchanama says nowhere near the land where the incident took place. Page number 50.
Your argument would be the PW,
PW1, PW2, PW3, nowhere.
The complainant, according to the complaint, she stated that ನನ್ನ ಮಗ ಕೀಟನಾಶಕ ಹೊಡೆಯಲು ನನ್ನ ಫೀಲ್ಡಿಗೆ ಹೋದ ಅಂತ ಅವನ ಫೀಲ್ಡಿಗೆ. That is your argument. That is your argument.
No, he did not. He went with a bottle to commit suicide. If he had gone to spray pesticide, the machine would have been seized.
Such evidence. He went to the spot to commit suicide and there is the evidence. Where is the evidence? Who says so? Whether you can presume the things in a criminal case?
But this is circumstantial evidence.
Circumstantial evidence means you can presume whatever you want, sir, without a corroboration of any evidence. Have you led any evidence?
Yes,
have you explained in 313 statement? Where is your explanation?
That is the weakness of the
counsel. Instead of arguing some other things, to argue the case on merit by instead of making some allegation against others or against the presiding officer.
My lord, I have not
argue
made
the case properly. Then you can make the allegation. It's not the way. Where is your explanation in 313? Have you examined any defense witness? In appeal, you are stating that you are committed suicidal and making some allegation.
the allegation is
Yes.
Yes, my lords. My lords, the
But no
Only-
injuries on the body.
my lords,
They squeezed his testicles and.
yes,
rape.
ma'am.
But that is not.
That is not that, but pouring on kerosene and finding that particular pesticide in the dead body stomach, I mean, the deceased stomach, that only merely sufficient to prove that this has been occurred. And also, my lords, there are the chain. There is a chain of evidence. There is a link of chain, my lords. Nothing has been elicited in the cross-examination. And also, my lords, the doctor opined that the cause of death is due to that pesticide. In the page number 40 and 41. And also all the
order on IA 2 of 2023 in criminal appeal, madam. First of all, order on IA 2 of 2023. Criminal appeal 20013 of 2023, order on IA 2 of 23. Other 23. These two applications are filed by the accused number, filed by the applicants to suspend the filed under section 389 of clause 1 of CRPC, seeking suspension of sentence and grant of bail pending disposal of this appeal. These appeals, full stop. The applicants are the appellant in the main appeal, main appeals. Appeal. They have challenged, wherein they have challenged the judgment of conviction and order of sentence imposed in session case number 119 of 2020, dated 16/1/2023, passed by the third additional district and session judge at Kalaburagi. Full stop. The summary of the Kalaburagi for the offense punishable under section 302 of 302 read with 34 of IPC. 302 read with 34 of IPC by sentencing, by sentencing them to undergo imprisonment for life for the major offense 302 of IPC. Full stop. The summary of the prosecution case is that the investigation officer of the respondent police has filed a charge sheet against the accused applicants for the offense punishable under section 302 read with 34 of IPC in connection with the homicidal death of one Ishwar, that is the son of PW3, full stop, PW3, full stop. The case was after committal of the filed charge sheet and before the committal court, full stop. After committal of the case before the then session judge, comma, after a detailed trial, the learned session judges convicted the appellants for the aforesaid offences and sentenced them as stated supra. Full stop. Next, it is the contentions of the learned counsel for the appellant in both the appeals that the learned session judges wrongly convicted the accused without appreciating the evidence on record in a right perspective. Full stop. They would contend that all the material witnesses have turned hostile and the entire case of the prosecution rests on circumstantial evidence. Full stop. The star witness PW1 in this case has totally turned hostile. As such, the evidence of PW3 and 4 for the hearsay witness cannot be, could not have relied by the trial court. Full stop. According, full stop. Further, they would submit that the appellates were on bail during the course of the full stop. Further, they would submit that the prosecution also failed to prove the recovery of the circumstance of recovery and the homicidal death of the deceased. Full stop. Death of the deceased. Full stop. Accordingly, they praised to allow the IA by suspending the sentence. Full stop. For contra, the learned additional SPP contend that the learned session judge after meticulously examining evidence on record, convicted the accused in a reasoned judgment. Full stop. You would contend that the material witness PW3 and 4, categorically stated the act committed by the accused by lodging an FIR, by lodging a complaint on the date of incident, immediately after the incident. Full stop. Though PW1, the star witness turned hostile, the other circumstance like motive and homicidal death of the deceased and recovery proved by the proved by the prosecution. Full stop. Accordingly, he prays to dismiss the application. Full stop. Full stop. We have carefully perused the impugned judgment passed by the trial court, so also the other materials, the evidence and other materials placed before us. Full stop. On perusal, it could be seen, the learned session while convicting the accused, the learned session judge relied the evidence of PW3 and 4, the hearsay witnesses who are none other than the mother and brother of deceased respectively. Full stop. On perusal of their evidence, they stated that PW1 has informed them about the incident. However, the PW1 totally turned hostile to the prosecution case in the full stop. Further, the prosecution also further, the witness for the recovery measure also turned hostile. In such circumstance, without expressing any opinion on the merits of the case, this appeal is of the year 2023, and the appellants are in custody, are under incarceration from last
4/8/2020.
4 years.
4/8/2020. 4 years, 5 months. 4 years, 5 months.
4 years, 5 months. 4 years, 5 months, and this 4 year, 5 months, and there is no possibility of hearing this appeal immediately near future, comma, in such circumstance, relying on the judgment of the Honorable Apex Court in the case of Kashmir Singh versus State of Punjab, reported 1977, AIR SC 2147, comma, we are of the considered view that the application will be considered by imposing condition. Accordingly, the IA2 of both the IA2 of 2023 filed in both the appeals are hereby allowed, and the substantive sentence imposed by the trial court is suspended pending disposal of this appeal, subject to the condition that the appellant shall deposit of appellant shall execute a personal bond. Each of the appellant shall execute a personal bond for a sum of ₹1 lakh with the two sureties for the like sum. Also, the appellant shall deposit the entire fine amount before the trial court.
I make one submission. The Lords dictated that PW3 and 4 were informed by PW1. It is informed by PW2, my lords. PW1 put the informed PW2 or 4. Yes. Okay.
Number 50, Amit Jayant Kumar Hatti.
And for the appellants, Your Lordship, the appellants are the plaintiff before the trial court, Your Lordship. There are 222 days of delay in filing this present appeal, Your Lordship.
Notice to the respondent. If they are to be summoned.
Your Lordship, out of the same judgment, there is another appeal preferred by the respondent numbers 8, Your Lordship. The RFA number 2001997 of 2013. Kindly that may be connected with this appeal.
Just along with RFA 20019.
97 of 2023, Your Lordship.
Write it and give it.
Yes, sir.
Yes.
Sanganagowda Biradar.
This is a claimant's appeal, my lord, seeking for enhancement. There is a delay of 155 days.
Issue notice on respondent number 1. Next, Sudarshan M is directed to take.
R1 may be dispensed with, my lords. R1 may be dispensed with. I call.
Issue Sudarshan, Land Council directed to take notice for respondent number 2. The Land Council for the Appellate files a memo to dispense the notice on respondent number 1. Accepting the notice memo, placing the memo on record. The notice to R1 is
Memo refer to local adalat, my lords.
There is no appellate. Counsel for the appellate submits the matter may be referred to local adalat. Accordingly.
Delay may be condoned, my lords. No interest.
Yes.
Delay may be condoned and no interest, my lords.
Accepting the reason assigned in the affidavit.
Yes, my lords.
Accompanied to IA number 1 of 23, the delay of 355 days in filing, or 355 days filing in this appeal is hereby condoned. Next, accordingly, IA 1 of 23 is here that the appellate is not entitled, the climate appellates are not entitled for the delayed period. Next, the counsel for the appellate submission matter may be referred to mediation. Accordingly, matter is referred.
Number 70, Sanjay A. Patil.
I'll file objection. Pass
over.
Second half null happens. 17 and 18. Serial number 17 and 18.
You are in 17?
18, my lord. 18. Second half, 230.
Compromise agida.
Pardon?
Settled. The dispute settled between them.
Settle ಆಗಿದೆ.
Married. Appellant married the victim.
ಇಲ್ಲ. So, victim girl married somewhere, my lord. Subsequently, they, after settlement, all the witnesses have turned hostile. And in fact, there is a delay of 10 months. Only on the date of complaint, my lord, the parents.
The pendency of session case.
Pardon?
The pendency of session case. During the pendency of session case. She married somebody else. Somebody else.
ಬೇರೆ ಕಡೆ ಮದುವೆ ಆಗಿದೆ. And later on, my lord, all the witnesses were recalled and they have turned hostile to the prosecution. The evidence left is.
Initially, they have supported.
Yes, initially support ಮಾಡಿದ್ದಾರೆ.
In the cross
Yes,
examination.
it's a love affair, my lord, and the age proof is not proved, my lord. Only the birth certificate issued by the PW4 headmaster, my lord. Relying upon that document, my lord, the trial court, my lord, held that she was minor. But and in the entire, my lord, medical records, my lord, the age of the victim girl shows, my lord, 18 years, 6 days, more than 18 years. And there is a delay of 10 months, my lord. On the date of complaint, my lord, when the victim girl, my lord, suffers pain, my lord, labor pain, my lord, there, my lord.
She delivered a child.
Pardon me?
She delivered the child.
Female child.
Female child.
Female child.
Now she married somebody else.
Somebody else. Complaint averments, my lord.
Luckily is appearing for R2.
A respondent to father of the victim girl.
Let him come.
By 2:30, I'll file and also I reply on that.
17, 18 password. 17.
E76 of the POCSO Act, he's been convicted for life. And admittedly, he was not on bail throughout the trial.
What a case for bail.
Out. I myself am saying he was not on bail. IA may be disposed of.
Withdraw ಮಾಡ್ಕೊಳ್ತೀರಾ? Detail order ಬೇಕಾ? Withdraw ಮಾಡ್ಕೊಳ್ತೀರಾ?
ಇಲ್ಲ, ತಾವು order pass.
Yes.
Anyway, paper books are ready. Matter also may be taken up for final hearing.
That will come according to chronology.
Yes.
We'll adjourn the matter. Let the papers book maybe. You just we'll defer this one. Not pressing ಅಂತ ಒಂದು ಮೆಮೊ ಆಗ್ತಿರಬೇಕಿದ್ರೆ.
I will do that.
ಮೆಮೊ
I'll do.
for the present and not pressing IA 1 of 24 for the present and
Very well.
referring IA 1 of 24,
Very
we'll
well.
admit the appeal and let.
Very well. I will do it, but in the
Yes.
course of the day, I will.
Yes, yes. Then counsel for the appellant files a memo stating that the IA 1 of 2024 will be deferred for the present. For the present. Placing the memo on record, IA 1 of 24 is deferred for the present and deferred for the present, full stop. The office registry is directed to secure the trial court. But
Admit agi paper book agide.
yes, list is appeal in the usual course. In the usual.
Please.
Brother ಇದ್ರೆ usual course ಬೇಗ ಬರುತ್ತೆ.
That is our experience.
90.
ನಿಮ್ದೆ ಲಗಡಿ ಅವರಲ್ಲಿ ಹೇಳಿಬಿಡಿ.
Party Shantabai.
My lord, claimant's appeal for enhancement, my lord. There is 21 days delay, my lord, preparing appeal. Delay may be condoned, my lord. R1 may be dispensed with, my lord. R2 is.
Will you refer the matter for mediation?
Yes, my lord.
Yes. She Preeti Patil Melkundi is directed to take notice for respondent number 2.
Whether she is the penal advocate for respondent to
ಇದೆ ಪ್ರೀತಿ ಪಾಟೀಲ್ ಮೆಲ್ಕುಂದಿ.
insurance company.
ಪ್ರೀತಿ ಪಾಟೀಲ್ ಮೆಲ್ಕುಂದಿ ಅವರು ಇದ್ದಾರಂತ ಇದ್ದಾರಲ್ವಮ್ಮ, ಅದನ್ನೇ ಹೇಳ್ತಾರೆ. ಆಯ್ತು. Land counsel for the appellate files a memo for the dispensing notice to R1. As placing memo on record, comma, notice to R1 is dispensed at the risk of appellant. The accepting the reason assigned the IA 1 of 2000, affidavit accompanied to IA 1 of 2024, comma, the delay of 21 days filing this appeal is hereby condoned. According to IA 1 of 24 is disposed. The land counsel for the appellate submitted matter may be referred to mediation. According record, Lok Adalat. Referred to Lok Adalat.
Number 20, Shivanand Party.
Defendant's appeal, my lord. Original suit was filed by the plaintiff's respondent for declaration and injunction. Now, if your lordship is directly pleased to come and look into page number 20, running page number 20.
Defendant's appeal.
Defendant's appeal. Running page number 20.
Yes.
There are 3 documents that are filed by the plaintiffs.
Page.
Running page number 20 on the last page of the judgment.
Yes.
Your lordship will find only 3 documents that are filed. One is record of right, another is mutation, and another is letters. Either none of them will disclose. Here in this case, the plaintiff claims to be the owner of some particular piece of land, agricultural land. Now, I am the owner of a house property. My house property is old and dilapidated. I apply for a demolition and reconstruction. The the panchayat grants a permission. I undertake the construction and complete the construction. While I was just before inauguration of the Graha Parvesha, this lady objects. The panchayat comes and inspects the position, finds that there are no illegal constructions. It is within the limited area that is granted. Now she says that she files this suit telling that I am encroaching into her agricultural land. When they make a specific allegation that we are encroaching into their specific agricultural land, the portion of encroached must be there. At least a commissioner must be appointed. Just because I say that I do have nothing, no concern with the said agricultural land, I am not encroaching upon the defendant admits that she is the owner of the agricultural land at injunction.
Now the property is situated outside the plaintiff.
Outside the agricultural land area. It is within the purview of, it is within the thing of Gram Panchayat.
You have produced records.
Yes, I have produced them. At the next D1, 2, 3, 4, all the 4 are of the Panchayat records.
That is, you have purchased the property or how?
No, not purchased. My old house. Within the village area, which is the Panchayat area, my old house, it is dilapidated. I demolished it with the permission of the Panchayat. Then I apply for construction. They give construction. I have completed the construction also.
You have kata for that property. D4.
D4 is Panchayat record, construction permission, construction map, and letter from PDO to Jalali PS. Or complaint to Martara, Jalali PS, PDO calls no, we have inquired, we have inspected, it is within the Panchayat area. We have refer Madala court.
The counsel for the petitioner submits that the trial court has heard in decreeing the suit and further submits that the trial court has not taken note of documents produced by the defendant at annexure D1 to D4, which would indicate that the house was constructed in property belonging to the defendant.
Falling within the limits of Panchayat area.
Falling within the limits of Panchayat area. Matter requires consideration. In the interregnum, there will be stay of the judgment and decree passed in OS number so and so. PCR to be summoned forthwith, emergent notice to the defendant.
There is an interim application. Interim. This is an executable decree interim.
I've stated
much.
Number 21, Ganesh Vachand Kalaburagi.
204 days delay. Yeah. Authority has challenged the order of the Honorable Single Judge, and a review was also filed. That review is also dismissed. The This respondent has filed the writ petition for a Mandamus for directing the respondents to consider the correction of the PAN cards which he has submitted along with the application for online. And that is not a non-rectifiable condition, Your Lordship, that is mandatory. So that on that part, Your Lordship, this Honorable Single Judge has held that condition is cannot be disturbed, but whereas permitted the respondent to participate in the
Now what has happened? You have announced the result.
no, Your Lordship.
Huh?
That condition which the directions which this Honorable has given positive direction, that is challenged, Your Lordship. The review was filed, review was also dismissed of that.
So you take out notice first.
Much.
That present.
Much.
Issue notice to the respondents. Appellant is permitted to serve counsel who appeared on behalf of the respondents in the writ proceedings.
Much.
Notice to show the name of
Yes. There are numbers.
Satish Kumar Gadkar.
No, Your Lordship. This is Sharanabasappa M. Patil.
Sharanabasappa M. Patil and R.V. Nadagowda.
Yes.
As representing the
Respondent.
Respondent number one.
One.
Now, what about the other respondent?
Satish Gadkar.
Office to show the name of learned counsel Satish Kumar Gadkar as representing the second respondent. Such direction is, however, for the present.
Much.
This is the matter. Date 28.
Much.
You serve copies.
Admission 22, Sharanabasappa K. Babashetty.
Appellant in this case. This is the appeal filed by the plaintiff, my lord. The suit for partition has been filed. Suit for partition has been dismissed, my lord. Again, that the appeal has been preferred.
We'll admit it, let the TCR come.
Yes. The earlier partition that is proved.
Proved.
That is proved. That exhibit D1 dated to 1979 partition. That has been proved on that ground. This
second
is
partition.
dismissed.
Unless they show it is unequal.
Yes.
Then on what ground you are
But
pursuing?
shops are concerned, my lord, it is not allotted. That is the contention of the.
Not part of the first partition.
That is the only.
The house was constructed and shops were there. During widening of the road, those shops were
Have
demolished.
gone.
Only house property was remained. That was allotted to this defend number one. This is an earlier partition. That was admitted fact and it has been admitted. So there was no substantive any pleading to that effect for reopening of the partition. An earlier partition was not equal. This one given.
No such
That has,
contention is
is
raised.
not taken. For that ground, the suit has been
Then what
dismissed.
is it?
But my lord, after widening, my lord, some portion of land is left, my lord. They are constructing the, my lord, the shops. And yeah, I am entitled, my lord, the.
In that first partition, some allotment has been made already.
It is proved that well earlier partition has been taken place. It is
Then look
admitted.
into it. Look into it. If you really don't have a case, see if you could settle it. We'll have it week after next. No day. Case idre will admit it. I'll have it in the same stage week after next. Otherwise, you try and settle it. This is the matter in the same
Meanwhile,
stage.
my lord, records may be called.
Week after next, TCR to be summoned. Correct, but if there's no case, what's the point?
Meanwhile, records to be called.
Ad barutte.
Please.
That's it. But you see, if there's no case, simply settle it.
Please.
Read para 15.
May I read, madam? Para 15. It is specific case of the plaintiff that their deceased father purchased open plot and they constructed building, but there is no specific detailed pleadings about the registered sale deed. Permission secured by putting up the construction and also as to in which year and property purchased and construction put up. Therefore, there is a vague pleadings, but it is their case that the property is purchased. If so, then there was no implement to secure
Issue
sell
number
deed
three,
and produce.
issue number 3, para 17, there's a clear findings regarding the earlier partition of 29/3/1979.
It is there, my lord.
You have not challenged the validity of that as being unequal. But ಏನು ಇಲ್ಲ. PCR are also not required unless you make out a case for admission. Otherwise, you settle it with him, that's all.
Not the.
Alex, you point out, you get ready and you come. Relist the matter in same stage week after next. Date could. PCR to be summoned, but even otherwise you must show some.
Lordship may kindly dispose.
Huh? What is that? Then you just tell us what the matter is. We'll have it tomorrow, get ready and you give us a synopsis.
Yes.
Give us a synopsis so that for dictation it will be easy. When do you want? When do you want?
17 if possible.
17. This the matter.
17 I will not be there, my lord. 17 I will. Week after next, otherwise.
20th.
Alla 17 I will not
Monday.
be there, my lord.
Aదే ಬೇರೆ date ಕೊಡೋಣ.
Monday, 20th.
Alla tomorrow it may be taken otherwise.
Tomorrow
is holiday.
Alla day after tomorrow.
15th ಆಗುತ್ತಾ? Release the matter on 15th in same state. Yes.
Bill number 23, Babu H. Metka.
Bill filed by owner of the challenging liability. ಇದರಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಕ್ಲೇಮೆಂಟ್ ಅದು ವೀರನಗೌಡ ಎನ್ಒಸಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದರ ಸಂದೀಪ್ ಪಾಟೀಲ್ ಅಂತ ಅಪೇರ್ ಆಗ್ತಾರೆ, ಅವರೆಲ್ಲೇ ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಕ್ಲೇಮೆಂಟ್ ಅಪೀಲ್ ಇದೆ ಸ್ವಾಮಿ. ಅವರು ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಪ್ಲಸ್ ಲಯಬಿಲಿಟಿ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ. ನಂದು ಅಪೀಲ್ ಓನರ್ ಆಫ್ ದ ವೆಹಿಕಲ್. ಅವರು ಸಂದೀಪ್ ಅಂತ ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರ ಹೆಸರು ತೋರಿಸಿಲ್ಲ ಇದ್ರಲ್ಲಿ.
ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತದೆ
ಇದು ಕ್ಲೇಮೆಂಟಿಗೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ MAP 200132/19 ಅಲ್ಲಿ ಸಂದೀಪ್ ಅಂತ ಅದ್ NOC ಇವರಿಂದ ಹೋಗಿದೆ ಸ್ವಾಮಿ, ವೀರನಗೌಡಿಂದ. ಅವ್ರ ವಕಾಲತ್ ಹಾಕ್ತಾನ ಅಂದಾರ, ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ. ಇವತ್ತು ನಾನು ನಿನ್ನೆ ಎಕ್ಸ್ಟ್ರಾ ಡೇ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೇನೆ.
Let us see, we'll have it next week, but let them come and see.
ನಾ ಅದೇ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಅವರು ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್ ಇರೋದ್ರಿಂದ.
ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ವೀಕ್ 22nd.
ಆಯ್ತು.
Bill number 25, Ravindra Reddy.
Now in this matter,
Please.
you examine that Tej Prakash Patak, and then you come back on the next date. Let us see what the legal position is.
Yes, please.
Huh?
Yes, yes.
Both of you examine what is the implication of that order.
Yes.
In the
Yes, I think I have already cited the judgment. Even this on court was pleased to refer the judgment and.
Not that. That was the
Same judgment. Same judgment.
After reference. After reference to larger bench.
Yes.
Now you see to what extent, by virtue of the reference answered in the larger bench,
Please. Yes.
how it would apply, what would be the consequences.
Yes. Yes.
Now what has happened? Selection has come to a standstill. Is it?
Please.
No
Sir.
progress. What has happened to the selection process?
Now
They are working.
Now they are working minutes. All are
Since my
working.
lord last.
They have been selected, they have been working, but
What is it?
before issuing appointment orders, there was an interim order of stay in regard to selection is concerned by the learned single judge during the pendency of the writ petition.
Yes,
ಕಂಟೆಂಪ್ಟ್ ಹಾಕೆಲ್ಲ ಡ್ರಾಪ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ಅದು ಇಲ್ಲ.
you have examined it. But now
Yes.
in light of the judgment in Tej Prakash Patak, what happens?
Yes.
It may have to go.
It's totally facts are different, Milots. In
us see.
Manjushri
Get ready.
case was referred to the larger bench, Milots, wherein the candidates were taken surprise, Milots. They scaled down the marks after.
Manjushri, correct.
Please
Manjushri is
notes.
referred in this.
Please notes.
And then they say that after a certain stage of the selection process, here they've amended. First they said scorecard.
Please.
That is a notification.
Please.
Then they said no scorecard, you must. There's a total change. You examine it.
It's,
So it stands or
what
falls.
what university done, Milots?
wherever the amendment is made to the notification, we have provided an opportunity to the candidates who applied for it. And there is a corrigendum is issued, my lords. It's
That
not
has been
something
considered.
we have
That has
taken
been considered by
surprise
the
to
larger bench.
No, no.
That
you
has been
examine it.
considered by the larger
Please,
bench.
please. Examine it. And what is the effect of change in rule?
Yes.
During the process of proceeding, whether you have to go by old rule as on date of notification or not, examine it, please, and file a synopsis, please, and come back. But the larger bench judgment must be looked into now.
Please, date.
Put it week after next. Both sides to file their synopsis.
Please, please.
Relist on
27th, so Lordship speaks, 27th or 28th.
28th.
Oh, bless.
Please.
Office
Along
to
with
show, office to show the name of learned counsel so and so, along with learned counsel Arun Kumar Amargundappa. The spelling is correct, huh? Pause list.
Arun Kumar.
Please.
Spelling correct ಇದೆ. Pause list ಅಲ್ಲಿ ಸರಿ ಇದೆಯಾ ಅಂತ ಕೇಳಿ.
Arun Kumar ಅಂತ.
Yes, madam.
ಅದೇನಾ?
Yes.
AM
AMARGUND.
A ಎಲ್ಲಿದೆ ಅಲ್ಲಿ? AM
AMAR.
A ಎಲ್ಲಿದೆ ಅಂತ
ಇಲ್ಲ,
ಹೇಳ್ತೀನಿ.
ಇದರಲ್ಲಿ spelling mistake ಆಯ್ತು.
Office to show the name of learned counsel Arun Kumar Amargundappa as ಅಂತ ಅದು AMAR ಅಂತ ಮಾಡಿ. ನಮ್ಮಲ್ಲಿ ಹಿಂದೆ ಕಾಸ್ ಲಿಸ್ಟ್ ಫಿಸಿಕಲ್ ವೆರಿಫೈ ಮಾಡುವಾಗ ಮಿಸ್ಟೇಕ್ ಇದ್ರೆ ಹಾಕ್ತಾ ಇರ್ಲಿಲ್ಲ.
ಹೌದು.
ಇವಾಗ ಅಟ್ಲೀಸ್ಟ್ ಬರುತ್ತಾ ಇವಾಗ?
ಬರುತ್ತೆ, ಈಗ ಚೇಂಜ್ ಆಗುತ್ತೆ. Obliged. Number 26, Sanjay A. Patil.
Appellant is convicted for life on 302.
ಅವ್ರು ಬರ್ಲಿ.
ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿ.
ಪಾಸು.
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತೀರಿ. ಇವತ್ತು ಅಡ್ಮಿಟ್ ಮಾಡಿ. Your Lordship may admit it on IA, let him file his objection.
Yes. Heard. Admit. The office is directed to secure the trial court records. In the meantime, re-notify this appeal on ಯಾವಾಗ 2 weeks
ಇಲ್ಲ ಒಂದು ವಾರ ಸರ್. He was on bail there. One week ಅಲ್ಲಿ LCR ಬಂದ್ರೆ he was on bail my lords throughout.
TCR ಬರ್ಲಿಕ್ಕೆ
ಅದೇ ತಾವು
27. In the meantime, the SPP is permitted to file objection if any.
IA
1 of 20.
ಮಚ್ಚು ಕೊಡ್ತೀನಿ
Paper book.
ಖಾಲಿ ಹಂಗಿಲ್ಲ ಮಧ್ಯಾಹ್ನ ಕೊಡು.
Admit it. ಆಯ್ತು, ರಿಜಿಸ್ಟರ್ ಪೇಪರ್ ಬುಕ್ ಮತ್ತೆ ಆಗಲ್ಲ 2 weeks ಅಲ್ಲಿ. ಪೇಪರ್ ಬುಕ್ ಬೇಡ ಮತ್ತೆ.
Number 29, BC Jata.
You are familiar with the facts, madam? File ಓದಿದ್ದೀರಾ?
Yes, sir.
ಡಿಕ್ಟೇಷನ್ ಮಾಡುವಾಗ ನಿಮ್ ಕಡೆ ಮುಖ ನೋಡಿದಾಗ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ರೆಸ್ಪಾಂಡ್ ಮಾಡ್ಬೇಕು.
Judgment ಶ್ರದ್ಧಾನಂದ ಸ್ವಾಮಿ ಹೇಳಿ. ಸ್ವಾಮಿ ಶ್ರದ್ಧಾನಂದ 2009 ಇರ್ಬೇಕು, ಮೋಸ್ಟ್ಲಿ 2009. The appellant has filed this appeal
against the judgment of conviction and order of sentence dated 31/12/2021, passed in session case number 69 of 2017 by the third edition session judge Vijaypura, wherein the learned session judge convicted the accused for the offence punishable under section 363, 364 capital A, 302, 201 of IPC, and sentenced him to undergo rigorous imprisonment for life and fine of ₹25,000 for the offence punishable under section 302 of IPC in default of payment of fine, further directed to undergo simple imprisonment for a period of 6 months. The accused sentenced to undergo rigorous imprisonment for a period of 3 years and pay a fine of ₹10,000, default of payment of fine, further directed to undergo simple imprisonment for a period of 3 months for the offence 363 of IPC. He sentenced to undergo rigorous imprisonment for life and to pay a fine of ₹25,000 in default of payment of fine, simple imprisonment for a period of 6 months for the offence 364A of IPC. The accused also sentenced to undergo rigorous imprisonment for a period of 3 years and to pay a fine of ₹10,000 for the offence punishable under section 201 of IPC. In default of payment of fine, further directed to undergo simple imprisonment for a period of 3 months. Full stop. It is directed that all the substantive sentence shall run concurrently. Full stop. Next, the brief facts which led to the trial of the appellant are as follows. The complainant in this case, PW1, that is the son of deceased in this case, has lodged the complaint before the respondent police on 21/9/2015 as per Exhibit P1, alleging that he is residing in the house of one Shankar Ethanol, that is PW6, on rent basis and along with this family full stop. He was a driver of auto rickshaw. Full stop. His son, auto rickshaw, by vocation, full stop. His son, Akshay, bracketally, now deceased in this case, is studying in third standard in the Marathi school, near Shivaji Circle, full stop. On 29/2015 at about 4 p.m. This is Akshay went outside of the house for playing and he could not return to the house, and the wife of the complainant has called him on telephone as their son was missing. Their son is missing. Full stop. Thereafter, PW1 and his wife have searched their son, but could not trace out him after making inquiry with the relatives at Appellate, Mumbai, Mannur in Afzalpur Taluk, finally, he lodged the missing complaint before the PSI of APMC police station as per exhibit P1 at about 8:30 PM, full show. The said complaint came to be registered in crime number 82 of 2015 by the APMC police for the offence punishable under section 363 of IPC as per exhibit P30 against unknown persons. Full stop. Subsequently, on 21, the next day, that is on 21/5/2000, that is on 22/9/2015, the PW1 received a telephone call, and it is stated that telephone call from a kidnapper by demanding ransom of rupees 2 lakhs to release his son. Full stop. As such, PW1 informed the said fact to the respondent police by giving his mobile number, carrying a mobile number, that is 97/30/12/35/93. Full stop. The PW7 PW11, the PSI of the respondent police, conducted the investigation by analyzing the call register of the mobile number of the complainant, PW1, so also the calls received by him from the kidnapper. Full stop. On CDR analysis, the PW11 came to know that the complainant has received ransom call from the mobile number bearing from the mobile number, that is 9743542273. Full stop. Accordingly, the PW11 conducted the investigation by finding out the finding out the user of the said mobile, and it was revealed that one Shankar Ethnal, that is the uncle of uncle of the accused, examined as PW7. PW7 was using this said mobile. Full stop. On inquiry of this said Shankar, internee revealed that the accused was residing along with him in the first floor. In the first floor of the house belongs to the first floor of the house where the PW1 was residing. Full stop. And further stated that the accused was using the said mobile and he was absconding from 2 days, that is 22/9/2000, from 22/9/2015. Full stop. As such, the respondent police, apprehended the accused on 24/9/2015. After inquiry, the accused, on inquiry, the police recorded the voluntary statement of accused, as per exhibit. Record. As per exhibit P18, wherein the accused revealed that on 29/2015 at about 4 p.m. he kidnapped the son of PW1, Master Akshay, from Agassi, Bambala Agassi, and he took him to Jyoti Pipe Factory, and he committed his murder by assaulting him, and thereafter, he thrown the dead body in a hill station near to the factory, and covered the dead body by size stones. Full stop. Subsequently, based on the and also admitted that you show the place where he buried the dead body. Full stop. Thereafter, the investigation officer PW22 along with the assistant commissioner, so also the PW123, 123. Thereafter, the accused led the investigation officer PW123, so also assistant commissioner, to the place where he buried the dead body, and by removing the size stones, and he showed the place of the said place, and the respondent police conducted the investigation, by identifying the dead body. Full stop. The PW 1 and 3 or the parents of the deceased also identify the dead body of their son based on the dress or clothes he worn at the time of missing. At the time of missing. Full stop. Subsequently, the investigation officer, subsequently PW 22, the permission of the learned jurisdictional magistrate invoked section 364, 364, 302 of IPC in the crime, full stop, in the crime, and conducted the further investigation, full stop. After drawing the relevant mahazar, so also obtaining necessary documents from the concerned authorities, PW 22 laid the charge sheet against the accused for the offense punishable under section 302, 363, 364A, 302, 201 and 201 of IPC before the committal court. Full stop. On committal of the case before the learned session judge, the learned session judge, as the learned session judge, having found prima facie case against the accused, framed the charges for the aforementioned offences, full stop. The accused pleaded not guilty to the charges and claimed to be tried. Full stop. Next, the prosecution examined as many as 13 witnesses in support of its case. Full stop. Its case. So also got marked 30 documents as exhibit P1 to P30 and got identified 7 material objects as the MO1 to MO7. Full stop. After completion of the prosecution evidence, the learned session judge recorded the statement under section 313 CRPC and CRPC, the accused denied his involvement in the crime. He pleaded that a false case has been lodged against him and he claimed to be innocent. However, no witness in defense has been examined by the accused. Full stop. The trial court, after considering the entire evidence on record, recorded the conviction and imposed sentence for the charges leveled against him as stated supra. Full stop. The said judgment is challenged under this appeal. Full stop. We have heard the learned counsel, Shri B.C. Jaka, for the accused appellant. So also, Shri Sitanagaudu Patil, the learned SPP for the state, respondent state. Full stop. The learned counsel for the appellant, Shri Jaka, learned counsel for the appellant, contended that the prosecution has utterly failed to prove the guilt of the accused beyond reasonable doubt, since the entire case rests on circumstantial evidence and there is no link of the chain link of the circumstance relied by the prosecution. Full stop. the learned session judge has convicted the accused based on the surmise and conjecture without appreciating the evidence on right perspective. Full stop. You would contend that the evidence of PW1 and PW3, that is the father and the mother of the deceased, deceased, has to be considered as a hearsay evidence, hearsay evidence, hearsay evidence, since they have informed about the incident by the police, full stop. By the police. PW2, though supported the case of prosecution, PW2, the punch witness, though supported the case of the prosecution, on perusal of his evidence, he has on perusal of his evidence, the drawing of relevant measures at the place of incident, and also the place where the dead body was recovered at the instance of the accused are not drawn as per the law laid down as per the law as laid down by the Honorable Apex Court in canon of judgments. Full stop. You would further submit that they submit that the PW submit that the last scene witness, that is PW4, has not fully supported the case of the prosecution, and there is an inordinate delay in recording his statement. Full stop. His statement. Full stop. The prosecution. Full stop. As such, the prosecution totally failed to prove the circumstance of last scene theory. Full stop. The further there is a contradiction. There is a material contradictions and omissions in the evidence of PW 1 and 2 in respect of the missing of their child, the deceased. So also the participation of the accused in the crime by demanding ransom. Full stop. The mobile number given by PW1 and the other information of he receiving the ransom call from the mobile number of the accused is totally not proved since the call register produced by the prosecution is not disclosing such call details. Full stop. Call details. In such circumstance, call details. In such circumstance, the learned session judge erred in convicting the accused for the offense 364A and 302 of IPC. 302 of IPC. Full stop. IPC. The further the motive further you would contend that the prosecution also failed to prove the circumstance of identifying the dead body by PW1 and 3. PW1 and 3. That is the parents. That is the parents. Full stop. According to them, the evidence placed by the prosecution reveals that PW 1 and 3 identified the dead body based on the shirt and based on the shirt and trouser worn by the deceased at the time of on the date of missing. But the recovery mahazar depicts that the color of the shirt and trouser totally but the recovery mahazar depicts that the color of the shirt and trouser which narrated by the PW1 is totally differs in respect of the seized materials. Full stop. In such circumstance, the prosecution has utterly failed to prove the guilt of the accused. Full stop. Lastly, you submit that since the case rests on circumstantial evidence, duty cast on the prosecution to prove the case beyond reasonable doubt by linking all the circumstance by pointing out the guilt of the accused. In this case, there is no such solid evidence placed by the prosecution. Accordingly, he prays to allow the appeal by setting aside the impugned judgment of conviction and order of sentence. Full stop. The learned SPP, the learned SPP for the state, refuting the above submission, the learned SPP for the state on the other hand, submitted that the prosecution has clearly established the guilt of the accused and no exception can be taken to the reasons indicated by the trial court under the well-reasoned judgment. The full stop. The evidence has also been analyzed by the in great detail by the trial court. Therefore, no question of any interference is called for with the conviction order recorded in the impugned judgment. Full stop. By enunciating his submission, he would he argued that the evidence of PW 1 and 3, that is the parents of the victim, parents of the deceased, clearly establishes the fact that the accused is solely responsible for the kidnap and murder of their son Akshay, and he himself, and he also demanded ransom from PW1. This said aspect was very much proved by the prosecution by placing the evidence of the call call register details, and also placing the certificate under 65B from the Airtel company, SPP, from the Airtel, from the concerned officer of the Airtel network, Airtel company, full show, Airtel company. Further, the accused himself led the police and PW 123. So also the assistant commissioner to the place where he buried the dead body. This buried the dead body, and at his instance, the dead body of the deceased was recovered. This major circumstance clearly proved by the evidence of PW 123, so also the evidence of PW 22, the investigation officer 22, the investigation officer and the assistant commissioner PW and the assistant commissioner PW. ಎಷ್ಟು?
18.
Huh? PW
18.
12. PW 12. PW 12. PW 12. So also PW 12. So also the exhibit exhibit P ಯಾವುದೆಲ್ಲ ಅದು? Exhibit P10, exhibit P10, exhibit P10, full stop. Exhibit P10. You would further exhibit P10. You would further contend that the last seen witness, the last seen circumstance, the theory of last seen circumstance also proved by the prosecution by examining PW4, who has categorically stated that he had seen the accused and the deceased on the date on 21/2015, near the place where the dead body was recovered. Dead body was recovered. Full stop. Though there is a delay in recording his statement, the said delay was properly explained by PW4. Explained by PW4. Full stop. Further, the motive for the incident, that is the motive for the incident, that is the ransom amount, that is the ransom amount claimed by the accused is proved by the evidence of PW1. So also the call details, that is exhibit P20, exhibit P27, exhibit P27, full stop. The P27. The further, the homicidal death of the deceased is also proved by the prosecution by examining the Tahsildar PW12 and also the doctor and also the doctor who conducted the autopsy on the corpus of the deceased. Full stop. The deceased, full stop. The in such circumstance, the medical evidence, the oral testimony of the material evidence corroborates to the medical evidence placed by the prosecution. Accordingly, medical prosecution. Full stop. He also, the learned SPP also submits that the minor contradictions in the evidence of material witness, does not go to the root of the prosecution to discard their testimony, and as such, the prosecution clearly proved the charges leveled against the accused beyond all reasonable doubt. And accordingly, the appeal is deserves to be dismissed. Full stop. Dismiss. Having heard the learned counsel for the appellant, so also the learned SPP, learned additional SPP, and also after perusal of the entire evidence on record, the points that would arise for our consideration are: number one, whether the judgment under this appeal suffers from any perversity or illegality. Number two, whether the learned session judge is justified in convicting the accused for the offense punishable under section 302, 364A, 201 of IPC, 363 and 363 of IPC. Full stop. Next, we have independently analysis the entire oral and documentary evidence appearing on record in order to appreciate the respective contentions of the learned counsels for the parties. Full stop. The before for the parties. Full stop. Before dwelling into before dwelling upon to analyze the evidence on record as stated supra, comma, this case totally rests upon the circumstantial evidence, comma, as per the settled position of law by the Honorable Apex Court way back in the year 1993, that is in the case of Sarbir Singh versus State of Punjab, reported in 1993, Supplementary Volume 3, SCC 41, the Honorable Apex Court in Para 6 held as under ಹಾಕೊಳ್ಬೇಕು. Next, the above principles enunciated in the above case is also reiterated in the case of Sharad Bidrichand Sharad versus State of Maharashtra, reported in 1984, Volume 4, SCC 116. And the Honorable Apex Court laid the golden principles to prove the case based on circumstantial evidence. Full stop. The said principles also reiterated in the recent judgment of the Honorable Apex Court in the case of Shankar versus State of Maharashtra, reported in 2023, SCC Online SC 268, wherein the Honorable Apex Court has summarized the guidelines to convict the accused in the cases which are based on circumstantial evidence. Full stop. Keeping in mind the above principles, comma, when we analyze the evidence on record and also the circumstance relied by the prosecution, comma, the following are the aspects that fall out in our consideration. Number 1, the homicidal death of deceased Akshay. Full stop. In order to prove the homicidal death of the deceased, comma, the prosecution has relied the evidence of PW9 doctor who conducted autopsy on the corpus of the deceased and issued the post-mortem report as per Exhibit P18. On perusal of Exhibit P18, comma, the doctor has mentioned that the deceased sustained the external injuries as under number 1, comminuted fracture seen over the occipital region extending from right mastoid process, MASTOID, process to left mastoid process. Full stop. On further examination, brain was liquefied and large number of larvae seen. Number 2, contusion seen over the ankle region, both right and left. Full stop. After examining, the doctor has opined that the death is due to hemorrhage and shock as a result of blunt injury to vital organs, bracketally brain. Full stop. The PW9 has deposed in support of contents of Exhibit P18. Though the learned counsel for the accused cross-examined PW9 and cross-examined PW9 that that the dead body, that the dead body, that the scientific examination was not conducted by an expert, comma, the doctor has stated that there is no need of such examination to state the cause of death. Full stop. As such, there is a clear corroboration to the corroboration between the testimony of PW9 and the contents of exhibit P18. Full stop. P18. Further, the prosecution also relied the inquest panchanama drawn on the dead body of the deceased as per exhibit P7 by PW12, the then Assistant Commissioner of Vijaypura. Full stop. Though the on perusal of the exhibit P7, the same reveals that though the body was decomposed, the parents of the deceased, that is PW123, identified the dead body of their son based on the dress worn by him. Dress found on the dead body, dress found on the dead body. Full stop. PW2 is the witness for exhibit, Pancha witness for exhibit P7, He also deposed that the accused has shown the place and the mahazar was drawn to that effect as per exhibit P10. Further, PW1 and PW3 were also examined, were also deposed about the injuries, about the injuries found on the dead body. Hence, a conjoint reading of the evidence of PW9, the doctor, PW12, the Assistant Commissioner, the PW2 punch witness for exhibit P7, and also the evidence of PW1 and 3, coupled with the exhibit P18, P7, and P10, we are of the considered view that the prosecution has proved the homicidal death of the deceased Akshay beyond reasonable doubt. Full stop. To connect the accused for the homicidal death of the deceased, the prosecution relied the circumstance like, lodging of complaint by PW1 and the missing of the son of PW1, missing of the deceased, lodging of complaint by PW1 and arrest of the accused. Full stop. As per PW1, next. As per PW1, as per the evidence of PW1, his son, Master Akshay was found missing from 29/2015.
Your Lordship, it's sincere apology. Your Lordship, in quota number 4, serial number 29 is it? If your permission, can I go?
As per PW1, and his son Akshay was missing from 29/2015 at about morning over 9 a.m. And later he searched himself and his wife PW3. Both were searched and not able to find him. Later at about 8 p.m. Later on the same night at about 8 p.m. he went to the police station and lodged the missing complaint as per exhibit P1 as per exhibit P1. Full stop. Based on the same, the respondent police registered the FIR, registered the FIR as per exhibit P, as per exhibit P30, exhibit P30 for the offense 363 of IPC. Full stop. According to PW1, on the next day morning, that is on 21/9/2015, he received the call from unknown number, call from unknown person in a mobile call for ransom of rupees 2 lakhs. He stated that the kidnapper, threatened PW1 to hand over a ransom of rupees 2 lakhs. Otherwise, he would kill the son of PW1. Hence, the PW1 informed the same to the police by handing over the mobile phone of the handing over his mobile phone to the police. Full stop. Accordingly, the PW11 conducted the further PW11 conducted the 11 how the SPP rank? PW11, correct. PW11, Veena Nayak, the then PSI of respondent police conducted the investigation by obtaining the CDR, call detail registers of the mobile of the complainant, that is 9730123593 full stop. 93 on the 93 full stop. On the evidence full stop. Further, PW11 deposed before the court that on analyze of CDR details of the said mobile, said phone number, she came to know that the complainant the PW1 has received a ransom call from the mobile of from the mobile number 9743542273 full show according to 73. Hence, as such, she conducted the investigation and arrested PW7 one Shankar Ethnal, PW7 Shankar Ethnal. On inquiry, Shankar Ethnal, who is none other than the uncle of the accused. On inquiry, this said PW7 revealed that though the said mobile number belongs to him, the same was handed over to the accused. The same was taken by the accused, and he was missing. The accused was missing from 22/9/2015. 2015. Thereafter, the entire call detail register was obtained by PW12, and by PW 11 as per exhibit P27 as per exhibit P27 and exhibit P27 and PW 11 arrested the accused on 24/9/2015. 24/9/2015. Full show. On further investigation, it is revealed that as many as 60 calls received by the PW1 from the above mentioned mobile, from the above mobile number of the accused in a span of 3 days, period of 3 days, period of 3 to 4 days, 3 to 4 days for ransom. Full show. 3 to 4 days for ransom. As such, ransom. Accordingly, after arrest of accused, comma, the PW arrest of the accused, comma, PW 11 recorded the voluntary statement of the accused as per exhibit P18, wherein the accused confessed about the crime and produced two mobiles as per MO SPP as per MO 345 ಅಲ್ಲಿ ಇವ್ರದ್ದು ಯಾವ್ದದು?
ಇವ್ರದ್ದು 3 and 4, sir.
3 and 4.
Yes.
So MO
that exhibit is 18B, my lords, voluntary state.
MO 3 and 4. MO 3 and 4. Full show. MO 3 and 4. The 3 and 4. PW1 full show. PW1 in his evidence clearly deposed that on 21 after the missing of his son, the deceased, the next day, that is on 21/9/2015, he has received the call to his mobile for a ransom of rupees 2 lakhs for 2 lakhs. Full shop. He further deposed that he has arranged the said amount. However, the kidnapper has not come forward to receive the said amount or to by releasing his son. Full shop. Thereby he lodged the complaint. Full shop. Thereby finally he lodged the complaint and informed the same to the police. Full shop. Informed the same to the police. On the next day, that is on 25/9/2015, the PW1 once again gave his further statement before the police as per exhibit P2. Exhibit P2. He cleared exhibit P2, wherein he once again reiterated the contents of exhibit P1, and also deposed about the voluntary about the confession made by the accused before the police station at his presence. Full show. At his presence. As such, on perusal of the above evidence of PW1, PW1, PW11, PW22, the investigation officer,
PW4.
PW22 investigation officer, the prosecution. The prosecution has proved the circumstance of missing of the the son of the PW1, lodging of the complaint by him, and the arrest of accused, arrest of the accused. Next. The next circumstance relied by the prosecution is the recovery of dead body of deceased at the instance of accused. So also the drawing of mahazars in the drawing of the mahazar at the place where the accused kidnapped the deceased, and committed his murder, full stop. According to the investigation officer, that is
PW 13.
PW 13, ಮೇಲೊಂದು 22 ಅಂತ ಬರ್ದಿದ್ದೀರಿ, ಅದು 13 ಅಂತ ಮಾಡ್ಬೇಕು. 22 ಅಂತ 13. According to PW
For submission, that mobiles 3 and 4 and 5. 4 and 5. According to PW 12, the investigation officer, PW 12, investigation officer, according to the PW 12, PW 12, the assistant commissioner, PW 12, the assistant commissioner of Vijaypura, and the evidence of PW 13, the investigation officer, after the arrest of accused on 24/9/2015, as per the voluntary statement of accused at exhibit P18 P18B, 18B, the PW 22 called PW 2 the pancha to the police station. So also PW 1 and 3, that is the parents of the deceased, and in front of all the three, the accused confess about the incident, and also he led all these witnesses to the place where he kept the dead body, full stop. Where he kept the dead body, full stop. That is kept the dead body. That is at Eliadu. That is it near the outside the city millets.
The place alone the ಹೇಳಿದಾರಲ್ಲ.
Place otherwise. Yes. Pipe factory.
Near pipe factory.
Pipe factory.
Near pipe factory. Full stop. Near pipe factory. Full stop.
Jyoti pipe. Jyoti pipe factory.
Jyoti pipe factory.
Yes.
The accused led the investigation officer and the panchas to the said spot, and on said spot, and on removal of the size stones, the police found the dead body of the deceased in a decomposed condition. Full stop. That is near Hilltop and that. Hilltop Jyoti Pipe Factory.
Yes.
There is a place called Hilltop near Jyoti Pipe Factory. Full stop. Thereafter, PW 1 and 3 identified the dead body based on the clothes worn by him at the time of his kidnap on 29/2015. At the time of his kidnap. Full stop. The PW 12, the assistant commissioner drawn the inquest panchanama on the dead body as per exhibit
P10. 10, sir.
P10 exhibit P10 alla.
Is it measure of the place of tracing out the dead body?
P10 alla nodi. P10 placing inquest panchanama ಎಷ್ಟು? as per exhibit P7, as per exhibit P7, full stop. P7. PW2 was PW2 and PW2, the Pancha was present. Pancha was present. Later, the investigation officer PW13 also drawn the Mahazar in the said place as per exhibit P10. Exhibit P10. PW2 was very much present at the time of drawing this, drawing exhibit P10, full stop. Nevertheless, PW1 and PW3 were also present along with the assistant commissioner, full stop. The assistant commissioner, full stop. The assistant commissioner. It is the contention of the learned counsel for the appellant that the dead body was totally decomposed as admitted by the doctor, PW9. As such, there is no such possibility of identifying the dead body by PW1 and 3, that is the parents of the deceased. Full stop. Further, he would submit that though the blood samples drawn from PW1 and 3, there is no such DNA examination was conducted by the concerned authority. As such, the prosecution has failed to prove that the dead body of the dead body recovered at the instance of the accused belongs to the son of PW 1 and 3, son of PW 1 and 3, full stop. 1 and 3. As 1 and 3. As discussed supra, on perusal of exhibit P1, the missing complaint lodged by PW1, he has categorically mentioned the color of the dress and the trouser on at the time of missing. That is on 29/2015. Full stop. On 2015. Thereafter, based on the said 15, based on the full stop. Later they both PW1 and 3 both were identified the dead body based on the said clothes.
MO1 and 2.
Said clothes, that is MO1 and 2.
Yes.
On careful perusal of the clothes mentioned in exhibit P1, the color of the clothes mentioned in exhibit P1 and the color of MO1 and 2 drawn under Mahazar.
Mahazar exhibit P10.
P10, ನೋಡಿ
Caesar cloth 12.
Exhibit P12. Exhibit P12, there is a clear similarity. In the color of the clothes.
Yes.
Full stop. Moreover, PW1 and 3 are none other than the parents of the deceased. It cannot be presumed at any stretch of imagination that the parents are unable to identify the dead body of their son after 4 to 5 days from the date of death, though the body was in a partially decomposed stage. Full stop. Nevertheless, on perusal of the inquest Panchanama, exhibit P,
Which ones? 12. Inquest is 7, my lords.
Exhibit 7, exhibit Panchanama, exhibit P7.
P7, my lords.
Exhibit P7.
163 pages. Exhibit P7, inquest.
Exhibit P7, exhibit P7, the inquest Panchanama drawn by the investigation officer, comma, on question number 5, comma, it has answered that the height of the dead body was 4.2 inches. 4.2 inches. The same once again clarifies that the dead body is of the male child.
Yes.
Male child. Full stop. Male child. Full stop. As such, the contention of the learned counsel for the appellant that the PW 1 and 3 are failed to identify the dead body cannot be, does not hold much water. Yes. Full stop. Further, PW, further, the accused on perusal of the evidence of PW 22 and PW 2, the Pancha, PW 2, the Pancha, comma, they categorically stated that the accused volunteered before confessed before the investigation of PW 22 in the police station, and thereafter he led the witness to the place where the dead body buried / kept. Full stop. The IO, the investigation of drawn the Mahazar in the said place as per exhibit P10. As per exhibit P10. Full stop. Exhibit P10. The as such it is clear that the said aspect was very much well within the only within the knowledge of accused. Only within the knowledge of accused. Full stop. Based on the voluntary statement of accused, only the said dead body was recovered by the police by removing the size stone kept on the dead body. The prosecution also placed the photographs of the same as per exhibit P8 and exhibit P8 and P9. Full stop. On P9. On perusal of the same, it once again clarifies that the said place shown by the accused was well within his knowledge. As such, in our consider opinion, comma, the prosecution also proved the circumstance of recovery of dead body at the instance of accused. Full stop. Under exhibit P10. Full stop. PW2 also deposed that the accused led them to the place where he has committed where he has kidnapped the accused, kidnapped the accused and the police were drawn a Mahazar in the said place as per exhibit P5. Full stop. P5. Further, the accused also shown the place where he has committed the murder of deceased by dropping a sized stone on him. The said the police were drawn a Mahazar in the said space as per exhibit P11. Full stop. Exhibit P11. PW2 PW2 also stated that the police were seized the clothes of the accused, clothes of the deceased from the clothes of the deceased clothes from the dead body. Clothes from the corpus of the deceased under exhibit P12 as per MO 1 and 2, 1 and 2, full stop. The 1 and 2. All these mahazars were drawn by PW13, the investigation officer, and PW2 and the parents of the deceased PW1 and 3 were present at that along with the police. As such, police, full stop. Though the defense cross-examined PW2 at length, nothing worthwhile has been elicited from his mouth to discard is evidence. Discard is evidence. Full stop. The minor contradictions in respect of the time of drawing mahazars, itself cannot be construed cannot be reason to disbelieve the version of PW disbelieve and discard the version of PW2. Hence, on perusal of the above evidence, we are of the considered view that the prosecution has also proved the above circumstance. Also proved the above circumstance. Full stop. Above circumstance. The next circumstance, last scene on the headlines. The prosecution, full stop. Apart from the above circumstance, the prosecution also prosecution also relied the last circumstance, relied the circumstance of last scene theory, that is the accused and the deceased were found at the place where the dead body was recovered on 21.
Yes.
29 2015 PW4 evidence of 29 PW15 by examining PW4 full stop. On perusal of the evidence of PW4, he stated in his evidence that on 29 2015 at about 4 p.m. when he was traveling to Bijjaragi showroom near Indi Road, Kunta Bombala Agassi, he found the accused and the deceased were going near were going near the hilltop near the pipe factory, near the pipe factory, full stop. However, pipe factory. However, full stop. Thereafter, he went to Mumbai and returned on 24/9/2015. On that day, he came to know about the murder, about the death of deceased and about the murder of deceased by the accused. Accordingly, he deposed accordingly, he stated the same before the police. Full stop. The evidence of PW4 full stop, full stop. Though there is a delay in recording the statement of PW4, though there is a delay of 4 days in recording the statement of PW4, the said delay has been properly explained by PW4, stating that after 29/2015, he went to Mumbai for 4 days and returned on that day and give a statement before the police, As such, before the police. As such, there is no reason to disbelieve the evidence of PW4. Full stop. Moreover, the dead body was identified, the place, dead body was recovered, the place where the accused near, where identified near the place where the accused and deceased was going together, as stated by PW4. As such, the prosecution also proved the theory through the last scene theory. Full stop. Last scene theory. Full stop. The last scene theory. Full stop. As stated, full stop. The next circumstance the prosecution relied is the motive for the commission of the crime. As discussed supra, the PW1 in his evidence and also in his complaint, exhibit P1 lodged on the next date of incident, that is on 21/9/2015, has clearly stated that his son was missing from 29/2015, and thereafter they searched himself and PW3, his wife, searched all the places, and thereafter they lodged the complaint. In his evidence, he has stated that on the next day, that is on 21/9/2015, he has received a call through to his mobile for a ransom of rupees 2 lakhs. Full stop. From 2 lakhs. Thereby he informed the same to the police and handed over the mobile to them. Full stop. On perusal of the evidence of PW11, she came to know about the call detail, she analyzed the call details of the said mobile, which analyzed the call details of the said mobile, and came to know that the uncle of the accused was using the said mobile, and on inquiry of the uncle of the accused, PW6, came to know that the accused was the perpetrator of the crime. Full stop. Accordingly, he has been arrested by the police. Full stop. The
PW7 uncle.
PW6 ಅಲ್ಲ, PW7. Full stop. The 7. Full stop. As per the full stop, to attract the offense, the Honorable Apex Court in the case of Ravi Dhingra was the state of Haryana, reported in 2023, volume 6 SCC 76 in para 25 held that in order to attract the provision of section 364A of IPC, whoever kidnaps and threatens cause of death or cause of death. Full stop. On careful perusal, careful perusal of the law summarized by the Honorable Apex Court in the above judgment, judgment, and by collocating collocating said guidelines to the fact and circumstance of this case, on perusal of evidence of PW1, he has stated that the accused threatened him, accused not only accused demanded and threatened him for a ransom of rupees 2 lakhs and specifically stated that if he failed to arrange the said amount, then he would kill his son. In such circumstance, the ingredients of section 364A of IPC clearly complied in the case on hand. Full stop. Case on hand. It is case on hand. Full stop. It is vehemently contended by the learned counsel for the appellant that the call registers placed by the prosecution as per exhibit P20. There is a discrepancy in the call register placed by the prosecution as per exhibit P26 and P27. Full stop. P27. Full stop. The evidence of PW11, the then PSI, who initially obtained the call CDR, call detail registers from the mobile belongs to accused, from the mobile belongs to the deceased, clearly revealed that the PW1 has received nearly 60 calls, more than 60 calls from the mobile number 9743542273 belongs to PW7. The PW7 on arrest in the statement of PW7, the statement recorded by the police under 161, the statement of PW7 recorded under 161. So also is evidence before the court. He has clearly admitted that the said mobile phone belongs to him. The said mobile number belongs to used by him, and on the date of incident and immediately after the incident, the same was taken by the accused, and the accused was absconding thereafter. We have carefully perused exhibit P26. On perusal, exhibit P26. On perusal, there are more than 60 conversation held between the mobile number 9735422273 and 9730123593.
Yes.
1293. Full stop. 93. 93. Further, the concerned officer of the Airtel network, Airtel alva, SP Bharat.
Airtel.
Airtel Bharata.
Airtel is.
Airtel, correct. Concerned Airtel officer has issued the certificate under 65B of Indian Evidence Act, which depicts that some 16 the call details containing 16 pages are retrieved from the above mentioned mobile phones for the period 15/9/2015 to 24/9/2015. Full stop. 2015. to 15. Moreover, the prosecution successfully proved the recovery of MO 1 and 2, that is the mobile phone at the instance of accused, based on his voluntary statement, exhibit P18.
Yes.
Exhibit P18. P18. P18B. Also, PW2, the witness also deposed to that effect. To that effect. Full stop. The honorable apex court, in the case of Honorable Apex Court in the case of, to further buttress the evidentiary value of the same, we rely on the decision of the Honorable Apex Court in the case of Muhammad Arif versus Ashaf Q versus State of NCT Delhi, reported in 2011, volume 13, SEC 621, wherein the Honorable Apex Court in paragraph number 60 has held as under Adanaku. Next, 60. Full stop. Further, in another decision of the Honorable Apex Court in Gajraj versus State, NCT Delhi, reported in 2011, volume 10, SEC 675, the Honorable Apex Court in paragraph number 16 of the judgment has held as under. By the above findings of the Honorable Apex Court in the judgments, it is clear that the electronic evidence placed by the prosecution, that to the conversation between the mobile phones can be relied, since every mobile handset has an exclusive IMEI number. No two mobile handsets have the same IMEI number. And every time a mobile handset is used for making a call, besides recording the number of the caller as well as the person called, the IMEI numbers of the handset used are also recorded by the service provider. Full stop. The service provider. In the case on hand, for service provider. Full stop. Hence, the evidence of the above evidence of the call details register can be safely relied to connect the accused in the alleged crime, since the said evidence comes well within the ambit of Section 8 of the Evidence Act. Full stop. Section 8 of the Evidence Act, as held by the Honorable Apex Court in the case of State NCT of Delhi versus Navajot Sandhu, reported in 2005, volume 11, SEC 600. Full stop. Hence, on careful perusal of the law laid down by the Honorable Apex Court in the above judgment, so also the evidence placed by the prosecution, we are of the considered view that the prosecution has successfully proved the said circumstance, proved the above circumstance, and above sir, and laid the hand on the accused, laid the hands on accused, full stop, laid the hands on accused, full stop, the accused. The as far as the as far as comma, as far as the full stop, this accused, the hands on overall hands on overall on perusal of the overall evidence placed by the prosecution, and also the above, and also the circumstance relied by the prosecution, the above circumstance relied by the prosecution, comma, prosecution, comma, comma, and considering the nature of the crime and the manner in which it was planned and committed, comma, the motive for the commission of the crime, the conduct of the accused, that is, after committing the murder of the murder of the deceased, the Master Akshay, who is aged about 9 years, comma, he has demanded the ransom. It is the evidence of PW1 that based on the ransom call, he arranged the said money, arranged rupees 2 lakhs. However, the accused was neither released his son nor received the money. In such circumstance, comma, the brutal act of the accused, comma, it's proved by the prosecution by relying the relevant circumstance of the conclusive, the evidence of conclusive nature, full stop. The circumstance relied by the prosecution discussed supra, comma, are consistent only with the hypothesis of the guilt of the accused, full stop. Except the accused, none else have committed the murder of deceased for any reason, even full stop, even even otherwise, comma, the accused failed to either put forward or prove such defense which would break the chain and would give a different interpretation than that of what is pleaded by the prosecution, full stop. In such circumstance, we are of the view that the golden principles laid down by the Honorable Apex Court in the case of Sharad Bidrichand Sharad stated supra, and subsequent judgments are proved, and the learned session judge as judgments are proved, and the learned session judge has rightly convicted the accused for the charges leveled against them, full stop. They leveled against them, full stop. They it is leveled against them. Hence, we find no good ground to interfere with the judgment of conviction and order of sentence. Accordingly, we answer point number 1 in the negative and point number 2 in the affirmative, and proceed to pass the following order. Criminal appeal so and so is hereby dismissed.
Much.
Submission. Serial number 37. I appear for the respondent. My lord, it may not reach any convenient date it may be given. It may not reach, my lords. 37. Appear for the respondent. Or else it may be continued in the list.
My lord, on submission. Serial number 31 and 35, my lord. I have already taken date on Tuesday, my lord. It's been repeating kindly at that Tuesday. my lord.
Yeah,
Any
every day
permission,
you are
Lord?
there, we are noting your presence. Yes.
My lord, serial number 11.
Sorry, my lord.
My
Yes,
lord,
yes.
I'll undertake to file a wakalat for R2, my lord.
Field number
11, my lord. A week time may be granted.
Lord Giri and so Kashampur undertakes to appear for
R2, my lord.
R2.
It is served.
Already we passed an order, you serve copies. Please. ಅದೆಲ್ಲ order ಮಾಡಿದ್ದೀವಿ ಬೆಳಿಗ್ಗೆ. ಹೌದಾ?
Pass
Now, what about the other respondents?
Other respondents is in government.
The only respondent to consider my representations for as per the
R2.
direction of the Lord Single
Please.
Judge.
R2. Government is already appeared for R5.
Yes, ma'am.
Play.
Other respondents
Other respond notice not order. They are the private respondents, ma'am.
not required.
Private respondents, they are part of the proceedings, my lord. Because some orders are required to be passed as against them.
Emergent notice to respondents
3 and 4, ma'am.
3 and 4.
Please.
What about 1?
One is state.
One is formal party statement.
Grateful.
Much
DA
obliged.
is directed to accept notice for R1 and R5.
Grateful.
Court officer.
ಸರ್ ಅದು ಬುಧವಾರ ಡೈಲಿ ರಿಪೀಟ್ ಆಗ್ತದೆ ಸರ್ ಅದು ಬುಧವಾರ ಬರ್ತೈತಿ
ಹಾ ಆಯ್ತು ತಗೋರಿ. ಅಂದ್ರೆ ಲಿಸ್ಟ್ ಆಗಿತ್ತಲ್ಲ ಮತ್ ಕರೆದು.
ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರ್ಲಿ ಅಂದ್ರು ನೀವು ಬುಧವಾರ ಮಾಡ್ತೇನೆ ಅಂದಿದ್ರಲ್ಲ ಸರ್
ಹ್ಮ್
ಏನಾದ್ರೂ ಸಿನಾಪ್ಸಿಸ್ ಕೊಡೋದಿದ್ರೆ ಕೊಟ್ಬಿಡಿ ಸರ್.
ಸರಿ ಆಯ್ತು. ಈಗ ಆಮೇಲೆ ಏನ್ ಮತ್ತೆ ಕರೆಯಲ್ಲ 31 ಈಗ
ಮೇಡಮ್
2:30ಗೆ.
ಇವತ್ ಕೊಡೋದಿದ್ರೆ ಕೊಡಿ ಸರ್.
ಅಲ್ಲಲ್ಲ ಮೇಡಮ್ ಆಮೇಲೆ 2:30ಗೆ ಮತ್ತೆ ಕರೆಯಲ್ಲ
ಏನ್
31
ಅವಶ್ಯಕತೆ
35.
ಇಲ್ಲ ಸರ್, ಬೇಡ ಬುಧವಾರ ತಗೊಂತಾರ ಸರ್.
ಸರಿ, ಥ್ಯಾಂಕ್ ಯು.
for the petitioner in this. I have received the no objection file, my lords, for from the petitioner's State Bank of India, my lords. I need some time for compliance, my lords.
When do you want?
1
Take
week,
a
my
date,
lords.
but you clear it.
Yes, my lords. I'll communicate, my lords, and thereafter because I have to receive the file. A date could be fixed, my lords. A 10 days accommodation, my lords.
Good. Let request list the matter on 23rd.
Please, my lords.
By then you find out what is to be done next.
Please, my lords.
This is the writ by the bank, is it?
Yes, my lords, bank.
You are challenging order of DRAT.
Yes.
DRAT.
DRAT, my lords. I have to get the entire papers and make my submission.
Get it.
Please. Obliged. Lord, I appear for the appellant in this matter, my lords. As I have submitted a copy of the reference judgment, my lords. And the coordinate bench judgment also submitted before the honorable court, wherein the connected matters have been remitted back for fresh consideration.
Correct. So what we wanted to know in the morning.
Yes, my lords.
Whether
I got that.
connected means 53 and
Yes, my lords. Those, my lords, are appeals filed before the district court doesn't for the want of pecuniary jurisdiction, my lords. Because the extent is less, so the amount is less than 10 lakhs, my lords. So
Correct.
it was filed before the district court, my lords. Here only as per the pecuniary jurisdiction, my lords, 2 appeals were filed before this honorable court.
now those two RAs.
Yes, my lords. LACA, my lords. LACA. Land acquisition appeals, my lords, before the district court.
It will be in like an RA.
Yes, my lords.
Now those have been remanded.
Yes, my lords.
So they cannot be conflicting.
Yes, ma'am.
Because the common.
Common order. Because these
So
judgments.
just correct. So now you just show me that appeal order.
Yes, my lords.
You have the appeal order?
Pardon.
Do you have the order remanding it back?
These are the appeals, my lords.
Which one?
These are the batch of judgments which I have submitted today morning, my lords.
But you said district court munde appeal.
My lords, there are a batch of around 30 matters.
Correct, but I'm on the point.
Yes, my
that if it is these other matters, 83.
Those are pending for consideration before the court below.
Which one?
Because
83 and 52.
Yes, my lords.
Correct. So then now okay, but you have to demonstrate.
Yes, ma'am.
Showing the order of the reference court.
Yes, ma'am.
In the other batch. Let us have a look at one other batch reference court order.
Yes.
Now you have produced a MFA, isn't it?
Yes, my lord.
Okay, see. Now what is the project? Okay, let us see. What is the project?
Project is for the purpose of laying railway line, my lords. New railway line from Munirabad to Mehboob Nagar, my lords.
No, but unless this land,
yes, ma'am,
which subject matter present appeal is adjacent to these which is disposed of, how we can just
of the very same village, my lords. Of the very same village, same notification, there is no difference with regard to that.
So on what ground the court has remanded?
My lords, before the reference court, my lords, the point for consideration was one judgment consent award was taken into consideration for determining the market value. Consent award, my lords, it includes all the statutory benefits, my lords, like in the additional market value and the consortium, my lords. Here, my lords, they have taken that as an exemplar.
So the appellate court said you can't do it only on the basis of consent
award. Yes.
And set aside the reference.
Set aside the order of the reference court for fresh consideration, the matter was remitted back.
So here also same, is it?
Yes, my lords. Exhibit P20 is the reference court order, my lords. Or the consent award, my lords.
P20.
P20 was the
statement of the Leo.
Yes, my lords. The consent award was taken into note of, and thereby, my lords, market value is determined at 15 lakhs per acre, my lords. And thereby, my lords, additionally 12% additional market value and consortium was awarded to the appellants for the respondent claimant, my lords.
P29 is the consent award.
Please, yes, my lords.
P29.
P20, my lords. P20, my lords.
No, just look at page 17.
Yes, ma'am.
There in the middle of the paragraph, exhibit P29 consent award accorded by the government. And therefore, they are entitled to get compensation of
15 lakhs per
annum.
Yes,
in place of actual award of compensation after deducting amount.
Yes, ma'am.
Now, in these appeals also, the court noticed the same consent award.
Yes, yes,
ma'am. Just take us through it.
Please, ma'am. Para 10, my lords. The submission of the claimants on behalf of the claimants was submitted at para number 10, my lords, regarding the awarding of consent award which was adopted. My lords. And para 18, my lords, at page number 69. '18 and 19.
Yes. Now you just take us through this. So you are saying on same ground, we can send it back.
Yes, my lords.
Who appears for the other side?
My lords, other side have been served with the notice, my lords, and they have remained unrepresented, my lords, as on behalf of claimant, my lords. As regard to the respondents, my lords, respond number 2 and 3 are the government, my lords.
They're sailing with you.
Yes, my lords, they are
Huh?
selling.
Isn't
Yes,
it?
my lords.
The landlord claimant is not there.
Yes, my lords.
They withdrawn the money. What happened?
No, amount was not withdrawn, my lords. It was kept intact, my lords.
So just take us through the MFA relevant observation.
Yes, ma'am. Para 18, my lords. May I read, my lords? Para 17, it starts. Para 16, my lords. It gives a broad picture as regard to the
Read.
It's further germane to notice that the special land acquisition officer in respect of the properties belonging to the claimants at Mamdapur village had on spot inspection declared that the lands belonging to claimants were all dry land, more specifically reporting that they were all tail end lands and only dry crops would be raised in all the properties. The said report is neither questioned nor challenged. The reference court, notwithstanding the aforestated spot inspection report of the special land acquisition officer, held that the government had in the year 1972 declared the properties of the claimants and the like were illegated properties in terms of the publication of official gazette on 7/12/1972. The reference court, in spite of the clear evidence of the special land acquisition officer in terms of the report placing reliance upon the gazette notification, considered the lands as a semi-irrigated lands. The special land acquisition officer was examined as RW1 before the reference court, and in his deposition, he has clearly stated that the properties in questions were tail end lands and the claimants were raised only dry crops. There is absolutely no cross-examination of the special land acquisition officer by the claimants in respect of the aforesaid categorical assertion. The reference court further relied upon Exhibit P31, which concerns the properties acquired of the Sinnoor Raichur district and Gangavati Taluk of the Koppal district for the similar purpose, formation of the new railway line, wherein the special land acquisition officer on consent had fixed the compensation of rupees 6 lakhs per acre for dry lands, 8 lakhs per acre for semi-irrigated lands, and 15 lakhs per acre for fully irrigated lands. It is pertinent to note at this stage itself that the lands are neither nearby nor the same taluka or district are at a distance of nearly 50 kilometers. The reference code further placed reliance upon the plethora of the correspondences with regard to the consent award mentioned supra to determine the aforesaid stated compensation. Exhibit P35 was the letter addressed to Deputy Commissioner to the Secretary Revenue Department seeking permission to pass the consent award in respect of the property situated at Channali and other 6 villages of Sinnoor Taluk, and Exhibit P36 was approval given by the Deputy Commissioner Raichur to pass consent award at the rates stated supra. Para 19, my lords. The claimants placing exclusive reliance on the consent awards in all their cases, as the different exhibits claimed the same compensation on the ground that the special land acquisition officer in his cross-examination admitted that the award of the compensation to properties acquired in Koppal Taluka for the same purpose. Though the claimants had contended that the properties have tremendous NA potential and would fetch more than 25 lakhs per acre. They sought compensation of only 15 lakhs per acre as it is granted under the consent award in respect of the acquisition of the land for the same purpose in different talukas, that is Koppal, Gangavati and Sindhunur. The reference court, placing complete reliance on the documents and without looking into the nature of lands as to whether the lands are dry lands or semi-irrigated lands or fully irrigated lands, held that the claimants lands of the claimants can be safely considered as semi-irrigated in para 16 of the impugned order, wherein the reference court held that the properties of the claimants to be semi-irrigated lands read as follows. At this stage, it is necessary to refer the award passed by the land acquisition officer, which is marked at Exhibit C4. At the time of spot inspection, the land acquisition officer noticed the properties acquired at Mamdapur village are dry lands. Though, according to the land acquisition officer, the assistant executive engineer, number 2, Canal Subdivision, Yarmas Camp, had declared as the irrigated properties, and the same is published in the official gazette on 7/12/1972. At the time of spot inspection of the LAO noticed that the properties were all tailland lands and the claimants were raising only dry crops in the said properties. Therefore, considering the situation of the properties in question, the LAO has considered the properties as dry lands and awarded the compensation. But fact remains that admittedly in the year 1972 itself, in the official gazette, the properties in questions have been declared as irrigated lands, though Tungabhadra left bank canal through. The claimant contended that they were raising 2 crops in a year, since the properties question are fully irrigated and they were raising 2 crops in a year. Insofar as the observation of the land acquisition officer that the properties in question are tailend lands and the claimants are raising dry crops, absolutely no cross-examination of RW1 on that aspect. Since the properties are irrigated through the canal, it cannot be said that either the properties in question are fully irrigated or dry land. It can safely be held that the properties are semi-irrigated properties according to the properties in question as considered as a semi-irrigated properties. The afore extracted para is only reasoning given by the reference court to hold that the lands of the claimants are semi-irrigated and to determine the market value at the rate of 8 lakhs per acre. It is pertinent to note that the irrigation department has not been examined in support of the alleged notification. The case of the claimant is that their lands are fully irrigated, hence entitled for the compensation at the rate of 15 lakhs per acre along with the statutory benefits. The reference court, if was convinced that the consent award is binding, ought to have also considered as to whether the claimants would be entitled for the statutory benefits in light of the law laid down by the apex court in case of Ranveer Singh versus State of Uttar Pradesh, reported in 2016 part 14 SEC page number 191 and 1995 part 5 SEC page number 746. Para 20 minutes. As contended by the learned counsel for the railways, the reference court has straightaway relied upon the consent awards concerning the acquisition of the lands of Koppal, Gangavati and Sindhunur Taluka, whereas the land in question are in Raichur Taluka, and has determined the market value at the same rate applicable to the properties of the claimants without appreciating any evidence with regard to the nature of the lands and without any basis. Since the issue is with regard to the method of determination of the market value, it is opposite to the refer to the judgment of the Honorable Apex Court, which is laid down in the postulates the criteria to be looked into the courts for determining the market value of the lands acquired, which law ought to be scrupulously followed by the reference court. The Honorable Court referred to 3 judgments, my lords. One is the judgment of Chinamlal Hari Govindas versus Land Acquisition Officer, my lords. Entire extract was called out, my lords. And another judgment at para 22, page number 82, my lords, was relied upon the Union of India versus Dayagal Devamma, my lords. 2018 part 8 SCC, page number 485. Now, my lords, another judgment of Manoj Kumar and others versus State of Haryana. The another judgment was referred at page number 94, my lords. 2018 part 13, SEC page number 96. And reasoning, ultimately the Honorable Court has appointed page number 100, my lords, to remit the matter.
Consent award relied on by the reference court in those matters is the same consent award
Yes.
relied on in the present case.
Yes.
So in the present case, P29.
Yes. The reference court judgment, my lords, at page number 15, my lords.
Yes.
Internal page number 50, internal page number 8, my lords, 8, 9, para number 15, my lords. I had considered these lands as a fully irrigated land and adopted the consent award and awarded 15 lakhs rupees per acre, and thereby awarded 12% additional market value and 30% solution to the
Para 15, is it?
para 15, my lords, of
Read.
the reference court judgment.
Read.
The careful perusal of Exhibit P80 notification issued by the LAO Munirabad Mehboob Nagar Railway Lines Formation Scheme Sindhunu dated 1/12/2012 goes to reveal that total 63 acres, 15 guntas of the land of Mamdapur village was acquired for the formation of railway line pertaining to the Raichur Taluka under the fore notification dated 18/6/2005, that is at Exhibit C8. And the careful perusal of Exhibit P20, the consent award passed by the SLAO of Munirabad Mehboob Nagar Railway Line dated 4/10/2012 goes to show that the fully irrigated lands were valued at 15 lakhs per acre for the payment of compensation. Since there is a consent award in this case, as per Exhibit P20, assessment of the compensation on the basis of the capitalization method or sales statistics method is not necessary, and the consent award can be taken into consideration for determining
Now
the
just tell
proper
us,
and
okay, we'll accept that. Now just tell us,
please.
you said in so far as other LACs.
Yes, my lords.
Matters remanded back.
Yes.
You have that number of that.
LACs, my lords. These are, my lords, in the tabular column, my lords, every number has been stipulated at page number 46.
No, you said in this reference court order.
Yes, ma'am.
LACs in other matters.
Yes.
Have been remanded back for
those, no, my lords. There were totally 4 LACs before the reference court which were clubbed and common evidence was led.
out of which 2 went to the first appellate court.
First appellate court.
And that has been remanded.
No, that is not yet remanded, my lords. These two, my
Still
lords,
pending,
yes. These 2 matters, my lords, were filed before this honorable court by virtue of the pecuniary jurisdiction, my lords, since it was more than 15 lakhs.
Yes.
Those, my lords, were around 10 guntas and 8 guntas of two
That is
cases.
pending
my lords.
before the
That was filed before the
District.
district court as per the pecuniary jurisdiction.
The present appeal has been filed challenging the judgment and award. Now there are 2 appeals.
Yes, my lord, 2 appeals.
MFA 202184 of 2017
Yes.
has been filed challenging the judgment and award of the reference court passed in LAC 53 of 2010, whereby the reference court has fixed the value of the compensation at rupees 15 lakhs per acre. Has fixed the enhanced the compensation at the rate of rupees 15 lakhs per acre. The order of the reference court was a common judgment and award as regards LAC 53 of 2010, LAC 52, 54 and 83 of 2010. Innond kodi. MFA number 202183 of 2017 has been filed challenging the judgment and award passed in common as regards LAC 53 of 2010, called with LAC number 52, 54, and 83 of 2010. In light of the judgment and award passed in common as regards LAC number 53 of 2010 and LAC 54 of 2010, both the appeals are taken up together and are disposed of by a common order. It is to be noticed that the beneficiary has filed the appeals and that the relevant facts made out are that the state of Karnataka had sought to acquire land of the landowners in survey number 110/2, measuring 1 acre 1 gunta, situated at Mandamus village, Taluk and district Raichur, for formation of new railway line under by virtue of notification under section 4(1) of the Land Acquisition Act 1894, and the notification passed on 18/6/2005, within bracket MFA 202184. The next, insofar as MFA 202183, the challenge relates to the judgment and award of the reference court relating to land of the landowner in survey number 138/2, measuring 2 acres, situated at Mandamus village, Raichur district and Taluk, for which was sought to be acquired for formation of new railway line by virtue of 4(1) notification referred to above. It is to be noticed that the Special Land Acquisition Officer had awarded market value of the acquired land at rupees 88,824 per acre of wetland. And this has now been enhanced to 15 lakhs per acre by virtue of order of the reference court. Learned counsel for the appellant beneficiary submits that the reference court has solely relied on the consent award at Exhibit P20 passed with respect to lands at Munirabad as regards Mehboob Nagar railway line, which consent award was passed on 4/10/2012, relating to irrigated lands valued at rupees 15 lakhs per acre. It is submitted that taking note of such consent award with respect to land in a different taluka may not be proper and would not benefit either the landowners, nor would it reflect the appropriate market value. It is further pointed out that as regards a similar contention raised with respect to lands for the same project, wherein the reference court had awarded 15 lakhs per acre as regards irrigated lands, and same was taken up before this court in MFA 20077 of 2015, connected with other matters. Coordinate bench of this court disposed of the said appeals by order dated 15th October 2020, and had noticed that mere reliance on the consent award may not be accurate after noticing several judgments of the apex court. And accordingly, it is submitted by learned counsel appearing for the appellant beneficiary that in light of the said appeals having been disposed of by setting aside orders of the reference court, taking note of an identical legal contention and remanding the matter back for fresh consideration in light of the directions made therein. The present appeals may also be disposed of on same grounds. Full stop. It is to be noticed that the landowner, though served, has remained absent. Full stop. Peruse the order passed in MFA 20077 of 2015. Point for consideration is as follows. Whether case is made out to set aside the order of the reference court and to remand the matter back for fresh consideration in light of the order passed in MFA 20077 of 2015 and connected matters. We'll stop next. It is a perusal of the order of the reference court would indicate that the reference court has relied on the order passed, relied on the consent award passed by the Special Land Acquisition Officer of Munirabad as regards Mehboob Nagar Railway Line, which consent award was passed on 4/10/2012. The said consent award has been marked before the trial court at Exhibit P20. A perusal of the order of the reference court would clearly indicate that the fixation of market value was solely on the basis of the award of the consent award passed by the LAO of Munirabad. It is admittedly the position that Exhibit P20 relates to lands pertaining to which taluka?
Mamdapur village. Mamdapur village.
No, those that consent award.
Consent award, my lords, with regard to the Mehboob Nagar, my lords.
That is different taluka.
Yes, my lords, different taluka.
Raichur, is it?
Yes, my lords. Correct. Same district, my lords.
In between. Pertaining to Koppal and Raichur taluka.
Yes, my lords. Koppal and Raichur taluka.
Koppal and Raichur taluka. While the present case relates to lands of Mamdapur village, though in respect of Raichur taluka. The reference court, adu Koppal anta biri. Adu Koppal anta. P20 relates to lands in Koppal taluka. It is to be noticed that the reference court has, taken note of such fact, has observed that the Koppal taluk and Raichur taluk are adjoining to each other, having irrigation facility, and they can be treated at par with each other, and proceeded to pass a award relying on the consent award. This aspect has been noticed by the coordinate bench, division bench in MFA 20077 of 2015, and has opined that the market value of each land will have to be assessed differently depending on the material on record, and mere reliance on consent award may not be appropriate. The relevant extracts of the judgment in MFA from paragraph
16.
16 till end.
Yes, my lords. Because several judgments were referred by this honorable court.
16 till end.
Yes, my lords.
Are as follows. Next. It must be noticed that the coordinate bench has clearly observed, after referring to judgments of the Supreme Court, that reference court placing blind reliance on consent award without considering facts and evidence in the cases before it was erroneous. Full stop. The coordinate bench has also observed that the impugned orders show that the market value has been determined without taking note of the principles laid down in section 23 of the Act of 1894 and disposed of the appeals by setting aside order of the reference court. Full stop. Next, in the present case also, a detailed perusal of the award of the reference court would indicate that the clinching point taken note for consideration is the amount fixed in the consent award. Full stop. Admittedly, as the consent award relates to land at Koppal Taluk, while in the present case, the lands in Mamdapur fall within Raichur district.
Please.
The mere reliance solely on consent award as observed by the coordinate bench would not be sufficient. Full stop. Matter requires consideration by taking note of observations made by the coordinate bench in MFA so and so. Full stop. Accordingly, we find that accordingly approach of the reference court cannot be accepted and the market value of land will have to be assessed independently, looking into the evidence on record let in by the claimant, taking note of the principles to be kept in mind as held by the coordinate bench. Accordingly, the judgment and award of the reference court is set aside and matter is remitted for fresh consideration to the reference court, which is to dispose of the reference, taking note of observations made by the coordinate bench in MFA number so and so.
Yes. There is one judgment of Honorable Apex Court, my lords, 2022, my lords, Special Land Acquisition Officer versus N. Savita, my lords, wherein the same point was considered by the Honorable Apex Court, my lords. I have given the judgment, my lords.
What does it say?
My lords, may I be permitted to read the content of the motion?
Yes.
A consent award cannot be the basis to award or to determine the compensation in other acquisition, and more particularly when there are other evidences on record. In case of a consent award, one is required to consider the circumstances under which the consent award was passed and the parties agreed to accept the compensation at a particular date. It is given in the given case due to the urgent requirement, the acquisition body and on the beneficiary of the acquisition may agree to give particular compensation. It was specifically observed, my lords.
Yes, that
by
one
Honorable
paragraph I learned.
Yes, my lords.
So then since they've given let evidence
Yes.
P1 to P50.
Yes, sir.
So the court ought not to have ignored such evidence. The reliance on the judgment in so and so is also requires consideration, as the apex court has observed that reliance on order of on a consent award without taking note of other evidence let in by the claimant requires to be taken note of. So no note asterisk against. Yes.
Please, oblige.
Yes.
Connected appeal, my lords, there is delay of 266 days in filing the appeal, my lords. That has to be.
IA for condonation of delay in MFA 1 of 24 is allowed accepting cause shown. Cause shown. Yes. Huh? Yeah. ಅಲ್ಲ ಅದಕ್ಕೆ ಅವನು ಇಲ್ಲ ಅದಕ್ಕೆ ನೋಟಿಸ್ ಹೋಗಿ ಎಸ್
Oblige.
prosecution case is that, my lord, on 22/9/2019, 19, my lord, or the, all of the PW6, my lord, who is the victim girl, or the informs their mother, my lord, that because of stomach pain, my lord, or in the morning, my lord, she was admitted to the hospital, my lord. At about 8 AM, my lord, she gives, she delivers a female child. Or there is a delay of 10 months, my lord, in lodging the complaint, my lord. Nowhere, my lord, it is explained with regard to the delay. The father, my lord, in his in his evidence, my lord, says that, my lord, because of, my lord, having hot food in the school, ಅದು ಹೊಟ್ಟೆ ಉಬ್ಬಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. Till 10 months, my lord, they did not file any complaint. Even that he has admitted in his cross examination. And even the PW4, who is the headmaster of the school, my lord, has produced exhibit P6, my lord.
About DNA?
Yeah, exhibit P3.
DNA profile.
Matched. Pardon me.
Matching.
DNA is positive. But all these witnesses, PW6, victim girl, PW8, father of the victim girl, PW9 is the scribe of a complaint, my lord, and PW10. All these witnesses have subsequently turned hostile. They say, my lord, in the subsequent cross examination, my lord, because of compromise, my lord, they have.
What is your stand?
Pardon me.
Legally, what is your stand now?
Milords, my stand would be that previously, now, Milords, to be honest, Milords, during the pendency, I'm married, and now I have 2 children. All these facts have not been disclosed to my husband. I'm now peacefully living with my husband, Milords, in Kalmal village of Raichur. Since this notice, Milords, I am pursuant to this notice, I have appeared. Initially, Milords, no doubt, I have supported the case of the prosecution.
The entire medical evidence, medical documents, my lord, age is shown as more than 18 years, my lord. Your lordship kindly appreciate these.
What has happened to the child, first child?
First, it is no more, my lord. You know, because of some edako, death agide anta ಹೇಳಿ.
My lord.
And no, my lord.
How long you are in custody?
But since 2019, my lord, now for the last, my lord, 5 years, 3 months, 9 days, my lord, as on.
Judgment is there, no, Mr. Legally, that
Even during pendency, my lord, Kashmira Singh's case.
Justice Kaji Madam ಅವರು rely ಆಗಿರ್ತಾರೆ. Then rely ಆಗಿರ್ತಾರೆ.
ಅವಾಗ ಕೊಟ್ಟಲ್ಲ judgment.
ಆಮೇಲೆ ಕಾಜಿ ಮೇಡಮ್ ಅವರು ಜಸ್ಟಿಸ್ ಕಾಜಿ ಮೇಡಮ್ ಅವರು ಬರ್ದಿದ್ದಾರೆ ನೋಡಿ, ಒಂದು ಕಾಂಪ್ರಮೈಸ್ ಆದ್ರೆ ಎಲ್ಲಿದೆ ಜಜ್ಮೆಂಟ್?
ಕೊಡಿ ಅದ್ಯಾವ್ದು?
It's a single bench judgment, my lord.
Kodi.
Justice Kunna has passed, so
Huh?
it's not binding in the division
Kodi.
bench, my lord,
Kodi.
because of that.
Yeah,
Even all the witnesses have turned hostile, they have not supported the case of the prosecution. Then also, the only DNA has been matched in
My lord,
this case also.
in identical.
I'm submitting.
I am
I'm
sorry.
submitting.
I'm sorry.
After that, to submit. And even, my lords,
We are only wondering about the first child.
Yes, after it was dead, Milords, from the mortal remains itself, DNA was examined.
Yes.
Immediately died, is it?
Yes, ma'am.
ಇಲ್ಲ ಇಮಿಡಿಯೇಟ್ಲಿ ಇಲ್ಲ, ಇಮಿಡಿಯೇಟ್ ಏನಿಲ್ಲ, ಒಂದು 2 years ಆದ್ಮೇಲೆ.
2 years ಆದ್ಮೇಲೆ.
ಈಗ ಫಾರ್ ದ ಲಾಸ್ಟ್ 3 years ಬಿಫೋರ್ ತೀರ್ಕೊಂಡಿದ್ದಾರೆ.
Immediately ಸತ್ತದ್ದು.
also, my lords, the
identical
initially
situation.
they have supported the case of the prosecution. And it has come in the judgment also, my lords. Now Raji ಆಗಿದ್ದೇವೆ.
No, the defense has got exhibit.
Able to bring her here to get her before the court.
Yes, ma'am.
Then
We'll see, only for, we just want to, we have not made up our mind. But let us,
I'll ask because father has contacted me. I'll ask the father to come, Lords, because she's married and with the now notice being sent to her, it should not jeopardize her marriage. So I'll keep the father present. The court is agreeable. Because mother is dead, Lords. Mother is dead, Lord, so I'll keep the father present.
anyhow, we have to decide on merits.
Yes.
There's no question of taking note of any settlement as. We'll decide on merits, we may, by the way, make some observations.
just inquire with their father, should not prejudice our marital life.
Yes, ma'am.
That is a very important aspect. Yes. If she only able to come here, then
Yes, ma'am. I'll inquire with the father and if without much thing, yes, ma'am. I now know the mind of the court. I'll try to.
No, but some lurking doubt I have. I want to know how the child died.
Yes, ma'am. I'll.
Truth is different matter, just for my satisfaction.
Yes, ma'am. Yes. Yes. I'll inquire that and make mine.
And defense has got marked exhibit D1 and D2, my lord. The learned session judge has not considered, no discussion at all. So far as exhibit D1 is the outpatient record, my lord. It has come in the evidence of PW 12. And exhibit D2 is the patient hospital register form, my lord. But it has come in the evidence of PW 12 itself. PW 12, my lord, who is the doctor, my lord, who is a pediatrician.
Regarding what is that? That evidence relates
relates to age of the victim girl.
victim.
Major antide, more than 18 years. All the medical documents.
No, but what about the birth certificate?
Pardon?
Birth certificate?
School certificate.
School certificate.
No, exhibit P3 is the
Last.
First standard to ninth standard, where she has studied.
birth certificate issued by the headmaster of the school.
Definitely, man.
He has admitted that the parents of the victim girl were illiterates. Even they do not know the exact date of birth of the.
What does the rule say? Which are the three documents?
Three documents, Lord. I have reiterated in paragraph, Lord.
Paragraph?
Uh, 12, Lord. As held in various decisions by the Honorable Apex Court, the document produced, that is birth certificate, is not what section 94(2)(1) mandates, nor it is in accordance with section 94(2)(2) because the entire medical records of PW 6. But I'm sorry, my lord.
So what are those three documents? Whether this falls within those three documents?
One is matriculation.
One.
As per section 94 of Juvenile Justice Act, first is matriculation or school certificate.
Who is?
School certificate. The matriculation and school certificate are in the same category. And in absence thereof, birth certificate issued by any corporation, municipality or Gram Panchayat. In absence of 1 and 2, third category would be medical examination of the victim.
Correct. So here, does it fall within, what is the document relied on? Does it fall within those?
That is, Baralanta, that is what, my lord, division bench of this honorable court.
According to you, it doesn't come.
Division bench, my lord, of this honorable court held that, my lord.
What is the age as per the certificate? What is the age as per the? What is the age
14,
as per the
14.
certificate?
15 ಅಂತ ಬರುತ್ತೆ.
14 years in chief examination, she stated 15. At the time of offense, 14 ಅಂತಿದೆ.
Para 19, 20 and 21 more. This on the I'm sorry.
Matriculation certificate or equivalent? Equivalent.
The birth certificate issued by the school authorities is not a conclusive proof ಅಂತ that is what not this honorable court, division bench of this honorable court has said.
ಎಷ್ಟು ಮಾರ್ಜಿನ್ ಕೊಡ್ಬೋದು? What is the margin?
Pardon.
ಮಾರ್ಜಿನ್ ಎಷ್ಟು ಕೊಡ್ಬೋದು?
ಅಲ್ಲ marginal that is not a conclusive proof ಅಂತ that birth certificate.
1 year
For
margin.
2 years ಅಷ್ಟೇ margin. If that is the case, 2 years margin can be extended. That is the law.
ಅಲ್ಲ even the father of the victim girl itself, he has admitted.
You are relying which document? Exhibit D1 and D2. What is those?
Not the
What are-
exhibit D1 and D2 are the outpatient, my lord, exhibit D1.
Under the JJ Act, Lagli.
Yes.
You argued in that other
Yes,
matter.
section 94.
No, correct. The rules, which rules?
94.
Rules.
Sir, in that case,
12,
my lord,
12,
it was
Rule 12.
the Juvenile Justice Act of 2007.
Correct.
Under that, my lords, there were different categories. The rules were there, and under that, my lords, the
No, so now in the present case, suppose it's after 2015.
yes, ma'am.
What are the rules in force?
2015 Juvenile Justice Act rules will apply, ma'am.
Now the 2015 rules in section 94
94.
are in consonance.
Yes.
Presumption and determination of age.
So date of birth certificate from school.
Yes.
That is not there here.
That is
There.
there.
Is there.
That is there, madam.
Then you are.
ಇಲ್ಲ birth certificate issued by the headmaster on the basis of what the
Instruction.
register ಅಂತಿದೆ.
Then
But registry is not produced before the court. And first attended, my lord, the birth certificate issued by the authority or the first attended school, it is not produced before the court.
What is exhibit B3?
Exhibit
B3.
birth certificate issued by the headmaster of the school, my lord.
Age confirmation.
ಏಜ್ ಕನ್ಫರ್ಮೇಶನ್ ಅಷ್ಟೇ. ಅದನ್ನೇ ಡಿಸ್ಬಿಲೀವ್ ಮಾಡಿದ್ದಾರೆ. This honorable court has disbelieved in several cases, my lord.
No, this relates
That
to
is
the
true.
old rule. This case judgment you are giving, please, relates to the old rules. If you, no, Mr. Yelli, just have a look. You have to look at the rules under the new, after the amended act, whether there are rules. Now, the rules referred to by the division bench in that case relate to old rules. You have a look at it, apply or mind.
ಇಲ್ಲ, ಬರಲ್ಲ. That's what my.
Have a look at it. That's under the old rules. You get ready. But the judgment of the division bench refers to the 2013 case, where the rules were different. Now you look at the latest rules and section 94 and you come back. And then you make out your case on that. Now we may keep in mind the subsequent events, but that cannot be taken note of for the purpose of giving you relief. Relief, you have to succeed on merits. So you make out your case on merits. But this age one, you just have a look at the new rules. Have a look. You just point out.
Yes, ma'am. I'll.
Or if in case of any settlement, is it possible to close it? Have a look at it.
That is what, my lord, the close ಆಗಿದೆ almost, that is, they have turned hostile.
No, no. Now you show us, we'll take note of merits. On the ground of settlement, Supreme Court under 142 has done it.
ಮಾಡಿದ್ದಾರೆ.
Has done it.
There are several
So
cases.
if there are any coordinate bench judgments, you do your research, show, let us have a look. at it.
Coordinate single bench judgments ಇದೆ. Almost maximum cases are quashed on this ground itself.
ಅಲ್ಲ, ಅದು 482.
482 ನಲ್ಲಿ.
ಇದೆ ಎಲ್ಲಿದೆ? ನಾವು ಹೋಗಿ ಹುಡುಕ್ಬೇಕಾ ಅಲ್ಲ ನೀವೇನ ತರ್ತೀರಾ?
ಇಲ್ಲ ತರ್ತೀನಿ.
ಮತ್ತೆ ಅದು
ಇಲ್ಲ I'll produce.
ಎಲ್ಲಿದೆ judgment?
Not the
ಜಜ್ಮೆಂಟ್ ಇದೆ ವಿಜಯನ್ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಕೇರಳ 6 months ಅದನ್ನ ತನ್ನಿ.
Vijayan.
ಜಜ್ಮೆಂಟ್ ತನ್ನಿ. ಯಾವ್ದು ನೀವು ಮಾಡಲ್ಲ ನೀವು ನಮ್ಗೆ ಹೇಳಿ.
On merits, you make out a case, we look into it, you come prepared, we'll give a date. Meanwhile, you bring the father, you keep the father. present.
Yes, ma'am. Yes, ma'am.
The only difficulty here we are facing is the DNA test. Now you don't need any other thing except that. Isn't it? So how do you overcome the obstacle, apply our mind, and then you place something on record? Let us see. Now the DNA test, how you are going to get over it?
My submission.
Yes.
May I submit?
Yes.
But when all the witnesses have turned hostile, my lord, the uncorroborated DNA test, my lord, there cannot be any conviction on the basis of DNA profile test. That is what, my lord, this honorable court has held in several
Tanni,
cases.
ಅದನ್ನ ತನ್ನಿ ನೋಡೋಣ.
Nagapa's case ಅಂತಂದು.
And even in their second recalled, when they have been recalled before the trial court, they have categorically stated that melons Raji ಮಾಡಿಕೊಂಡಿದ್ದೇವೆ. Is it admission in the IF law? When they'll come under section
judge.
191 to 193.
Single judge
Perjury
bench
matters.
bench ಇದೆ.
That settlement is only arbiter. That may only be used to give some benefit, but on the merits you'll have to make out.
Yes.
Which you have to look into.
It's also there, they are supported in the first instance, in verbatim. And in the cross examination, they haven't given any this thing, my lords.
Which
And
is
other
the
side has
judgment?
not elicited anything. for,
2020 part 3, my lord, KCCR 1704, single judge bench. Based on this judgment, my lord, division bench, my lord, in another case, my lord has accepted, my lord, division bench, my lord, in the case of criminal appeal number 100504 of 2021.
Place it on record, let us.
Only suspension of sentence. I
So
just.
get ready on the merits. Get ready on the merits.
Ready on.
Fix a date. Now, but for this case, we can't upturn the law regarding the DNA test. So you have to be a little careful, isn't it, when we make a, because it should not prejudice any other case.
Yeah, of course.
So you make out your case on merits regarding age. And now just see, if it's 14 years, consent goes away. That becomes dangerous if age is established. So you just apply your mind to age 1, and then how you are going to get across the DNA test. Yes. These are the main two things that appear prima facie against you. You see how you are going to get across, get over this, come ready, we'll fix a date.
I'll keep the father. Yes, sir.
Relist on.
1 week.
2 weeks.
Yeah, date. 30th.
Yes.
So get ready on the merits.
Final hearing.
Now you make out a case on merits. For your benefit. Yes.
Lords, one kind submission, Lords. Serial number 7, my lords. In view of remand, my lords, the court fee may be refunded, my lords.
63.
Serial number 7, my lords.
Okay, section 63(2).
Yes, my lords.
Huh?
Yes, my lords.
Refund of court fee.
Yes.
In light of section 63(2).
2, my lords.
You just mark paragraphs of that and give it.
Please.
The judge, some kavita.
Yes, my lords.
No, refund under which section?
Provision, my lords. I'll quote this section, my lords.
File a memo.
Please, my lords.
File a memo.
I'll file a memo to that effect, my lords.
You file a memo.
Please, my lords.
Somebody refund dash and thank you.
Para 5 and 6.
Para?
Para 5.
Correct. Consent award can never be the basis.
Yes, my lords. Because the circumstances would be completely different, my lords.
No,
in
by
each and-
consent, no.
Yes.
So there's no adjudication on it.
Yes.
Yes, we'll take note.
Please. Obligement. I'll submit a memo, my lords.
Yes. Yes.
ನೋಟಿಸ್ ಕೊಟ್ಟದ್ದು ಇದರಲ್ಲಿ ನೋಟಿಸ್ ಅರುಡ ಕೊಟ್ಟಿಯಲ್ಲ ನೋಟಿಸ್ ಅರುಡ ನೋಟಿಸ್ ಅರುಡ ಏಟಕ್ಕಿಲ್ಲ ಬರಬೇಕು ಇಲ್ಲ ವಾರಂಟ್ ಕೊಡ್ಬೋದು ಕರೆದು ಮೇಡಮ್ ಕೊಟ್ಟಿಯಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ 40ದಲ್ಲಿ office notice reveals that the notice to respondent is served and is unrepresented. Hence, issue bailable warrant against the accused for a sum of rupees 25,000. Returnable by 3 to 25. ಅಷ್ಟೇ ಕಾಲ ಇದು ಮಾಡೋದಿದ್ರೆ ನಾಲ್ಕಿದೆ ಅಂತೆ ಇದು ವಾಟ್ ಇಸ್ 39 ಒಮ್ಮೆ ಕೇಳಿವರಲ್ಲಿ ಎಸ್ ಎಸ್ ಪಿ ಪಿ ವಾಟ್ ಇಸ್ ಇಟ್ 39 ವಾಟ್ ಇಸ್ ದ ಅಫೆನ್ಸ್ ನೋಡಿದಿರಿ
ನೋಡಿಲ್ಲ ಸರ್ ಓನ್ಲಿ ದೀಸ್ 4 appeals connected.
ಸಂಜಯ್ ರೆಡಿ ಇದ್ದೀರಿ
Yes.
I prefer appellants in my lords 38.2. So for accused number 1 and 3 is concerned, my lords.
For appearing 38.2,
Yes, my lord. Criminal appeal number 200173, accused number 193,
A1 and A2.
193, my lord.
1 and 3,
Yes, my lord. Criminal appeal number 200062 of 17 is related
First
to,
in the one 38 ಅಲ್ಲಿ ಯಾರು 200169 of 17
that is my colleague.
Sheikh Sood
Yes, he is also.
A1
A2, my lord. A2.
A2.
Yes, my lord.
Next 200062
That is A5. A5.
A5 only.
5. A5. Yes.
2072. Yes. A4.
A4.
So A1 1 to 5
Yes.
1 to 5. Only 5 accused, right?
Only 5 accused.
All are convicted for 302.
All are convicted for life penalty. 302.
Yes. So Sanjay has to argue A1.
Yes, ma'am. A1 and 3 minutes.
A1 and 3 he is appearing.
Yes.
1 and 3.
Both the, this is a synopsis, my lord.
Yes, yes. Synopsis. Good.
ಯಾವಾಗ್ಲೂ ಗ್ರೂಪ್ ನಲ್ಲಿ ಎಲ್ಲರೂ ಹಿಂದೆ ಇರ್ತಾರೆ. ಅವ್ರು ಮಾಡ್ಲಿ.
Sanjay is not like that. Sanjay is not like that. He comes forward always.
In fact, I sought permission from the senior colleagues. They say.
Not like that.
Main contention is based, we are attacking on the pre-investigation. Investigation is made such a way that trimming the lapses on the part of the component and creating a story. That which point I want to address the board on that. So I want to know their because each one of them has their own counsel in the trial court also.
Lords, the case of the prosecution is, my lords, with a history that, my lords, there is a civil dispute among the parties. That is the reasons, my lord, in fact, the one part of his, my lord, the one common ancestors was, my lords, Hanumanta, my lord. He is a grandfather of, my lords, this deceased. My lords, he had, one of 2 wives.
No, just a minute, Sanjay.
Please.
Come to the charge. What is the charge for?
That is, my lords, 302. 302.
Only the page number?
2, my lords. My synopsis, lord, can you see?
No, in paper.
143, 147, 148, 120B, 307, 302, 201. Read with 149 minutes.
Accused convicted for all the offense? All the offenses?
Yes, yes, all of them convicted for the same.
So major
life.
sentence life,
Life, major
for 302.
302.
Yes. Now come to complaint. Let us read the complaint.
Please.
Exhibit to P1,
Yes, my lords.
Yes.
Page 5, my lords, of paper book.
ಅದೇ ಗಿರೀಶ್ ಪಾಟೀಲ್ ಅಂತ ದಿನ ಅಪೇರ್ ಆಗ್ತಲ್ಲ. ಕರೆಕ್ಟ್. ಅವ್ರ ನಂಬರ್ ಇದ್ರೆ ಫೋನ್ ಮಾಡಿ ಆಫ್ನಲ್ಲಿ ಅಂತ ಹೇಳಿ ಈಗ ಅವ್ನು ಟಿಕೆಟ್ ಬುಕ್ ಮಾಡ್ಕೊಂಡು ಬಂದ್ಬಿಟ್ಟಿದ್ರೆ ಪ್ರಾಣ ಇಂದ್ರೆ ಮುಂಚೆನೆ ಹೇಳ್ಬೇಕು. ಸೊ ದಟ್ ಕ್ಯಾನ್ ಬಿ ಅವಾಯ್ಡ್. ಅವ್ರ ನಂಬರ್ ತಗೊಂಡು ಫೋನ್ ಮಾಡಿಬಿಟ್ಟು until this gets over, it will not. You may have to come on a different date. So you please follow. That matter every day is putting his appearance. ಬುಧವಾರ ಬಂದ್ಬಿಟ್ಟು
Already
matter ತಗೊಳ್ಳಿ ಅಂತ.
Yes, my lords.
May I read, my lords?
Yes.
Page 5 of paper book, my lords. That is exhibit P1. Nanu Tammanna is a PW1, my lords. Tande Basappa Dalwai Jati Hindu Kurubara ವಯಸ್ಸು ಸೊ ಅಂಡ್ ಸೊ ಮಿಲಾಟ್ಸ್, ಬರೆದು ಕೊಡುವ ಫಿರ್ಯಾದಿ ತಾರೀಕು 7/1/2014. ನನ್ನ ಖುದ್ದು ಊರು ಗುಣದಾಳ ಗ್ರಾಮ ಇದ್ದು ಅಲ್ಲಿ ನನ್ನ ಹೊಲ ಮನೆಗಳಿದ್ದು ಮನೆಯಲ್ಲಿ ನಾನು ನನ್ನ ಅಣ್ಣ ಅಮರ್ಸಿದ್ದ, ತಂದೆ ಬಸಪ್ಪ ಸೈದಪ್ಪ ದಳವಾಯಿ ವಯಸ್ಸು 52 ವರ್ಷ, ತಾಯಿ ರಂಗವ್ವ ವಯಸ್ಸು 48 ವರ್ಷ ಈ ಪ್ರಕಾರ ಕೂಡಿ ವಾಸವಾಗಿದ್ದು ನಾನು ಬಿಜಾಪುರದಲ್ಲಿ ನೌಕರಿ ಮಾಡುತ್ತಿದ್ದೇನೆ. ನನ್ನ ತಾಯಿಯ ತವರು ಮನೆ ಸತಗುಂದಿ ಗ್ರಾಮ ಇದ್ದು ನನ್ನ ತಾಯಿಯ ತಂದೆಯಾದ ಹನುಮಂತ್ ಕುಮಟಗಿ ಇವನಿಗೆ ಮೊದಲು ಕಂಬಗಿ ಗ್ರಾಮದ ನಾಗವ್ವ ಇವಳೊಂದಿಗೆ ಲಗ್ನವಾಗಿದ್ದು ಅವಳಿಗೆ 2 ಹೆಣ್ಣು ಮಕ್ಕಳು, ಅಂದರೆ ನನ್ನ ತಾಯಿ ರಂಗವ್ವ, ಶಿ ಈಸ್ ಆಲ್ಸೋ ಡಿಸೀಸ್ ಮದರ್ಸ್, ನಮ್ಮ ದೊಡ್ಡಮ್ಮ ಭೀಮವ್ವ ಈ ಪ್ರಕಾರ ಇದ್ದು ನಮ್ಮ ತಾಯಿ ನಾಗವ್ವ ಇವಳಿಗೆ ಆಕೆಯ ತವರು ಮನೆಯಿಂದ 9 ಎಕರೆ ಆಸ್ತಿ ಬಂದಿದ್ದು ಇರುತ್ತದೆ. ನಂತರ ನಮ್ಮ ತಾಯಿ ನಾಗವ್ವ ತೀರಿಕೊಂಡಿದ್ದು ನಮ್ಮ ಮುತ್ಯ ಕಬುಳ್ಗಿ ಗ್ರಾಮದ ನಾಗವ್ವ ಅನ್ನೋವಳಿಗೆ 2ನೇ ಮದುವೆ ಆಗಿದ್ದು ಅವಳಿಗೆ ಮಾಳಪ್ಪ A1, ಪರಮಾನಂದ A2, ಮುರಪ್ಪ A3, ಕರೆಪ್ಪ ಈ ಪ್ರಕಾರ 4 ಮಂದಿ ಗಂಡು ಮಕ್ಕಳು ಇರ್ತಾರೆ. ನಮ್ಮ ಆಯಿಯ 9 ಎಕರೆ ಆಸ್ತಿಯಲ್ಲಿ ನಮ್ಮ ತಾಯಿ ಮತ್ತು ದೊಡ್ಡಮ್ಮ ಭೀಮವ್ವ ಇವರಿಗೆ ಸಮಪಾಲು ಆಸ್ತಿ ಬಂದಿದ್ದು ಇರುತ್ತದೆ. ಈ ಆಸ್ತಿಯಲ್ಲಿ ತಮಗೂ ಪಾಲು ಬರ್ಬೇಕೆಂದು ನಮ್ಮ ಮುತ್ಯಾನ 2ನೇ ಹೆಂಡತಿಯ ಮಕ್ಕಳಾದ ಮಾಳಪ್ಪ, ಪರಮಾನಂದ್, ಮುರಪ್ಪ, ಕರೆಪ್ಪ ಇವರು ತಕರಾರು ಮಾಡುತ್ತಾ ಬಂದಿದ್ದು ಈ ಬಗ್ಗೆ ಕೋರ್ಟ್ನಲ್ಲಿ ನ್ಯಾಯ ಆಗಿ ಅದು ನಮ್ಮಂತೆ ಆಗಿರುತ್ತದೆ.
ಮಕ್ಕಳಾದ ಯಾರು? ಹನುಮಂತ ಕಮಟಗಿ.
Yes, my lords. Yes, my lords. He is a common, I mean, the
Hನುಮಂತ
ancestor.
ಕಮಟಗಿ is the husband of
No, he is a father of deceased Rangava.
father of deceased Rangava.
Yes, my lords.
Yes.
Both wives' names are same. Nagava antide. First wife daughters are this deceased Rangava. one kattige.
Ah.
Then
Next,
MO 18,
rod,
iron rod, my lords, and one shirt, MO3,
belongs to E4,
A4,
same PW4 and CW8.
8. That is also exhibit P15.
Ah,
Place also same. My lords.
Now 1, 4, 3, I to 2. No recovery from 2,
Except the first vehicle cruiser jeep, no recover.
3,
Correct.
4. So 2 and
5,
no recovery from 2 and 5.
5,
Except Jeep.
except jeep.
Yes. Portion of voluntary statement ಬರ್ದಿದ್ದೀರಾ ಇವ್ರದ್ದು
Yeah.
1 to 5 ಬರ್ದಿರಾ 8 ಬರ್ದಿರಲ್ವಾ?
Yes.
As per 28 voluntary
Yes.
statement. Yes. Next.
The evidence,
After this recovery,
my lords,
this is all the recovery.
all recovered. That's it.
This is all the recovery.
Yes.
Yes.
One cloth seizure Panchanam also held, that is the deceased cloths, my lords.
Yes, yes.
That is exhibit P11 and 12.
Deceased cloth.
Yes. CW not, CW3.
Exhibit
Exhibit P11 and 12, my lords.
P11 and 12.
Yes, my lords.
Pant and shirt,
Pant and shirt, my lords.
Ah.
Dhoti,
Yes. MO ಎಷ್ಟು ಅದು ಗೊತ್ತಾ?
MO, my lords,
7 to 9. What about this is in 2?
7, 8,
6-2
and
is
9.
sorry, one,
3 to 9.
3 to 6 that of Basappa, 7 to 9 that of Rangava.
MO
7 to 9 D2 ದು 3 to 6 D1 ಅದು.
yes, ma'am. Then 7 to 9.
Under Mahazar ಇದೆಯಾ ಇದು exhibit?
Yes, my lords. Exhibit P11 and 12.
P11 and 12.
Yes, my lords.
P11 D1 ದು P12 D2 ದು.
Yes, my lords.
Yes. Whether these items were sent for FSL?
Yes.
Yes.
Human bloods and
Group.
O group, all the items.
All the items.
Yes, except one.
Including the dress of this accused.
Yes.
The
Both.
dress of accused and the deceased
Deceased.
found with stained with the
Human blood.
Human blood. O
and
group.
O group.
There is no blood grouping of the samples
Disease.
taken from
Any
that
blood drawn by the body, nothing.
Nothing. There is no matching from the disease.
There is no such serology report of these accused. Matching the blood stain. Nor they have taken the sample of blood, the accused samples, blood sample. Tally with that.
Accused blood sample O group.
ಇಲ್ಲ ತಗೊಂಡಿಲ್ಲ.
ತಗೊಂಡಿಲ್ಲ ಅದೇ ತಗೊಂಡಿಲ್ಲ.
Neither disease ತಗೊಂಡಿಲ್ಲ ಇವ್ರದ್ದು
That
ತಗೊಂಡಿಲ್ಲ.
seized items are human blood. That of O group.
O group. That's it.
And that
First to
of
be of deceased ಅಂತ.
dead body.
Two dead.
There can be, apart from one injured, is a eyewitness, child witness is also injured, bleeding injuries and etc. So whose blood is out the three found on these items is again.
There is no such law laid down by the Honorable Apex Court. Blood sampling, blood has to draw from the dead body of the deceased.
Dead body, dead body ಅಲ್ಲ.
ಎಲ್ಲಿಂದಂತ ಈಗ ಅದು ಡಿಸೀಸ್ಡ್ ಅಂತ ಹೇಳಿದ್ರೆ ಡೆಡ್ ಬಾಡಿ ಆಫ್ ದ ಡಿಸೀಸ್ಡ್ ಇಂದ ತೆಗಿಬೇಕಲ್ಲ ಇವ್ರದ್ದು ಬ್ಲಡ್ ಅಲ್ಲ
ಹೌದು ಹೌದು ಇವ್ರ ಬ್ಲಡ್
ದಟ್ ಮಸ್ಟ್ ಬಿ ಡಿಸೀಸ್ಡ್ ಅಲ್ಲ
It is different from that of the accused. That is a very, very positive incriminating material as per the prosecution case. And unless they satisfactorily prove that it is a blood, that is blood stains that are found on the items, that is blood clothes of the deceased, blood clothes, or for that matter, any of the weapons, blood stains are there. If they found to be tallying with the blood stains found on the clothes of the accused. They must establish that that is the blood stains of the deceased or the injured. If that is not there, then definitely it is a cannot.
Supreme Court in one case, Supreme Court said the blood sample found in the clothes and the weapons, if it is in human blood of such and such group, that can be considered as a corroborative piece of evidence. Corroborative piece of evidence. Even there is no sampling of even the blood not drawn from the either from the dead body of the deceased or the maybe a corroborative piece of evidence.
Yes, some.
Yes. Let us see. That we will examine later. Yes.
Only first they have to establish.
Yes.
Statement and
Yes,
taking
yes,
them to
yes.
particular space.
And this
and do it.
particular witness who is stood pancha to all these majors, my lords, he is a close relative of the deceased. Because he is.
Now, this is all the investigation now.
Yes, ma'am.
This is all the investigation.
Please.
Now come to the evidence.
Yes,
Let
ma'am.
us see the evidence.
Page 157, my lords, evidence of PW1, Tammana, my lords.
PW?
1, my lords, page 157. Is a complaint and the son of the deceased. May I read, my lord?
Yes.
ನಾನು ಗುಣದಾಳ ಗ್ರಾಮದಲ್ಲಿ ಇರುತ್ತೇನೆ. ಗುಣದಾಳ ಗ್ರಾಮದಲ್ಲಿ ಇರುವ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ನಾನು, ನನ್ನ ಅಣ್ಣ ಅಮರ್ಸಿದ್ದ, ನಮ್ಮ ತಂದೆ ಬಸಪ್ಪ ಮತ್ತು ತಾಯಿ ರಂಗವ್ವ ಇವರೊಂದಿಗೆ ಕೂಡಿ ವಾಸಿಸುತ್ತಿದ್ದೆವು. ನಮ್ಮ ತಾಯಿ ರಂಗವಳ ತವರು ಮನೆ ಸತಗುಂಡಿ ಗ್ರಾಮದಲ್ಲಿ ಇದೆ. ನಮ್ಮ ತಾಯಿಯ ತಂದೆ ಹೆಸರು ಹನುಮಂತ ಕಮಟಗಿ ಎಂದು ಇದೆ. ನಮ್ಮ ತಾಯಿ ರಂಗವಳ ತಾಯಿಯ ಹೆಸರು ನಾಗವ್ವ. ನಮ್ಮ ತಾಯಿ ನಾಗವಳಿಗೆ 1, ನಮ್ಮ ತಾಯಿ ರಂಗವ್ವ 2, ಭೀಮವ್ವ ಮಾತ್ರ 2 ಹೆಣ್ಣು ಮಕ್ಕಳು. ನಮ್ಮ ತಾಯಿಯ ತಾಯಿ ನಾಗವಳಿಗೆ ಕಂಬಾವಿ ಗ್ರಾಮದಲ್ಲಿ 9 ಎಕರೆ ಜಮೀನು ಇದೆ. ನಮ್ಮ ತಾಯಿ ರಂಗವ್ವ ಮತ್ತು ಆಕೆಯ ಸಹೋದರಿ ಭೀಮವ್ವ ಚಿಕ್ಕವರಿದ್ದಾಗ ನಾಗವ್ವ ಮೃತವರಾಗಿದ್ದಾಳೆ. ನಮ್ಮ ತಾಯಿಯ ತಾಯಿ ನಾಗವ್ವ ಮೃತಳಾದ ನಂತರ ನಾಗವಳ ಗಂಡ ಹನುಮಂತ ಕುಮಟಗಿ ಇವರು ಕಲ್ಲುಬೆಳಗಿ ಗ್ರಾಮದ ನಾಗವ್ವ ಎಂಬ ಹೆಸರಿನ ಮತ್ತೊಬ್ಬ ಹೆಣ್ಣು ಮಗಳೊಂದಿಗೆ 2ನೇ ಮದುವೆ ಮಾಡಿಕೊಂಡಿದ್ದರು. ನಮ್ಮ ಮುತ್ಯ ಹನುಮಂತ ಕಮಟಗಿ ಮತ್ತು ಆತನ 2ನೇ ಹೆಂಡತಿ ಕಲ್ಲುಬೆಳಗಿ ಗ್ರಾಮದ ನಾಗವಳ ದಾಂಪತ್ಯದಿಂದ 1 ಮಾಳಪ್ಪ, ನಂಬರ್ 2 ಪರಮಾನಂದ, ನಂಬರ್ 3 ಮುರಪ್ಪ ಮತ್ತು ನಂಬರ್ 4 ಕರೆಪ್ಪ ಅನ್ನುವ ಹೆಸರುಗಳ 4 ಜನ ಗಂಡು ಮಕ್ಕಳು ಹುಟ್ಟಿದ್ದಾರೆ. ನಮ್ಮ ತಾಯಿಯ ತಾಯಿ ನಾಗವ್ವ ಮೃತಳಾದ ನಂತರ ಆಕೆಯ ಹೆಸರಿನಲ್ಲಿದ್ದ ಕಂಬಾಗಿ ಗ್ರಾಮದಲ್ಲಿಯ 9 ಎಕರೆ ಜಮೀನು ನಮ್ಮ ತಾಯಿ ರಂಗವ್ವ ಮತ್ತು ನಮ್ಮ ತಾಯಿಯ ಸಹೋದರಿ ಭೀಮವ್ವ ಇವರಿಗೆ ಬಂತು. ನಮ್ಮ ಮುತ್ತನ 2ನೇ ಹೆಂಡತಿಯ ಮಕ್ಕಳಾದ ಮಾಳಪ್ಪ, ಪರಮಾನಂದ, ಮುರಪ್ಪ ಮತ್ತು ಕರೆಪ್ಪ ಹಾಗೂ ನಮ್ಮ ಮುತ್ಯ ಹನುಮಂತ್ ಇವರು ನಮ್ಮ ತಾಯಿ ಮತ್ತು ಆಕೆಯ ಸಹೋದರಿ ಭೀಮವ್ವಳಿಗೆ ಅವಳ ತಾಯಿಯ ಮೃತದ ನಂತರ ಬಂದ 9 ಎಕರೆ ಜಮೀನಲ್ಲೂ ತಮಗೂ ಪಾಲು ಬರುತ್ತದೆ ಎಂದು ಹೇಳಿ ಜಗಳ ಮಾಡುತ್ತಾ ಬಂದು ಕೋರ್ಟಿನಲ್ಲಿ ಈ ಬಗ್ಗೆ ದಾವೆ ಮಾಡಿದರು. ಆ ಜಮೀನಿನ ಬಗ್ಗೆ ಅವರು ದಾಖಲು ಮಾಡಿದ ದಾವೆಗಳಲ್ಲಿ ನಮ್ಮ ತಾಯಿ ರಂಗವ್ವ ಮತ್ತು ಆಕೆಯ ಸಹೋದರಿ ಭೀಮವ್ವಳ ಪರವಾಗಿ ತೀರ್ಪುಗಳು ಆದವು. ಈ ಕಾರಣಕ್ಕೆ ಸದರಿ ನಮ್ಮ ಮುತ್ಯನ 4 ಜನ ಮಕ್ಕಳು ನಮ್ಮ ದ್ವೇಷ ಸಾಧಿಸುತ್ತಾ ನಮಗೆ ಹೊಡೆಯುತ್ತೇವೆ ಎಂದು ಹೇಳುತ್ತಾ ಬಂದರು. ನಮಗೆ ಜೀಗ ತೆಗೆಯುತ್ತೇವೆಂದು ಹೆದರಿಸುತ್ತಿದ್ದರು. ನನ್ನ ಅಕ್ಕನ ಹೆಸರು ನಮ್ಮ ಮನೆಯಲ್ಲಿ ದ್ಯಾಮವ್ವ ಎಂದು ಮತ್ತು ಆಕೆಯ ಮದುವೆ ಆದ ನಂತರ ಆಕೆಯ ಗಂಡನ ಮನೆಯಲ್ಲಿ ಆಕೆಯ ಹೆಸರನ್ನು ಲಕ್ಷ್ಮೀಬಾಯಿ ಎಂದು ಇದೆ. ನಮ್ಮ ಅಕ್ಕ ದ್ಯಾಮವ್ವಳನ್ನು ಬಾಗಲಕೋಟೆ ಜಿಲ್ಲೆಯ ಬಾದಾಮಿ ತಾಲೂಕಿನ ಹನುಮಗೇರಿ ಗ್ರಾಮದ ಬಸಪ್ಪ ತಂದೆ ಅಮೋಘಪ್ಪ ಕಮಟಗಿ ಇವರಿಗೆ ಮದುವೆ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೇವೆ. ನಮ್ಮ ಅಕ್ಕನ ಮಾವ ಅಮೋಘಪ್ಪ ಕುಮಟಗಿ ಇವರು ಹನುಮಗೇರಿ ಗ್ರಾಮದಲ್ಲಿ 9 ಎಕರೆ ಜಮೀನನ್ನು ತೆಗೆದುಕೊಂಡು ನಮ್ಮ ಅಕ್ಕ ದ್ಯಾವಣ್ಣನ ಹೆಸರಿನಲ್ಲಿ ದಾಖಲೆ ಮಾಡಿಸಿದರು. ನಮ್ಮ ಅಕ್ಕನ ಮಾವ ಅಮೋಘಪ್ಪ ಕುಮಟಗಿ ಇವರಿಗೆ 4 ಜನ ಹೆಣ್ಣು ಮಕ್ಕಳು. ಆ ಪೈಕಿ ಒಬ್ಬಳ ಹೆಸರು ಸಾವಯವಳ ಗಂಡನ ಹೆಸರು ಕೃಷ್ಣಪ್ಪ ಚಂದ್ರಪ್ಪ ಹಂದರ್ಗಿ A4. ಕೃಷ್ಣಪ್ಪ ಚಂದ್ರಪ್ಪ ಹಂದರ್ಗಿ ಈ ಪ್ರಕರಣದಲ್ಲಿನ 4ನೇ ಆರೋಪಿ ಇದ್ದಾನೆ. ನಮ್ಮ ತಂದೆ ತಾಯಿಯ ನಮ್ಮ ಅಕ್ಕನ ಮಾವ ಅಮೋಘಪ್ಪ ಕುಮಟಗಿ ಇವರು ನಮ್ಮ ಅಕ್ಕನ ಹೆಸರಲ್ಲಿ 9 ಎಕರೆ ಜಮೀನು ಖರೀದಿ ಮಾಡಲು ಕಾರಣ ಆಗಿದ್ದಾರೆಂದು 4ನೇ ಆರೋಪಿ ಮತ್ತು ನಮ್ಮ ತಂದೆ ತಾಯಿಯ ಮೇಲೆ ಸಿಟ್ಟಾಗಿದ್ದನು. ಈ ಘಟನೆಗೂ 4-5 ವರ್ಷ ಮೊದಲಿನಿಂದಲೂ 4ನೇ ಆರೋಪಿ ಹನುಮಗೇರಿ ಗ್ರಾಮ ಬಿಟ್ಟು ಬಂದು ನಮ್ಮ ಮಾವಂದಿರಾದ A123 ಆತರೊಂದಿಗೆ ಸುತಗುಂಡಿ ಗ್ರಾಮದಲ್ಲಿ ಇರುತ್ತಿದ್ದನು. 4ನೇ ಆರೋಪಿ 1ರಿಂದ 3ನೇ ಆರೋಪಿ ತರೊಂದಿಗೆ ಸೇರಿಕೊಂಡು ನಮ್ಮ ತಂದೆ ತಾಯಿಗಳಿಗೆ ಕೊಂದು ಜೀವ ತೆಗೆಯುತ್ತೆ ಅಂತ ಹೆದರಿಸ್ತಾ ಬಂದಿದ್ದರು. ದಿನಾಂಕ 5/1/2014 ನಮ್ಮ ತಂದೆ ವಿಜಯಪುರದಲ್ಲಿದ್ದ ನನಗೆ ಫೋನ್ ಮಾಡಿ ನಾನು ನಮ್ಮ ತಾಯಿ ರಂಗವ್ವ, ನಮ್ಮ ಅಣ್ಣನ ಮಗಳು ಪೂಜಾ ಮತ್ತು ನಮ್ಮ ಊರಿನಲ್ಲಿ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಇದ್ದು ಶಾಲೆ ಕಲಿಯುತ್ತಿದ್ದ ನಮ್ಮ ಅಕ್ಕನ ಮಗ ಕಲ್ಮೇಶ್ನೊಂದಿಗೆ ಕೂಡಿ ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ಹನುಮಗೇರಿ ಗ್ರಾಮಕ್ಕೆ ನನ್ನ ಅಕ್ಕನನ್ನು ಭೇಟಿಯಾಗಿ ಬರುತ್ತೇವೆ ಎಂದು ತಿಳಿಸಿದರು. ದಿನಾಂಕ 7/1/2014 ನನ್ನ ತಂದೆ ಪುನಃ ನನಗೆ ಫೋನ್ ಮುಖಾಂತರ ತಾನು ಹಣಮಗೆರೆ ಗ್ರಾಮದಿಂದ ನಮ್ಮ ತಾಯಿ ರಂಗವ್ವ, ನನ್ನ ಅಣ್ಣನ ಮಗಳು ಪೂಜಾ, ನನ್ನ ಅಕ್ಕನ ಮಗ ಕಲ್ಮೇಶ್ನೊಂದಿಗೆ ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ಗುಣದಾಳ ಗ್ರಾಮಕ್ಕೆ ವಾಪಸ್ ಬರುತ್ತೇವೆ ಎಂದು ತಿಳಿಸಿದರು. ದಿನಾಂಕ 7/1/2014 ಸಾಯಂಕಾಲ 4 ಗಂಟೆ ಸುಮಾರಿಗೆ ನಮ್ಮ ಅಕ್ಕನ ಮಗ ಕಲ್ಮೇಶ್ ನನಗೆ ಫೋನ್ ಮಾಡಿ ತಾನು ಮತ್ತು ನಮ್ಮ ತಂದೆ ಬಸಪ್ಪ, ನಮ್ಮ ತಾಯಿ ರಂಗವ್ವ ಮತ್ತು ಅಣ್ಣನ ಮಗಳು ಪೂಜಾ ಕೂಡಿಕೊಂಡು ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ಗುಣದಾಳಕ್ಕೆ ಬರುವಾಗ ನಂದಿ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಸ್ಕೂಲ್ ಹತ್ತಿರ ಮೋಟಾರ್ ಸೈಕಲ್ನ ಹಿಂಬದಿಗೆ ಕ್ರೂಸರ್ ಜೀಪ್ ಹಾಯಿಸಿ ತನಗೆ ಮತ್ತು ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ಇದ್ದವರಿಗೆ ಬೀಳಿಸಿ ಕ್ರೂಸರ್ ಜೀಪಿನಿಂದ ಇಳಿದು ಬಂದು ನಮ್ಮ ತಂದೆ ಬಸಪ್ಪ ಮತ್ತು ತಾಯಿ ರಂಗವಳಿಗೆ ಜೀಪಿನಿಂದ ಇಳಿದು ಬಂದು ಹೊಡೆದು ಸಾಯಿಸಿದ್ದಾರೆ ಎಂದು ತಿಳಿಸಿದನು. ನಾನು ಅದೇ ದಿನ ಸಾಯಂಕಾಲ 6 ಗಂಟೆಗೆ ಸುಮಾರಿಗೆ ಗುನ್ನಾ ಸ್ಥಳಕ್ಕೆ ಹೋಗಿ ನೋಡಲಾಗಿ ನಮ್ಮ ತಂದೆ ಬಸಪ್ಪ, ನಮ್ಮ ತಾಯಿ ರಂಗವ್ವ ಮೃತರಾಗಿದ್ದರು. ನಮ್ಮ ತಾಯಿ ರಂಗವಳ ಗದ್ದದ ಮೇಲೆ ಹಾಗೂ ಎಡ ಮೆಲಕಿಗೆ ಬಲವಾದ ಗಾಯಗಳು ಆಗಿದ್ದವು. ನಮ್ಮ ತಂದೆ ಎಡ ಮೆಲಕಿನ ಮೇಲೆ ಮತ್ತು ತಲೆಯ ಮೇಲೆ ಗಾಯಗಳು ಆಗಿದ್ದವು. ಆಮೇಲೆ ಅಲ್ಲಿಯೇ ಅಳುತ್ತಾ ಕುಳಿತಿದ್ದಾಗ ನನ್ನ ಅಣ್ಣನ ಮಗಳು ಪೂಜಾ, ಅಕ್ಕನ ಮಗ ಕಲ್ಮೇಶನಿಗೆ ವಿಚಾರಿಸಲಾಗಿ ಗಲಗಲಿಯಿಂದ ಗುಣದಾಳ ಕಡೆಗೆ ಬರುವಾಗ ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ಇದ್ದ ತಮಗೆ ಮತ್ತು ತಮ್ಮ ಅಜ್ಜ ಬಸಪ್ಪ, ಅಜ್ಜಿ ರಂಗವ್ವ ಸವಾರಿ ಮಾಡಿಕೊಂಡು ಹೊರಟಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್ ಹಿಂದುಗಡೆಯಿಂದ ಕ್ರೂಸರ್ ಜೀಪ್ ಓಡಿಸಿಕೊಂಡು ಬಂದು ಹಾಯಿಸಿ ತಾವು ಬಿದ್ದಾಗ ಕ್ರೂಸರ್ ಜೀಪಿನಿಂದ ಇಳಿದು ಬಂದ ಪರಮಾನಂದ, ಮಾಳಪ್ಪ, ಮುರೆಪ್ಪ, ಕರೆಪ್ಪ ಹಾಗೂ ಮತ್ತೊಂದು ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ಬಂದ ಇಬ್ಬರು ಹೊಡೆಯಲು ಬಂದಾಗ ತಾವು ಓಡಿ ಹೋಗಿ ಕಂಟಿಯ ಮರೆಯಲ್ಲಿ ಕುಳಿತುಕೊಂಡೆವು. ಆದರೆ ಮೇಲೆ ಹೇಳಿದವರೆಲ್ಲ ಕೂಡಿ ನಮ್ಮ ತಮ್ಮ ಅಜ್ಜ ಬಸಪ್ಪ, ಅಜ್ಜಿ ರಂಗವಳಿಗೆ ಹೊಡೆದು ಕೊಲೆ ಮಾಡುತ್ತಾರೆಂದು ಹೇಳಿದರು. ಕಬ್ಬಿಣದ ರಾಡು, ಜಾಲಿ ಬಡಿಗೆ, ಬೆಲ್ಟ್ ಸಮೇತ ಇದ್ದ ಸೀಸದ ಗುಂಡು ತೆಗೆದುಕೊಂಡು ಬಸಪ್ಪ ಮತ್ತು ರಂಗವಳಿಗೆ ಹೊಡೆದರು ಎಂದು ಹೇಳಿದನು. ಈಗ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇರುವ 5 ಜನ ಆರೋಪಿತರು ಮೊದಲಿನಿಂದಲೂ ನಮ್ಮ ತಂದೆ ತಾಯಿಯ ಮೇಲೆ ದ್ವೇಷ ಸಾಧಿಸುತ್ತಿದ್ದ ಕಾರಣ ಇವರು ಘಟನೆಯ ವೇಳೆಗೆ ನಮ್ಮ ತಂದೆ ತಾಯಿಗೆ ಹೊಡೆಬಡಿ ಮಾಡಿ ಕೊಲೆ ಮಾಡಿದ್ದರೆಂದು ತಿಳಿಯಿತು. ಕಲ್ಮೇಶ್ ಮತ್ತು ತಂದೆ ತಾಯಿಗಳಿಗೆ ಹೊಡೆದವರ ಪೈಕಿ ಒಬ್ಬನ ಹೆಸರು ಗೊತ್ತಿಲ್ಲ, ಆದರೆ ನೋಡಿದರೆ ಆತನಿಗೆ ಗುರುತಿಸುತ್ತೇನೆಂದು ನನಗೆ ಹೇಳಿದನು. ನಾನು ದಾರಿ ಉದ್ದಕ್ಕೂ ಎಲ್ಲರಿಗೂ ಫೋನ್ ಮಾಡುತ್ತಾ ಇರುವಾಗ ಮಲೇಶಿ ದಳವಾಯಿ PW7 ಗುನ್ನಾ ಸ್ಥಳಕ್ಕೆ ಬಂದರು. ಪೂಜಾ ಮತ್ತು ಕಲ್ಮೇಶನಿಗೆ ಪ್ರಥಮ ಚಿಕಿತ್ಸೆ ಗಲಗಲಿಯಲ್ಲಿ ಆಸ್ಪತ್ರೆಗೆ ತೆಗೆದುಕೊಂಡು ಹೋದೆವು. ಅಲ್ಲಿ ಪ್ರಥಮ ಚಿಕಿತ್ಸೆ ಕೊಟ್ಟ ನಂತರ ಕಲ್ಮೇಶನಿಗೆ ವಿಜಯಪುರದಲ್ಲಿನ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಬಂದೆವು. PW7 ಮಲ್ಲೇಶಿ ಈತನು ಕಲ್ಮೇಶನ ಬಳಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಉಳಿದುಕೊಂಡನು. ನಾನು ರಾತ್ರಿ 10:30 ಗಂಟೆಯ ಸುಮಾರಿಗೆ ಬಬಲೇಶ್ವರ್ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಹೋದೆನು. ನಾನು ಬಬಲೇಶ್ವರ್ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ನಮ್ಮ ತಂದೆ ತಾಯಿಗೆ ಹೊಡೆಬಡಿ ಮಾಡಿ ಕೊಲೆ ಮಾಡಿದವರ ಮೇಲೆ ಬರವಣಿಗೆಯಲ್ಲಿ ಫಿರ್ಯಾದಿ ಕೊಟ್ಟೆ. ಈಗ ತೋರಿಸಿದ ಫಿರ್ಯಾದಿ ನಾನು ಬಬಲೇಶ್ವರ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದು ಇದೆ. ಈ ಫಿರ್ಯಾದಿಯನ್ನು ನಿಶಾನೆ P1 ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. ಈಗ ತೋರಿಸಿದ ಸಹಿ ನನ್ನದು. ಸಹಿಯನ್ನು ನಿಶಾನೆ 1A ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. ನಿಶಾನೆ 1ರಲ್ಲಿ ಬರೆದಿರುವ ವಿಷಯವನ್ನು ನನ್ನ ಹಸ್ತಾಕ್ಷರದಲ್ಲಿ ಇವೆ. ನಾನು ಗುನ್ನಾ ಸ್ಥಳಕ್ಕೆ ಹೋದಾಗ ಮಹೀಂದ್ರ ಮ್ಯಾಕ್ಸ್ ವಾಹನ ನಂಬರ್ ಸೋ ಎದ್ದು ನಿಂತಿದ್ದು, ನಮ್ಮ ತಂದೆಯವರು ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್ ನಂಬರ್ ಸೋ ಇದ್ದು ಸಹ ಜಖಂಗೊಂಡ ಸ್ಥಳದಲ್ಲಿ ಬಿದ್ದಿತ್ತು. ನಾನು ಪೊಲೀಸರಿಗೆ ಪುನಃ ಹೇಳಿಕೆ ಕೊಟ್ಟಿದ್ದೇನೆ. ಪುನಃ ಹೇಳಿಕೆಯಲ್ಲಿ ಘಟನೆ ವೇಳೆಗೆ ನಮ್ಮ ತಂದೆ ತಾಯಿಯರನ್ನು ಕೊಲೆ ಮಾಡಿದ ಹೆಸರು ಗೊತ್ತಿಲ್ಲದ ಆರೋಪಿಯ ಹೆಸರು ರೇವಣ್ ಸಿದ್ದ A5, ತಂದೆ ಶೇಖಪ್ಪ ಬ್ಯಾಡ್ಗಿ ಇವರು ಇದ್ದಾರೆ ಎಂದು ಪೊಲೀಸರಿಗೆ ಹೇಳಿದ್ದೇನೆ. ನಾರಾಯಣ ತಂದೆ ಗೋಗಪ್ಪ ಫಕೀರಪ್ಪಗಳು ಇವರು ಸದರಿ ಶ್ರವಣ ಸಿದ್ದಪ್ಪನ ಹೆಸರನ್ನು ನನಗೆ ಹೇಳಿದ್ದಾನೆ. ದಿಸ್ PW5 informed him notes. His eyewitness.
Narayana.
Yes, his eyewitness notes. He informed this PW1 about A5. ಪೊಲೀಸರಿಗೆ ಹೇಳಿದ್ದೇನೆ. ನಾರಾಯಣ್ ಫಕೀರಪ್ಪಗಳ ಈತನು ಘಟನೆ ನಡೆಯುವ ವೇಳೆಗೆ ತಾನೂ ಘಟನೆ ಸ್ಥಳದ ಹತ್ತಿರ ಬರುವಾಗ ಉಳಿದ ಆರೋಪಿತಗಳೊಂದಿಗೆ ಕೂಡಿ ರೇವಣ್ ಸಿದ್ದ ಸಹ ಇದ್ದನು ಮತ್ತು ರೇವಣ್ ಸಿದ್ದ ನಮ್ಮ ತಂದೆ ಬಸಪ್ಪನು 2 ಕಾಲಗಳನ್ನು ಘಟನೆಯ ವೇಳೆಗೆ ಗಟ್ಟಿಯಾಗಿ ಹಿಡಿದುಕೊಂಡಿದ್ದನು ಎಂದು ನನಗೆ ಹೇಳಿದ್ದಾನೆಂದು ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿದ್ದೇನೆ. ಆರೋಪಿಗಳು ನಮ್ಮ ತಂದೆ ನಡೆಸುತ್ತಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್ ಹಾಯಿಸಿದ ಕ್ರೂಸರ್ ನಂಬರ್ ಸೋ ನೆದ್ದರ ಬದಲಾಗಿ ಮಹೀಂದ್ರ ಮ್ಯಾಕ್ಸ್ ನೆದ್ದನ್ನು ಗುನ್ನಾ ಸ್ಥಳದ ಮೇಲೆ ಬಿಟ್ಟು ಹಾಯಿಸಿದ ಸದರಿ ಕ್ರೂಸರ್ ಜೀಪನ್ನು ಸ್ಥಳ ಬೇರೆ ಕಡೆಗೆ ತೆಗೆದುಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಎಂದು ನಾರಾಯಣ PW5 ನನಗೆ ತಿಳಿಸಿದ್ದಾನೆಂದು ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿದ್ದೇನೆ. ದಿನಾಂಕ 8/1/2014 ಪೊಲೀಸರು ನನಗೆ ಘಟನಾ ಸ್ಥಳಕ್ಕೆ ಕರೆದುಕೊಂಡು ಹೋದರು. ಸ್ಥಳದಲ್ಲಿ ನಾ ಪೊಲೀಸರಿಗೆ ಮತ್ತು ಸ್ಥಳಕ್ಕೆ ಬಂದ ಪಂಚರಿಗೆ ಗುನ್ನಾ ಸ್ಥಳ ತೋರಿಸಿದ್ದೇನೆ. ದೆನ್ ಇಟ್ ಇಸ್ ಕಂಟಿನ್ಯೂಡ್ ಮೈ ಲಾರ್ಡ್ಸ್. ನಮ್ಮ ಮುಂದುವರೆದ ಮುಖ್ಯ ವಿಚಾರಣಾ ಸರ್ಕಾರಿ ಅಭಿಯೋಜಕರಿಂದ ನಮ್ಮ ತಂದೆಯವರು ಮೋಟಾರ್ ಸೈಕಲ್ ಸೋ ನೆದ್ದನ್ನು ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿದ್ದರು. ಪಂಚನಾಮೆಯ ವೇಳೆಗೆ ಗುನ್ನಾ ಸ್ಥಳದಲ್ಲಿದ್ದ ಸ್ವಲ್ಪ ರಕ್ತ ಹತ್ತಿದ ಮಣ್ಣು ಮತ್ತು ಸ್ವಲ್ಪ ರಕ್ತ ಹತ್ತಲಾರದ ಮಣ್ಣು ಹಾಗೂ ಮಹೀಂದ್ರ ಮ್ಯಾಕ್ಸ್ ಮತ್ತು ನಮ್ಮ ತಂದೆಯವರು ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಬರುವಾಗ ಘಟನೆ ವೇಳೆಗೆ ಸ್ಥಳದಲ್ಲಿ ಬಿದ್ದಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್ ಪೊಲೀಸರು ಜಪ್ತಿ ಮಾಡಿಕೊಂಡರು. ನಮ್ಮ ಮುತ್ಯ ಮತ್ತು ಮುತ್ತಿನ 2ನೇ ಹೆಂಡತಿಯ ಮಕ್ಕಳು ನನ್ನ ತಾಯಿ ರಂಗವ್ವ, ಆಕೆಯ ಸಹೋದರಿ ಭೀಮೋಳ ವಿರುದ್ಧ ಅವರ ತಾಯಿ ಮೃತ ನಾಗವಳ ಆಸ್ತಿ ಅವರ ಪಾಲಿಗೆ ಬಂದಿದ್ದರ ವಿರುದ್ಧ ದಾಖಲಿಸಿದ್ದ ಕೇಸುಗಳಲ್ಲಿನ ದಾಖಲೆಗಳನ್ನು ನಾ ಪೊಲೀಸರಿಗೆ ಕೊಟ್ಟಿದ್ದೇನೆ. ಈಗ ತೋರಿಸಿದ ಪ್ರಿನ್ಸಿಪಲ್ ಸಿವಿಲ್ ಜಡ್ಜ್ ನ್ಯಾಯಾಲಯದ ವಿಜಯಪುರದಲ್ಲಿದ್ದ OS ನಂಬರ್ 440 ಆಫ್ 98 ನೇತೃತ್ವದ ತೀರ್ಪು ತೀರ್ಪಿನ ದೃಢೀಕರಣ ನಕಲನ್ನು ನಾನು ಪೊಲೀಸರಿಗೆ ಕೊಟ್ಟಿದ್ದೇನೆ. ಇವುಗಳನ್ನು ಕ್ರಮವಾಗಿ ನಿಶಾನೆ P2, 3 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಈಗ ತೋರಿಸಿದ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕರ್ನಾಟಕ ಬೆಂಗಳೂರಿನಲ್ಲಿನ RSA ನಂಬರ್ 2439 ಆಫ್ 2005 ನಲ್ಲಿನ ತೀರ್ಪನ್ನು ನೋಟ್ರಾಗ್ನ ಕಾಪಿ ನಾನೇ ಪೊಲೀಸರಿಗೆ ಕೊಟ್ಟಿದ್ದೇನೆ. ಇದನ್ನು ನಿಶಾನೆ P4 ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. ಈಗ ತೋರಿಸಿದ ದಿನಾಂಕ 8/8/2013 ಬಬಲೇಶ್ವರ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡುವ ಕುರಿತು ಕೊಟ್ಟ ಕಂಪ್ಲೇಂಟಿನ ಜೆರಾಕ್ಸ್ ಕಾಪಿ ನಾನು ತಂದೆಯವರು ಅದರಲ್ಲಿ ಹೇಳಿದ ಆರೋಪಿಯರ ವಿರುದ್ಧ ಕೊಟ್ಟಿದ್ದಿರುತ್ತದೆ. ಈ ಜೆರಾಕ್ಸ್ ಕಾಪಿ ನಾನು ಪೊಲೀಸರಿಗೆ ಕೊಟ್ಟಿದ್ದೇನೆ.
Important portion ಎಲ್ಲಾದ್ರೂ ಇದ್ರೆ ಕ್ರಾಸ್ ಓದಿ, ಇಡೀ ಕಂಪ್ಲೀಟ್ ಕ್ರಾಸ್ ಬೇಡ.
Yes, that's what I marked a few important
Yes.
portions.
Relevant portions.
Yes, yes. Page 164, my lords. Let's start with the top,
Yes.
first line, my lords.
Hmm.
ಇಬ್ಬರು ಬಂದರು. That is ಬಂದು ಬಡಿಯಿತು ಮತ್ತು ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ಇಬ್ಬರು ಬಂದರು. ಅವರು ತನಗೆ ಮತ್ತು ಪೂಜಾಳಿಗೆ ಹೊಡೆಯಲು ಬಂದಾಗ ತಾವಿಬ್ಬರು ಕಂಟಿಯ ಮರೆಯಲ್ಲಿ ಹೋಗಿ ಕುಳಿತುಕೊಂಡೆವು ಎಂದು ಕಲ್ಮೇಶ್ ನನಗೆ ಹೇಳಿದನು ಎಂಬ ವಿಷಯವನ್ನು ನಿಶಾನೆ P1 ಫಿರ್ಯಾದಿಯಲ್ಲಿ ಬರೆದಿಲ್ಲ ಎಂದರೆ ನಿಜವಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್ ಮಲಟ್. ಕಲ್ಮೇಶ್ ಈತನು ಕ್ರೂಸರ್ ಜೀಪ್ ಮತ್ತು ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ಬಂದವರು ತನ್ನ ಅಜ್ಜಿಗೆ ಜಾಲಿ ಕಟ್ಟಿಗೆ ಮತ್ತು ಬೆಲ್ಟ್ ಇದ್ದ ಸೀಸದ ಗುಂಡೆಯನ್ನು ಹೊಡೆದರು ಎಂದು ನನಗೆ ಹೇಳಿದನೆಂಬ ವಿಷಯ ನಿಶಾನೆ P1 ರಲ್ಲಿ ಬರೆದಿಲ್ಲ ಅಂದರೆ ನಿಜ. He did not mention it. And another aspect is, my lords, the sketch map is, my lords, exhibit the sketch of the, my lords, scene where, my lords, it has been drawn. There is absolutely no thing, as they have stated, they hide it behind the brownie bush. Absolutely no bush has been shown in a sketch. As per the sketch, my lords.
So Narayana did not inform to
PW1.
one.
Yes, lords. He was very much available. He seen entire the incident, my lords. Because he followed them. In fact, this accused have, my lords, crossed him. And my lords, he was very much available.
While shifting hospital, while shifting Kalmesh to hospital, Narayan was present. Huh?
Yes, he was there, my lords.
That is
But
say of PW1.
yes, he only informed about involvement of accused number 5, Revan Siddha. However, by registration of complaint, my lords, the complaint says that he doesn't know the name of A5. That is very much contrary to the fact.
Right.
Then, my lords, page
This Narayana examined as PW?
5 is eyewitness to the incident. Lordship may kindly have a glance at the sketch, page 129, notes. 136 also.
129.
29, page 129 of paper book. And also of 136. And the person who prepared sketch also, he says that he did not notice any bush over there. The engineer who prepared the spot sketch, my lord, that is a exhibit P44. He's a PW 13. In his evidence, my lords, he clearly cross-examination, he admits that since there was no tree or bushes at the place of incident, there is a clear admission, my lords. That he falsified the very case of prosecution, saying that the Kalmesh injured eyewitness hided behind the bush and we watched the entire incident. That extent, my lords, It's fatal to the case of prosecution. And page 167, that is a cross examination further, some extent, my lords. From the top, my lords, 13th line, 166, Gunna Jagadinda. 13th line from the top, my lords. 3, 6, 9. Yes, 13th.
ಜಾಗದಿಂದ?
Yes, my lords. ಗುನ್ನಾ ಜಾಗದಿಂದ ಪಶ್ಚಿಮದ ಕಡೆಗೆ ಹೋಗುವ ಉತ್ತರ ಬದಿಗೆ ಸುಮಾರು 200 ಫೂಟ್ ಅಂತರದಲ್ಲಿ ಒಂದು ರೈತ ಭವನ ಇದೆ ಅಂದರೆ ನಿಜ. 2014ನೇ ಸಾಲಿನಲ್ಲಿ ಈ ರೈತ ಭವನ ಕಟ್ಟುವ ಕೆಲಸ ನಡೆದಿತ್ತು ಅಂದರೆ ನಿಜ. ಆ ವೇಳೆ ಅಲ್ಲಿ 100ರಿಂದ 150 ಕೆಲಸಗಾರರು ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದಾರೆ ಅಂದರೆ 10-20 ಜನ ಮಾತ್ರ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು. It's about filled with many people. School was there. The people, some construction work also going on, my lords. People were there, my lords. And sugar factory also there, my lords. And lordship may come back to page 160, my lord.
Hmm. 160?
Yes, in the chief itself, my lords. One thing alert, yes. Second line, my lords. ಅಕ್ಕನ ಮಗ ಕಲ್ಮೇಶನಿಗೆ ವಿಚಾರಿಸಲಾಗಿ ಗಲಗಲಿಯಿಂದ ಗುಣದಾಳ ಕಡೆಗೆ ಬರುವಾಗ ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ಇದ್ದ ತಮಗೆ ಮತ್ತು ತಮ್ಮ ಅಜ್ಜ ಬಸಪ್ಪ, ಅಜ್ಜಿ ರಂಗವ್ವ ಸವಾರಿ ಮಾಡಿಕೊಂಡು ಹೊರಟಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್ ಹಿಂದಗಡೆಯಿಂದ ಕ್ರೂಸರ್ ಜೀಪ್ ಓಡಿಸಿಕೊಂಡು ಬಂದು ಹಾಯಿಸಿ ತಾವು ಬಿದ್ದಾಗ ಕ್ರೂಸರ್ ಜೀಪಿನಿಂದ ಇಳಿದು ಬಂದ ಪರಮಾನಂದ, ಮಾಳಪ್ಪ, ಮುರೆಪ್ಪ and ಕರೆಪ್ಪ. Actually, Kareppa is not, my lord, the A4. I just wanted to make a point, my lords, to say that due to the family rivalry, my lords, 1 to 4 are the, my lords, belongs to the same family. They wanted to say that, my lords, even Kareppa also there. Roughly, they, my lords, adduce the evidence. It is A4 is a Krishnappa. Otherwise, it has been practiced at saying that all 4 belongs to one family. They wanted to implicate falsely.
What is the name of A5?
A5 is Revan Siddha. A4 is a Krishnappa, not Kareppa. ಯಾಕೆ ಹೇಳ್ತಾರಂದ್ರೆ ಅವ್ರಿಗೆ 4 ಜನ ಮಕ್ಕಳು ನಮ್ಮ ಆಸ್ತಿಗೋಸ್ಕರ ಫೈಟ್ ಮಾಡ್ತಾ ಇದ್ರು ಅಂತ. That extent, that flow she has stated.
So in the charge sheet, A4 is
no, this Kareppa is not there. A4 is some other guy, Krishnappa. Yes.
Krishnappa.
Yes. And next, my lords, evidence of PW 3, A4, my lords. He's punched the Caesar Panchnama, and he stood all the way for all recoveries, my lords. Page 188, my lords.
Page?
Srishail, Kadabur, page 188.
PW4.
Yes, PW4.
PW4 is the punch witness, alva?
Yes, yes.
Before PW4,
yes.
Let us see the evidence of eyewitness.
PW5.
PW5.
Eyewitness.
Kalmesh.
Kalmesh PW6. Injured eyewitness.
Let us see the evidence of Kalmesh.
Yes.
PW6.
6, my lords. Is Kalmesh page 214.
Injured eyewitness.
Yes, my lords. He was 8 at the time of incident. While adducing evidence, he was 11-year-old, my lords. Married, my lords?
Yes, yes.
ನಮ್ಮ ತಂದೆ ತಾಯಿಗಳು ಹನುಮಗೇರಿ ಗ್ರಾಮದಲ್ಲಿ ಇದ್ದಾರೆ. ಈಗ ನಾನು ಗುಣದಾಳ ಗ್ರಾಮದಲ್ಲಿ ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ, ಆಯಿ ರಂಗವಳ ಮನೆಯಲ್ಲಿ ಇದ್ದೇನೆ. ಈ ಘಟನೆಗೂ ಮೊದಲು ನಾನು ಗುಣದಾಳಲ್ಲಿಯ ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ, ಆಯಿ ರಂಗವಳ ಮನೆಯಲ್ಲಿ ಇರುತ್ತಿದ್ದೇನು. ನಾನು ಸ್ವಾಮಿ ವಿವೇಕಾನಂದ ಶಾಲೆ ಗುಣದಾಳಲ್ಲಿ ಶಾಲೆ ಕಲಿಯುತ್ತಿದ್ದೇನು. ಹನುಮಗೇರಿಯಲ್ಲಿರುವ ನನ್ನ ತಂದೆ ತಾಯಿಗಳನ್ನು ನೋಡಲು ನಾನು ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ, ಆಯಿ ರಂಗವ ಹಾಗೂ ಪೂಜಾಳ ಸಮೇತ ಹನುಮಗೇರಿಗೆ ಹೋಗುತ್ತಿದ್ದೇನು. ದಿನಾಂಕ 5/1/2014 ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ, ಆಯಿ ರಂಗವ, ನಾನು ಮತ್ತು ಪೂಜಾ ಕೂಡಿ ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ನನ್ನ ತಂದೆ ತಾಯಿಯನ್ನು ನೋಡಿಕೊಂಡು ಬರಲು ಹನುಮಗಿರಿಗೆ ಹೋಗಿದ್ದೆವು. ನಮ್ಮ ಅಜ್ಜ ಬಸಪ್ಪ ಮೋಟಾರ್ ಸೈಕಲ್ ಚಾಲನೆ ಮಾಡುತ್ತಿದ್ದರು. ದಿನಾಂಕ 7/1/2014 ಹನುಮಗಿರಿಯಿಂದ ಪುನಃ ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲಿಂದ ನಾನು ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ, ನಮ್ಮ ತಾಯಿ ಆಯಿ ರಂಗವ ಹಾಗೂ ಪೂಜಾ ಕೂಡಿ ವಾಪಸ್ ಗುಣದಾಳಕ್ಕೆ ಹೊರಟಿದ್ದೆವು. ಆ ವೇಳೆಗೆ ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ ಮೋಟಾರ್ ಸೈಕಲ್ ಚಾಲನೆ ಮಾಡುತ್ತಿದ್ದರು. ಆ ವೇಳೆಗೆ ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ ಚಾಲನೆ ಮಾಡುತ್ತಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್ TVS ಸ್ಟಾರ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಎದ್ದು ಇತ್ತು. ಗಲಗಲಿಯಲ್ಲಿ ಮೋಟಾರ್ ಸೈಕಲ್ ನಿಲ್ಲಿಸಿ ಸಂತೆ ಮಾಡಿದೆವು. ಈ ರೀತಿ ಗಲಗಲಿಯಲ್ಲಿ ಸಂತೆ ಮಾಡುವಾಗ PW5 ನಾರಾಯಣ್ ಇಸ್ ಐ ವಿಟ್ನೆಸ್ ನಮಗೆ ಭೇಟಿಯಾಗಿ ನಮ್ಮ ಅಜ್ಜ ಬಸಪ್ಪನೊಂದಿಗೆ ಮಾತನಾಡಿದರು. ನಂತರ ಪುನಃ ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ ಚಾಲನೆ ಮಾಡುತ್ತಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ನಾನು, ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ, ನಮ್ಮ ಆಯಿ ರಂಗವ ಹಾಗೂ ಪೂಜಾ ಕೂಡಿ ಗಲಗಲಿಯಿಂದ ಗುಣದಾಳ ಕಡೆಗೆ ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ ಹೊರಟಿದ್ದೆವು. ಆ ದಿನ ಮಧ್ಯಾಹ್ನ 1:30 ಗಂಟೆಯ ವೇಳೆಗೆ ಹನುಮಗಿರಿಯಿಂದ ಹೊರಟಿದ್ದೆವು. PW10 ನಾರಾಯಣ್ ಭೇಟಿಯಾದಾಗ ಮಧ್ಯಾಹ್ನ 3ರಿಂದ 3:30 ಗಂಟೆ ಸಮಯ ಆಗಿತ್ತು. ಇಂಟರ್ನ್ಯಾಷನಲ್ ಸ್ಕೂಲ್ ಹತ್ತಿರ ಒಂದು ಕ್ರೂಸರ್ ಜೀಪ್ ನಾವು ಪ್ರಯಾಣಿಸಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್ಗೆ ಹಿಂಬದಿಗೆ ಡಿಕ್ಕಿ ಹೊಡೆಯಿತು. ಈ ರೀತಿ ಮೋಟಾರ್ ಸೈಕಲ್ ಜೀಪ್ ಡಿಕ್ಕಿ ಮಾಡಿದಾಗ ಮೋಟಾರ್ ಸೈಕಲ್ ಸಮೇತ ನಾನು, ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ, ಆಯಿ ರಂಗವ ಹಾಗೂ ಪೂಜಾ ಕೆಳಗಡೆ ಬಿದ್ದೆವು. ಆಗ ಮೋಟಾರ್ ಸೈಕಲ್ಗೆ ಡಿಕ್ಕಿ ಪಡಿಸಿದ ಕ್ರೂಸರ್ ಜೀಪಿನಿಂದ 1ನೇ ಆರೋಪಿ ಮಾಳಪ್ಪ, 2ನೇ ಆರೋಪಿ ಪರಮಾನಂದ, 4ನೇ ಆರೋಪಿ ಕೃಷ್ಣಪ್ಪ ಇಳಿದು ಬಂದರು. 1ನೇ ಆರೋಪಿ ಮಾಳಪ್ಪ ಜಾಲಿಗೆ ಬಡಿಗೆ, 4ನೇ ಆರೋಪಿ ಕೃಷ್ಣಪ್ಪ ಕಬ್ಬಿಣದ ರಾಡು ಹಿಡಿದುಕೊಂಡಿದ್ದರು. ಜೀಪಿನ ಹಿಂದಿನಿಂದ ಮೋಟಾರ್ ಸೈಕಲ್ ಮೇಲೆ A3 ಆರೋಪಿ ಮುರಪ್ಪ ಮತ್ತು A5 ಆರೋಪಿ ರೇವಣಸಿದ್ದ ಬಂದರು. 3ನೇ ಆರೋಪಿ ಮುರಪ್ಪ ಸದರಿ ಮೋಟಾರ್ ಸೈಕಲ್ ಚಾಲನೆ ಮಾಡುತ್ತಿದ್ದನು. ಮೋಟಾರ್ ಸೈಕಲ್ ಅನ್ನು ನಿಲ್ಲಿಸಿ ಕ್ರೂಸರ್ ಜೀಪಿನಲ್ಲಿದ್ದ ಸೀಸದ ಗುಂಡನ್ನು ತೆಗೆದುಕೊಂಡು ಬಂದನು. 1ನೇ ಆರೋಪಿ ಜಾಲಿ ಬಡಿಗೆಯಿಂದ, 3ನೇ ಆರೋಪಿ ಸೀಸದ ಗುಂಡಿನಿಂದ, 4ನೇ ಆರೋಪಿ ಕೃಷ್ಣಪ್ಪ ಕಬ್ಬಿಣದ ರಾಡಿಯಿಂದ ನಮ್ಮ ಅಜ್ಜ ಬಸಪ್ಪ, ನನ್ನ ಆಯಿ ರಂಗವಳಿಗೆ ಹೊಡೆಯ ಹತ್ತಿದರು. ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ ಮತ್ತು ಆಯಿ ರಂಗವ ಚೀರಾಡುತ್ತಿದ್ದರು. ನಾನು ಮತ್ತು ಪೂಜಾ ಓಡಿ ಹೋಗಿ ಹತ್ತಿರ ಮರೆಯದಲ್ಲಿದ್ದ ಕಂಟಿಯ ಮರೆಗೆ ಕುಳಿತೆವು. ನನ್ನ ಆಯಿ ರಂಗವ ಸ್ಥಳದಲ್ಲೇ ಮೃತಳಾದಳು. 5ನೇ ಆರೋಪಿ ರೇವಣಸಿದ್ದ ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪನ ಕಾಲುಗಳನ್ನು ಗಟ್ಟಿಯಾಗಿ ಹಿಡಿದುಕೊಂಡಾಗ 2ನೇ ಆರೋಪಿ ಪರಮಾನಂದ ಜೀಪನ್ನು ತನ್ನ ಅಜ್ಜ ಬಸಪ್ಪನ ತಲೆಯ ಮೇಲೆ ಓಡಿಸಿದನು. ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ ಆಗ ಸ್ಥಳದಲ್ಲೇ ಮೃತನಾದನು. ಆರೋಪಿಗಳು ಗಾಡಿಯನ್ನು ತೆಗೆದುಕೊಂಡು ಫ್ಯಾಕ್ಟರಿ ಕಡೆಗೆ ಹೋದರು. ಆಗ ಸಮಯ ಸುಮಾರು 3:30ರಿಂದ 4 ಗಂಟೆ ಆಗಿತ್ತು. ಆರೋಪಿಗಳು ಹೋದ ನಂತರ CW10 ನಾರಾಯಣ ಘಟಕ್ಕೆ ಬಂದನು. ನಾನು ಅಳುತ್ತಾ ಇದ್ದಾಗ 3ನೇ ಆರೋಪಿ ಮುರಪ್ಪ ಪಿಕಪ್ ವಾಹನ ತಂದು ನಿಲ್ಲಿಸಿದನು. ನಾನು ನನ್ನ ಮಾವ ತಮ್ಮಣ್ಣನಿಗೆ ಫೋನ್ ಮಾಡಿದೆ. ನಾನು ಫೋನ್ ಮಾಡಿದ ನಂತರ ನನ್ನ ಮಾವ ತಮ್ಮಣ್ಣ PW1 ಸ್ಥಳಕ್ಕೆ ಬಂದರು. PW1 ತಮ್ಮಣ್ಣ ಸ್ವಲ್ಪ ಹೊತ್ತಿನಲ್ಲಿ CW12 ಮಲ್ಲೇಶಿ ಮತ್ತು ಶ್ರೀಶೈಲ್ ಸಹ ಬಂದರು. ತಮ್ಮಣ್ಣ, ನಾನು, ಶ್ರೀಶೈಲ್ ಕೂಡಿ ಗಲಗಲಿಯ ದವಾಖಾನೆಗೆ ಹೋದೆವು. ಈಗ ಪುನಃ ಹೇಳುತ್ತೇನೆ, ನಾನು CW2 ಮಲ್ಲೇಶಿ ಮತ್ತು ಶ್ರೀಶೈಲ್ ಕೂಡಿ ಗಲಗಲಿಯ ದವಾಖಾನೆಗೆ ಹೋದೆವು. ನನಗೆ ಮೂಗು ಮತ್ತು ಬಲಕೆನ್ನೆಗೆ ಹಾಗೂ ಮೆಲಕಿನ ಮೇಲೆ ಗಾಯಗಳು ಆಗಿದ್ದವು. ಗಲಗಲಿಯಲ್ಲೇ ವೈದ್ಯರು ನನಗೆ ಪರೀಕ್ಷಿಸಿದರು. ನಂತರ ನಾನು CW12 ಮಲ್ಲೇಶಿ ಮತ್ತು PW1 ತಮ್ಮಣ್ಣ ಕೂಡಿ ಬಿಜಾಪುರಗೆ ಬಂದೆವು. ವಿಜಯಪುರದ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ವೈದ್ಯರು ನನಗೆ ಚಿಕಿತ್ಸೆ ನೀಡಿದರು. ಪೊಲೀಸರು ನನಗೆ ವಿಚಾರಿಸಿದ್ದಾರೆ. This is also most important because he has been enquired by the police while he was in a hospital, my lords. Police aware of this, my lords. ಈಗ ತೋರಿಸಿದ MO12ರಲ್ಲಿ ಗುರುತಿಸಿದ ಸೀಸಿನ ಗುಂಡಿನಿಂದ 3ನೇ ಆರೋಪಿ ಮುರಪ್ಪ ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ, ಆಯಿ ರಂಗವಳಿಗೆ ಹೊಡೆದಿದ್ದಾರೆ. ಈಗ ತೋರಿಸಿದ MO15ರಲ್ಲಿ ತೋರಿಸಿದ ಕಟ್ಟಿಗೆ ಬಡಿಗೆಯಿಂದ 1ನೇ ಆರೋಪಿ ಮಾಳಪ್ಪ ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ, ಆಯಿ ರಂಗವಳಿಗೆ ಹೊಡೆದಿದ್ದಾರೆ. ಈಗ ತೋರಿಸಿದ MO18ನಲ್ಲಿ ಗುರುತಿಸಿದ ಕಬ್ಬಿಣ ರಾಡಿನಿಂದ 4ನೇ ಆರೋಪಿ ಕೃಷ್ಣಪ್ಪ ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪ ಮತ್ತು ಆಯಿ ರಂಗವಳಿಗೆ ಹೊಡೆದಿದ್ದಾನೆ. In a cross examination, my lords, she says in page next 218, my lords, first para, last 3 lines. ಈಗ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇರುವ 4ನೇ ಆರೋಪಿ ನನ್ನ ಅಜ್ಜ ಬಸಪ್ಪನ ತಂಗಿಯ ಗಂಡ ಇದ್ದಾನೆ. ಈಗ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇರುವ ಆರೋಪಿಗಳು ನಮ್ಮ ಮನೆಯ ಕಾರ್ಯಕ್ರಮಗಳು ಬರುತ್ತಿದ್ದರಿಂದ ಅವರಿಗೆ ನಮ್ಗೆ ಗೊತ್ತಿತ್ತಾನೆ. To say that she could identify.
What is the injury sustained by the deceased?
That is, my lord,
Are there any such crush injury on the head of the deceased?
Yes, it is there.
It is there, huh?
Yes.
ಯಾವುದು PM report ಎಷ್ಟು?
That is page, my lords.
107.
PM is up page 105, my lords. That belongs to Basappa.
ಏನೋ ತಲೆಯ ಮೇಲೆ ಓಡಿಸಿದ್ರಂತ.
ಹೌದು. Page 103 is, my lords.
What is the opinion?
Opinion is, my lords, same. Death was due to hemorrhage of shock as a result of injury sustained over head for both of them, both diseases.
What is the injuries now?
Point one not three.
What is
Page.
the evidence of doctor
Doctor, that is, my lords,
before going to the next, this one?
yes, my lords,
Eyewitness.
please.
Let us see the evidence of doctor. What he says.
Doctor is, my lords, PW 10, my lords. Ramesh Patil, page 250,
Page 250,
250 minutes,
215,
250.
250.
Yes, Ramesh Patil minutes.
Ah.
Two five zero minutes.
Ah.
May I read, my lords?
Yes,
The injuries is mentioned, my lords.
yes, after injuries, yes.
Yes.
All the internal organs,
True, my lords. All the internal organs were intact. The injuries were antemortem in nature. Time since death was 12 to 24 hours prior to the PM examination. As per my opinion, death was due to hemorrhage shock as a result of injury sustained overhead. I have issued PM report now shown to me. Same is marked as Exhibit P22. The signature now shown to me are the signature of same. Next para is so important, my lords.
Yes,
I'll take
yes.
lordship. I marked it. If a person is being assaulted with a lead ball marked at MO12, wooden club marked at MO15, and with an iron rod marked at MO18, now shown to me before the court and also due to fall from the moving motorbike and passing on a wheel of jeep on the head, like external injuries, internal injuries mentioned in Exhibit P22 may cause. Yes, like balancely said, it could be possibly even not if he fell down from the vehicle, as good as these things. This is also most important, maybe not at Malots from the different side. Due to accident, he may cause it. Yes. Adhe mark madi. Yes.
Yes.
This
ಅದು
piece
ನಾ-
of paragraph. Not
ನಾವು ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಅಷ್ಟೊಂದು ವಿ ಪೇ ಅಟೆನ್ಷನ್ ರೆಕಾರ್ಡ್ ಮಾಡೋದ್ರಲ್ಲಿ ಏನೇನೋ ಆಗುತ್ತೆ.
that is also possible.
ಅಲ್ಲ ಒನ್ ಡೇ ಐ ವೆಂಟ್ ಕಲಬುರ್ಗಿ ಕೋರ್ಟಲ್ಲಿ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಜನರಲಿ ಐ ವೆಂಟ್ ಅಂಡ್ ಸ್ಯಾಟ್ ಇನ್ ಪೋಕ್ಸೋ ಕೋರ್ಟ್.
Yes.
ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ನಡೀತಾ ಇದೆ. ಸೊ ದ ಅಕ್ಯೂಸ್ಡ್ ಇಸ್ ಥ್ರೂ VC.
Please.
So the father is there.
Yes.
So they're asking questions and then say, your daughter has become pregnant because of him. That is the question put.
Yes.
Judge ಏನ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ರು? That he has raped ಅಂತ. ಎಲ್ಲಿ ಬಂತು ರೇಪ್? ನನ್ ಮುಂದೆನೇ ಆಯ್ತು, ನಾನ್ ಕುತ್ಕೊಂಡಿದ್ದೀನಿ, ರೆಕಾರ್ಡ್ ಮಾಡ್ತಿದ್ದಾರೆ.
Yes.
So I'm saying ಇವಾಗ ಮೇ ಕಾಸ್ ಅದು ಇದು ಹೇಳ್ತೀವಲ್ಲ.
Please.
So, no doubt you're arguing, but I'm saying sometimes you have to keep a broader picture of.
Yes.
Yes.
Again, it is reiterated in Malas page 255. The middle paramenots, if a person being assaulted with the lead ball marked at MO12, wooden club so and so, and iron rod marked at 18, now shown to me before this court, also due to fall from the moving motorbike, like external injuries and internal may cause it. So it substantiates our defense, saying that it's in case of accident.
Some admission on your part also there in the cross. On my own experience, I am deposing injuries I noticed on the dead bodies, Basappa Rangava, not possible in road traffic accident.
Reason being that the drill objects that were alleged to have been used in the commission of offense. They were not shown to doctor seeking opinion regarding any particular offense would have caused any particular injuries that were found at the time of PM.
Yes, not deposed so in the chief.
Yes.
But
then
ಇಲ್ಲಿ-
why the necessity of asking this?
ಅದೇ
Other explanation.
unfortunate.
Explanation.
Explanation.
ಡಾಕ್ಟ್ರಿಗೆ ಏನಾದ್ರು ಒಂದು ಕ್ರಾಸ್ ಮಾಡ್ಬೇಕಂತ ಕ್ರಾಸ್
ಅದೇ that's what. ಏನೋ ಮಾಡ್ಬೇಕಂತ. ಇಲ್ಲ, ಅಲ್ಲಿ establish.
So take his opinion regarding. Likely it is. But in this case, considering his arithmetic answer, that I am seeing these all memos for the first time in the court. Obviously, it means that they were not sent to him for such exam.
Now, my lords, PW5 evidence, my lords. May I read PW9 also is a doctor, my lords.
PW9. Continue. to
Yes.
one. Continue.
Many a time, while recording of evidence,
Yes.
the true purport of what the witness is saying doesn't come. No doubt we give much importance.
So,
That's why now what they're saying, recording of the evidence, video,
yes.
may also be necessary. ಆಮೇಲೆ ಅಟ್ಲೀಸ್ಟ್ ಅಕ್ಯೂಸ್ ಲಾಯರ್ ಒಬ್ಜೆಕ್ಟ್ ಮಾಡ್ಬೇಕಲ್ವಾ? ಪ್ರಶ್ನೆ ಕೇಳಿದ್ದು ಡಾಟರ್ ಬಿಕಮ್ ಪ್ರೆಗ್ನೆಂಟ್ ಬಿಕಾಸ್ ಆಫ್ ಹಿಮ್. ಅದು ಪ್ರಶ್ನೆ ಕೇಳಿ ಹೌದು ಅಂತ ಹೇಳ್ತಾರೆ. ಇವ್ರು ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದೇನು? ರೇಪ್.
Yes.
ಅಕ್ಯೂಸ್ ಲಾಯರ್ ಏನಿಲ್ಲ.
One submission. 2 matters have been posted on 15th, my lords, for final.
ಅಲ್ಲ ಇದು ಮುಗಿಯೋವರೆಗೂ.
Yes.
With ಮುಗಿಯೋವರೆಗೂ we will
Because
not.
I have been informed by this, my lordship.
No, correct. So till this is finished.
Please.
We will not touch. ಅವ್ರಿಗೆ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ದೇನೆ.
Please.
ಇರ್ಲಿ ಲಿಸ್ಟ್ ಅಲ್ಲಿ. That's why I say outside counsel, please come through video conference. ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ನಾನು ಟಿಕೆಟ್ ಬುಕ್ ಮಾಡಿ ನಾನು ಏರ್ಪೋರ್ಟ್ ಹೋಗ್ಬಿಡ್ತೀವಿ. ನಮ್ಮ ಪ್ರಾಣ ಇಂದ ನಾವೇನ್ ಮಾಡಕ್ಕೆ?
Yes.
ಬರೀ ಹೆಡ್ ಆಫ್ ಚಾರ್ಜ್ ಕಾಪಿ ನೋಡ್ತೀನಿ ಸರ್, ಕೊಡ್ತೀನಿ ಸರ್. ಅವ್ರ ಅದು ಅದಕ್ಕೆ ನಾನು ಹಿಂದೆ ಹೋಗಿರ್ತಾರೆ. ಪೀಪಲ್ ಹೇಳದೇ ಇರೋದನ್ನ ಕ್ರಾಸಲ್ಲಿ ಇವನೇ ಹೇಳ್ತಿದ್ದಾನ. ಅಂದ್ರೆ ಹೊಡೆಯೋದ್ರಿಂದ ಆಗತ್ತೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅದಕ್ಕೆ ಸಾಹೇಬ್ರ ನೆಕ್ಸ್ಟ್ ಹೋದ್ರು ಹೇಗಿತ್ತ ಇದು ಅಂತ. ಅನ್ಫಾರ್ಚುನೇಟ್. ಆಲ್ರೆಡಿ ಕವರ್. ನಮ್ಗೆ ಹೆಂಗ ಅನ್ಸುತ್ತೆ ಅಂದ್ರೆ 5 ಸೆಕೆಂಡ್ ಕೊಡ್ತೀವಿ. ಎಲ್ಲ ಘಟಾನುಘಟಿ ಕಪಿಲ್ ದೇವ್ ಇದ್ದು ಸರ್ ಸರ್ ಎನಿ ಅಬ್ಸಲ್ಯೂಟ್ಲಿ ನೋ ವರೀಸ್.
ನನಗೆ ಸಣ್ಣ ಪಾರು ಬಲಿ ಮಾಡೋದಿಲ್ಲ.
Marshal, Markham Marshal.
ಸರ್ ನೀವು ಅಬ್ಸಲ್ಯೂಟ್ಲಿ ವೆರಿ ಮಾಡ್ಬೇಕು. ಇನ್ ಪ್ರೆಸೆನ್ಸ್ ಆಲ್ಸೋ ಎಲ್ಲ ಕವರ್ ಮಾಡಿ ಏನಿಲ್ಲ ಸರ್, ಎಲ್ಲ ಕವರ್ ಮಾಡಿ ಎಲ್ಲ ಈಗ ಮುಂದೆ ಇದೆ ಒಂದ್ 2 ಬಿಸ್ನೆಸ್ ಹೋದ್ಮ್ಯಾಗ ಹೇಳ್ಬಿಡ್ರಿ. ಆಲ್ರೆಡಿ ಸರ್ 5 ಓದ್ಬೇಕು ಸರ್. ಆ ಮಗನ ಎಲ್ಲ ಇವನಿಗೆ ಹೇಳಿನ ಅಂತಾನ ಅವ ಯಾವಾಗಿದ್ದನು ಮತ್ತೆ FIR ನಾಗ KFI ಬರ್ಬೇಕು. ಇವಾಗ ವೇರಿಯಂಟ್ ಅವೈಲೇಬಲ್ ಬೈ 6 ಸರ್. ಈ ಕೂಡ ಕಾಲ್ಡ್ ಇಟ್ ಟ್ರೂ ಸಾಂಗ್. 2 ಸರ್ಕಮ್ಸ್ಟಾನ್ಸಸ್ ಮಾಡೀನಿ ಸರ್. ಈಗ ಬೆಸ್ಟ್ ಆಯ್ತು ಸರ್, ಒಂದು ಸರ್ಕಮ್ಸ್ಟಾನ್ಸ್ ಚಾರ್ಜ್ ಮಾಡಿ. ಇವಾಗ ವೆರಿ ಮಚ್ ಅವೈಲೇಬಲ್ ಅಟ್ ಸ್ಪಾಟ್.
ಅದೊಂದಾಯ್ತು. ಎಕ್ಸಿಬಿಟ್ RSA 2006
ಅದೊಂದು
7 ವರ್ಷ
7 ವರ್ಷ ಆದ್ಮೇಲೆ ಅದಕ್ಕೆ
is accused number 150.
Not accused, uploading party.
There is a suit filed by the daughters against the father.
ಅದಕ್ಕೆ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಅಂದ್ರೆ when there is stale and bleak motive.
Court officer? Court officer? Court officer?
ಸರ್ ಹೇಳಿ.
ಹಾ ಮೇಡಮ್, ಏನಾಯ್ತು ಸೀರಿಯಲ್ ನಂಬರ್ 38 ಮುಗಿತಾ?
ಸರ್ ಅದು ಕಂಟಿನ್ಯೂ ಬುಧವಾರ ಕಂಟಿನ್ಯೂ ಆಗತ್ತೆ ಸರ್. ಅದು ಮುಗಿಯೋವರೆಗೂ ನಿಮ್ಮದು ತಗೊಳ್ಳಲ್ಲ, ಅದು ಕಂಪ್ಲೀಟ್ ಆಗಿಂತ ತಗೊಂತಾರೆ ಸರ್.
ಅದ ಹೇಳಿದ್ರಿ, ನಂಗೆ ಫೋನ್ ಬಂದಿತ್ತು ನಂಗೆ.
ಹಾ ಸರ್, ನಾನೇ ಮಾಡಿದ್ದೆ.
ಹೌದ್ರಿ, ಓಕೆ ಓಕೆ. PP ಸಾಹೇಬ್ರು ಇದಾರ್ರಿ? PP ಸಾಹೇಬ್ರು HCGP ಹೋದ್ರ?
ಸಾಹೇಬ್ರು ಹೋದ್ರಲ್ಲ, PP
ಅಲ್ಲ
ಸಾಹೇಬ್ರ
HCGP.
ಅವರು ಹೋದ್ರು.
ಸರಿ ಮೇಡಮ್, ಇದಿನ್ನ ಎಷ್ಟೊತ್ತಾಗ್ಬೋದು ಮೇಡಮ್? ಎಷ್ಟು ಮ್ಯಾಟರ್ ಮುಗೀತಿ 38 ಅಲ್ಲಿ?
ನಮಗ್ ಐಡಿಯಾ ಇರಲ್ಲ, ಇನ್ನು ಆರ್ಗ್ಯುಮೆಂಟ್
ಅಲ್ಲ ಕರೆಕ್ಟ್. ಅಂದ್ರೆ 38 ಅಲ್ಲಿ 4 ಮ್ಯಾಟರ್ ಇದೆಯಲ್ಲ, ಎಷ್ಟು 1-2 ಮುಗಿತಾ ಹೆಂಗೆ?
ಮುಗೀತು. ಈಗ ಇವತ್ತಿನ ಸಿಟ್ಟಿಂಗ್ ಮುಗೀತು, ಬುಧವಾರ ಕಂಟಿನ್ಯೂ ಆಗದ್ರಿ.
ಅಲ್ರಿ ಸಿಟ್ಟಿಂಗ್ ಇವತ್ ಮುಗಿತ್ರಿ. ಅಂದ್ರೆ 38.1, 0.2, 0.3, 0.4 ಇದೆಯಲ್ಲ, ಆ 4ರಲ್ಲಿ ಎಷ್ಟು ಮುಗೀತು ಅಂತ ಕೇಳ್ದೆ.
ಇನ್ನು ಒಬ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದಾರೆ.
ಓ, ಅಂದ್ರೆ ಬುಧವಾರ ಮುಗಿಯೋ ಡೌಟ್ ಇತ್ತು. ಸರಿ ಆಯ್ತು, ಕ್ಯಾನ್ಸಲ್ ಮೈ ರಿಸರ್ವೇಶನ್.